18th of
18th of September. My lord, 18th September, their extension of 18th September, my lord, kindly I ask for a simple precedent because it's a trust matter. They have asked for injunction over the trust properties. Already some of the properties have been sold by order of this honorable court passed by Honorable Justice Apurva Sinha Roy. Thereafter, they have filed this application suppressing all the material facts, and they have not paid the leave under clause 12, which is required to be taken for asking for injunction over the trust property and removal of some of the trustees.
So
There are certain, I have been arguing that matter, and thereafter, my lord, I have prayed for time because I was late by, my lord, I want some precedent that the matter may be fixed. Matter may be fixed on 18th September at some time.
Bar will not take the resolution of 330 and be fixed tomorrow.
My lord,
Give the undertaking from the bar that the bar will not take any resolution of 330 or not to attend, not to pass any order. I will fix the matter tomorrow.
my lord, I leave it to your lordship.
You persons are
My lord, I mentioned
and when there is an urgency coming before this court mentioning it is an urgency, please fix the matter tomorrow, day after tomorrow.
My lord, I bow down, my lord. I don't want to get into that as well, my lord, but whatever my lord feels fit, my lord, do there. No problem, my lord.
my lord, the matter was already due to be listed. I mentioned it only because the interim order was expiring, and I mentioned it upon notice to the other side.
Let it be.
Yes, next.
Yeah, please, my lord. Thank you.
My lord, may I please seek leave for issuance of master summons in 3 suits, my lord, 3 applications. If a lordship recalls, my lord, this is that matter of Credit Suisse, the bank in Switzerland, which has now been taken over by another bank. So the name of the plaintiff has to be substituted. We were granted leave to take necessary steps. There is one defect, my lord, which is an impediment, namely that the signatory, the deponent, is Sapna Bhavnani. But the power of attorney, my lord, is in the name of Sapna Vishal Bhavnani. I'm assuming, my lord, Vishal is her husband. My lord, this is, my lord, the only discrepancy, my lord. Really, it's the same person. My lord, it's been signed in another city. If a lordship would kindly allow this. A commercial, my lord. Commercial. Leave for issuance of master summons. Not Sapna Bhavnani, but the power of attorney says Sapna Vishal Bhavnani. 3 applications in 3 similar suits, connected suits, my lord. Pull it out. My lord, may I only pray for Monday? Because, my lord, all applications, my lord, can come up on Monday. All applications. Yes. Monday. No, they were returnable day after tomorrow, which is why, my lord, if all matters can come together, other applications also, everything can come on Monday. I'm so grateful.
May I have my lord's kind leave, my lord, to mention one matter, my lord. Lordship was pleased to, my lord, hear this interlocutory
I am for the
application
respondent, your lordship, in this matter.
and pass an order of security. Mr. Shobhosachi Chaudhary was leading me, and Mr. Sengupta was being led by Mr. Ranjan Bachawat. Now, my lord had passed an interim order on 13th of August, my lord, restraining, my lord, them from defendants 1 to 5 from operating their bank account without leaving apart the sum of rupees 6.93 crores and odd. Now, pursuant to your lordship's order, we have communicated this to the bank. My lord, we got information that apart from 70,000 and odd, there is nothing in the, my lord, bank account of the defendants. And my lord, we wanted some more information from the bank as to whether post institution of the suit and service of the application, whether money was withdrawn from these bank accounts or not. No information is being furnished because there is no order. My lord, we had another prayer of cash security. My lord, since there is no direction for affidavit also given in the order passed by your lordship, I was praying, my lord, kindly, my lord, fixes it any day, my lord, next week, so that, my lord, we can praise for, my lord, further orders which would really be, my lord, effective for the purpose of protecting my client's interest. Any day, my lord, convenient to the bench.
I am for the answering respondent.
My lord's voice is not audible somehow, my lord.
The court has passed an interim order. If it is not suffice, then it is a returnable date is there. You mentioned that on that day, and this court, because I have not passed an order with regard to the affidavit because notice was not issued. Only they have appeared when seeing the
My-
was.
No, it was
Lordship,
they were on.
lordship is Lordship is correct, my lord. The returnable date,
We were on caveat. They have served us, Your Lordship.
and
they
it
have-
was a contested hearing, my lord. Lordship has kept it
If
on
they have, Your
17th
Lordship,
of
any other
September.
prayers, let them take
as
out the
new
application, because the reason is, Your Lordship, my client.
May I just indicate before Mr. Sengupta, my lord, makes any submission? I was only praying for this. Lordship has kept it on 17th September as new motion, no direction for affidavit given. I was only praying, my lord, because of the changed circumstances, Lordship kindly prepones this date, keeps it next week, any day convenient to my lord, and so that, my lord, we can press for further orders if Lordship feels that it is
Further
not
order-
possible.
For further order, no, if you want, the only direction can be given for the affidavit, that can be done. With regard to the further order, I will not pass any further order after hearing, after exchange of the affidavit. What this court has found in the prima facie, the court has passed an order. If you want any further modification, you come.
But only the clarification to the extent that the bank should give us that information whether money was withdrawn or not. Kindly keeps it, my lord, any day, my lord, next week.
That will see you. You come with the document. It is not there. Then the
Yes,
court-
yes, my lord. Lordship keeps it next week, my lord, any day, kindly, my lord.
It's a commercial matter.
Commercial.
Tuesday has to be mentioned.
Grateful, my lord. Grateful.
Lordship, may I be permitted to mention on
Lordship,
commercial?
may I be permitted to mention, Your Lordship? Am I audible to Your Lordship?
Yes, yes.
Lordship, item number 68 has been today kept at 12 noon. Lordship, we have been served with a notice by the learned counsel for the Administrator General. Lordship, it is that matter where the tenders which were submitted, Your Lordship, the bids were to be opened today, Your Lordship, at 12 noon.
Yes.
Lordship,
My
they
lord-
have served a notice, Your Lordship. They might be seeking an adjournment today because apropos to today's scenario, Your Lordship.
Correct.
Lordship may kindly takes it up tomorrow at 12 noon. Lordship, I am ready today at 12 noon, Your Lordship.
Let the matter call. The matter.
Lordship, I'll appear at.
Yes.
Lordship.
May I be permitted to mention a non-commercial suit, Your Lordship, for inclusion in the list only for the purpose, Lordship, the writ of summons could not be served on the defendant number 2, so I'm seeking orders for substituted service. So only for that, to that extent.
Commercial.
Non-commercial, Lordship. Any day convenient to Your Lordship, inclusion in the list.
With my lord's permission, may I
Lordship.
please mention a commercial matter that is CSCOM 748 of 2024. My lords, in this, my lords, the parties have settled, my lords. So we are seeking to withdraw this suit, my lords.
Commercial.
Commercial matter, my lords.
Friday has to be mentioned.
Lord, may I have my Lord's leave? Lord, may I have my Lord's leave, Lord, to mention? Lord, just a typographical error. Your Lordship may kindly turns to page 2, second paragraph. Your Lordship, I appear for defendant number 4 in this matter. I was directed to produce the copy of the deed to show that I am the owner. Your Lordship has recorded at the last showing that flat number 502 is recorded in the name of defendant number 2. Your Lordship may kindly keep. Yes, my lord, should be 4. Your Lordship may kindly keeps it on Friday because there is a contested matter, my lord. I don't want anything.
Friday.
Extremely great.
Non-commercial list orders, item number 1.
It is not from my staff. It is affirmative with regard to the all three. You will get the order today.
Very grateful. Grateful.
Order in India.
Then item number 2.
Disposal.
Item number 2, my lord, I appear for the defendant in this matter, my lord.
Item number
2, my lord.
Yes.
I appear for the defendant, my lord. This is the, my lord, the plaintiff's restoration application of their suit, my lord. So I don't know, my lord, whether, my lord, anybody is appearing for the, my lord, the plaintiff today.
Who is for the plaintiff? Who has filed this petitioner?
My lord, it's the plaintiff's petition. I'm for the defendant.
Delay in filing the instant application we condone order.
My lord, this application was initially moved, my lord, before Justice Patnaik. The issue was that, my lord, there was an objection raised, my lord, on behalf of, my lord, the defendant by me, my lord, saying that, my lord, the order that they have enclosed along with the annexed along with this application, my lord, there's some discrepancy. There were actually, my lord, 2 orders passed on, my lord, 9th of October. The order that, my lord, they have annexed along with the petition is not, my lord, the order passed in this matter, my lord. Hence, my lord, the matter was released by, my lord, Justice Patnaik, saying that, my lord, they should seek a clarification from your lordship as to, my lord, which is the order, my lord, which is passed in this matter, my lord. It probably, my lord, it cannot be taken without, my lord, their presence.
Okay, nobody is there. Not today.
In that event, my lord, can it appear, my lord, on Friday, my lord, if it's so, my lord?
Nobody is there, so I cannot pass any order. Not today.
My lord. Okay.
May it please, my lord, I appear for the plaintiff. Today, my lord, is fixed for filing of the written notes of arguments, my lord. Is
Yeah,
it ready?
Lordship would recall my lord 14.1 and 14.2.
Yes.
My lord, I am also filing it, my lord, both of us.
Census suffering for the plaintiff, census suffering for the defendant. As per the order dated 7th of August 2024, both the parties have filed their written notes of argument. Let the same be kept with the record. CAV.
Extremely grateful, my lord.
Your Lordship, in item number 4, I am for the plaintiff, Your Lordship. The matter has appeared at my
Lord,
inspection.
I appear.
It is leading.
I'm leading Mr. Now, my lord, this is an originating summon suit which we had filed, and the defendant in the suit have also filed their affidavits, and the matter, in fact, was being heard out at length before Honorable Justice Arindam Mukherjee. Now, my lord,
Honorable Justice
one of
Shekhar
the
Saraf before Honorable Justice Ravi Kishan Kapoor and also Honorable Justice Arindam Mukherjee.
now, my lord, one of the plaintiffs has died. The plaintiff has died. Now, my lord, we want to substitute. But, my lord, once we have taken out the application, the department is saying that since the originating summon suit has not been formally been admitted by your lordship, this application will not be allowed to be, my lord, filed. My lord, this is a little, my lord, unusual because, my lord, we have always filed originating summon suits before your lordships, and your lordships have allowed affidavits, and then the matter has been heard out. But, my lord, we don't want to take a chance, and since the department has said this, my lord, kindly, my lord, gives us leave. My lord, kindly admit the originating summon suit, and, my lord, give us leave.
But
to
who is
file
the
another.
other side?
My lord, my other side is, my lord, Mr. Shakoshen was appearing with Mr. Zulfikar Ali, if I am not wrong, or Manali.
Victim.
My lord, this is not an adverse order really, my lord, because, my lord, they are appearing. There's only a question of formally allowing.
May take some point. I don't know.
That's true, my lord. I cannot say that, your lord.
Let come tomorrow, not today. Not
My
today.
lord, my lord, my lord.
Next.
Milord, I'm appearing on behalf of the defendant number 5, Milord.
Which one?
5.
Yes.
Ojha matter.
No, item number not.
Oh, I'm so sorry.
Ojha is 6.
I'm so sorry. I apologize.
Not today.
Okay, item number 6, item number 7.
Yes.
My lord, item 6 and 7, I appear for the defendant number 2 and 4. My lord, on the last occasion, if your lordship sees last date's order dated 8th of August 2024, my lord, till date, no copy of the amended plaint has been served upon us in spite of repeated orders by your lordship. My lord, on 3 occasions, your lordship had passed orders and numerous other occasions your lordship observed. My lord, I am praying that the suit be, my lord, dismissed, your lordship, because of the deliberate, my lord, violation of your lordship's order continuously on every day basis, your lordship.
Department का report आया.
My lord, as per my lord's last order, my lord, I have communicated my lord's order to the department. My lord, I don't know, my lord, I have communicated to my client also, but I have not received any instruction from my client. That
What?
actually, my lord, my client is of the view is my
भेजा था. Department ने भेजा था.
My lord, a report is supposed to be filed by the department to this effect.
That's not communicated.
My lord, I think Mr. Sen is attempting to join. I find Mr. Sen's name in the
Nobody
tabloid.
is here
That is
to
the difficulty. In courtroom number
operate.
36, there is no stenographer. So we gave the option. We suggested that my lord will dictate slowly. It is getting recorded. It can be managed.
Mr. Sen, is your lordship leading me? If someone of the officers of your lordship can kindly assist in joining Mr. Sen, he is texting me online.
There is no staff. That's the difficulty.
Yes. Yes, after the amendment, why you are not served?
My lord, I have communicated my lord's order to the department, my lord.
Department has complied with the order.
But I have also informed my client to come and re-verify the plane.
My
lord, I have not received any
the
instruction.
court can go to your client and take the signature of your client on the verification. If you are not having the control over the client, can the court go to your client and take the verification of your client at the home? What you are making submission? Your client has not come. I am dismissing the suit. Your client will automatically come for restoration of the suit. What can be done?
Kindly do that. Kindly do that.
What can be done? If your client is not coming, you have complied with the order of the amendment after the period of 6 months, not 6 months, about a year. Once this on 13th August it has been complied with. Now we are on 28th August. 15 days has been passed. The client has not come for the affidavit and re-verification and re-confirmation. So what can be done?
My lord, on 27th February, your lordship passed an order asking them to amend the plan. 27th of February, if your lordship sees the order, and then on 3rd of April, and then on 8th of August. It is the third order that your lordship had reflected in your lordship's order that they should amend the plan and serve it upon us. They are not deliberately, my lord, adhering to your lordship's order.
Client is not interested, then the court will dismiss. What can be done?
My lord, give me 10 days time, my lord. I will
10 days for re-verification, reaffirmation of the plan.
My lord, I will seek an instruction from my lord.
What instruction? Only for what instruction?
My lord, what my client's view is that a review has been filed from that order of amendment, my lord.
I know the intention. I know the intention.
I have
Intention has come 2 days before from the mouth of the learned advocate. That's why I passed the written order.
This is a generational intention. Even his
that has come because you didn't want to amend this prayer because till the disposal of the review application, it was your intention. So and so appearing for the plaintiff. You are for the Mr. Banerjee?
But I am appearing on behalf of the defendant number 5.
So and so. And Mr. Mandal?
Yes, your lordship. I am appearing for 2 and 4. I am led by Mr. Sen, your lordship. He is waiting online, but unable to join, your lordship.
Defendant number 2 and 4, and so and so appearing for the defendant number 5. You are appearing for plaintiff.
After your lordship's order, your lordship, I'll indicate I am the chairman appointed by the honorable court. Lordship can understand my situation, your lordship. 2018, I am doing it. Lordship, once your lordship, I expressed your lordship, I don't want to, your lordship, continue. If your lordship kindly consider it. Now, your lordship, they are taking decisions, sending it to me. I'm just your lordship, without any powers. I'm only disbursing your aspect.
No, I don't want to because they have filed the review application. Otherwise, it could have been full stop. Let's wait some time. We'll see to that. Okay. Appearing for so full stop. In terms of the order dated 8th August 2024, the registrar origin site has submitted the report informing that the office has carried out the amendment in terms of the order passed by this court. Full stop. The counsel for the defendant, counsel for the plaintiff prays for time to serve the amended copy of the plaint to the defendants. Full stop. Considering the submission made by the counsel for the plaintiff for the interest of justice, case adjourned for a week. Place the matter on.
My lord, kindly direct them, my lord, with a last opportunity, your lordship,
September
peremptorily.
2024. In the meantime, the plaintiff is directed to serve the copy of the amended plaint to all the parties within the date fixed, failing which the court will pass appropriate order. Please the matter on 5th of September.
My lord, one humble request, my lord, instead of 5th, can it be, my lord, the next week? I am in some difficulty on 5th, my lord.
And 11th September. Next.
Deeply obliged, your lordship. 6 and 7, both, your lordship.
Yes. Item number?
My lords, I appear on behalf of the petitioner, plaintiff petitioner, your lordship. Mr. Banerjee is leading me in this matter, your lordship. Sudhashotta Banerjee and my lord Shaunak Sengupta, my lord, they are leading me in this matter.
What is the application for? Who is
My
for the
lord,
other
GA1 is my lord the injunction application.
You are
and-
for the plaintiff?
Yes, my lord. And
Who is for the
GA3,
defendant?
my lord,
Nobody.
Mr. Gupta is there. He is there waiting virtually, your lordship.
कोई है
Shayan
कि
Gupta, my
computer?
Well, I have been told that he has not been given entry.
Huh?
Shayan Gupta has not been given entry. He is just texting me to.
He's there waiting, my lord. He's for the other side, your lordship.
But my person is not here who is operating the.
দেখো তো সুদর্শত্ব আছে কি সুদর্শত্ব ব্যানার্জি আছে মনেরও জন অ্যাডমিট অল উপরে
All are on online.
I'm sorry, my lord.
That I have fixed, Mr. Sen, I have fixed on 11th of September.
Very
as
well.
a last chance, otherwise I'll pass separate order.
Very well, my lord. Yeah, I think, my lord, there is a report which says that they have not taken any steps.
No, the report has come. They have the department has carried out the amendment. Now they have to verify, reaffirm, and the amended copy is to be served to you, all
Yes.
of the dependent.
They
They ask for
they
the
have
time.
not done that.
11th of September, then they will take the necessary steps and then the matter can be proceeded with.
By that time, they have to serve the amended copy of the plaint to all the parties. Then we'll see.
Obliged, obliged.
Yes. Mr. Gupta is there? No.
Gupta is there, my lord.
Yes,
Yes,
Mr.
sir. I'm grateful. I'm grateful to Mr. Banj. I was not getting entry, my lord, in the. But I'm opposing this application, my lord. But I would like to use an affidavit because there's a story which is way beyond the whatever little the parties have agreed has been
GA1?
GA1, your lordship.
GA1.
Yes, my lord.
But this is that matter your lordship would recollect, my lord, one of the defendants had passed away and my learned friend had taken out an application for substitution that has been carried out.
Correct.
But this is an interlocutory application praying for interim reliefs in the suit. I would kindly gives us 3 weeks time to use an affidavit.
Mr. Gupta, is for the The plaintiff has filed an application being GA1 of 2024, praying for interim order. For the counsel for the defendant prays for time to file affidavit in opposition. You are offering for 1 to 7 and 9 to 11?
Yes, ma'am.
What about the 8? No, nobody is offering.
8 had passed away. Thereafter, substitution has been carried out.
Yes. 1 to 7 and 9 to 11. Let affidavit in opposition be filed within 3 weeks. A reply, if any, there to be filed within 1 week, 2 weeks.
2 weeks, your lord.
Within 2 weeks. This is the matter on. Fourth of October.
But before the
let the proceeding be completed.
Right. Great.
Extremely obliged, ma'am.
Grateful. My lord, item number 9, my lord, I appear for the petitioner. My lord,
I take to appear for the defendant number 1 and 2.
My lord, this matter was taken up on 1st of August 2024. It appeared under the heading to be mentioned. My lord, thereafter, my lord had been pleased to fix the suit, my lord, which is a summary suit under Order 37 on 10th of September. My lord, only one affidavit has come in from Mr. Choyan Gupta's client, who is a third party to this proceeding. My lord, my reply is ready, but the deponent could not go to affirm it. I was praying for some time, my lord, to affirm the affidavit. Maybe, my lord, by next Friday, my lord, we can affirm the affidavit or Monday, and lordship may keep this application, the interlocutory application, anytime after 10th of September.
No, 10th of September for witness action. What is the interlocutory
My
application?
lord, there won't be any necessity of any witness action or anything, my lord. Why I say this? Because it's a suit under Order 37, and the provisions of the provisions of, my lord, Order 37 entitle me to a judgment in a summary form if, my lord, the defendant within the stipulated time period does not enter appearance in the suit. And the lordship has taken note of that from the report filed, my lord, report of the registry, which, my lord, I had relied upon on the last day. That is the reason why I was praying, my lord, kindly keeps it after, my lord, 10th of September, the interlocutory application. And, my lord, in the meantime, if there is a decree, my lord, maybe lordship need not go into that application at all. And in the meantime, kindly permits me to put in affirm my affidavit in reply to the, my lord, affidavit filed by Mr. Choyan Gupta's client.
So it is already fixed on 10th of September.
No, the interlocutory application, my lord, it is today, my lord. It's GA1 which is appearing today.
Okay, 22nd of August.
Yes, that's right.
So you want to file affidavit?
I want to file my lord, it's ready, my lord. I could not affirm it because of these, my lord, 2 days, my lord, the deponent could not come. Give me time to affidavit.
Yes, I am appearing for the defendant number 1 and 2. But we have carried out 2 applications, that is GA3 and 4, my lord. We could not serve. We have tried to serve it on Friday, my lord. My lord has granted us a leave to file this application. But what happened, my lord? If your lordship see the order dated, my lord, 13th December 2020.
That is not on the board. That is not on board with regard to your AP 3 and 4.
Yes,
one is appearing today.
Yes, my lord. My lord has granted us a leave to file, my lord. There is some difficulties, but we could not appear, my lord, and file. Only Vokalatnama has been filed, my lord. Thereafter, this application has been filed, my lord. If your lordship kindly, my counsel is not there, my lord. Mr. Mukherjee is leading me in this matter. But if your lordship kindly keeps it on 10th, we have no objection, my lord. Then, in the meantime, we will serve the copy of this application.
Have you filed the GA?
Yes, my lord. It is GA 3 and 4.
Let the same become on list.
Very well.
So appearing for the plaintiff. Yes, Mr. Gupta is appearing. Mr. Gupta.
Yes, my lord. I appear for a third party in the suit against whom interlocutory relief has been sought by the plaintiff.
Mr. Choyan Gupta, then advocate appearing for the Aurora Studio Private Limited. Aurora Studio Private Limited. Mr. The counsel for the and has filed an application being GA1 of 2023. Police counsel for the plaintiff prays for extension of time to file affidavit in opposition. Let
affidavit in reply, my lord, to the Aurora's affidavit.
Reply. Let affidavit in reply be filed by.
My lord, I'll affirm it by Monday, my lord. Kindly gives me time till Monday.
And by.
My lord, that should be, my lord. Monday should be, my lord.
Now, who has filed the GA1?
GA1 is petitioner, plaintiff's application, to which
them, my lord.
In opposition. I am petitioner will only file a reply to Aurora's affidavit by 2nd of September. That is good enough, my lord. 2nd of
2023. Police. Place for action on 25 affidavit in reply. Let affidavit in reply be filed by 3rd of September 2024. After serving the copy to the intervening applicant and the defendant.
My lord, I have not filed any application for intervening. He is wanting to rope me as a party.
Okay.
So I have not applied.
Let the matter appear on after serving copy to the defendants. Let the matter appear on 10th of September 2020.
My lord, it's a non-commercial matter, maybe on 11th.
Non-commercial?
Yes, non-commercial.
Yes, non-commercial, because lordship is taking it up today, my lord. So
why 10th September is given?
I think, my lord, there was some mistake, my lord, that day, my lord, we did not realize that.
11th September.
Grateful.
Grateful, my lord.
I appear on behalf of the respondent number 1. Your
My lord,
lordship
I
sees
appear
the
for the
last two orders. One is
my lord,
of
I
7th
appear for the
August.
petitioner, my lord,
one 10th
before
July.
Mr. Roy Choudhury, my lord, prejudices lordship's mind, my lord. Kindly, my lord, hears me out, my lord. I am, my lord, seeking
lord,
today an extension.
But
I know
again, my lord, third and fourth
granted me,
extension.
my lord, extension to file my reply, but I was not keeping well the entire last week, my lord. I couldn't come to court. My lord kindly gives me, my lord, 10 days time. I'll put in my reply. Mr. Roy Choudhury's client will not suffer any prejudice because there is
my
no.
learned friend may say so. Your lordship sees the 10th July order and then the 7th August order. My lord, twice, my lord, it can't be. I understand my learned friend may say I was unwell for 1 week, but the time had expired long before 1 week. Your lordship just sees these two orders, 10th July and my lord, 7th August. My lord, this matter, my lord, my learned friend has always pressed only for ad interim orders and nothing else. When it comes to hearing of the final matter, my learned friend has a lot of problems.
Yes. In this
My
matter,
lord, the affidavit in opposition was filed after 8 months.
My lord, 10 July,
Out of Mr. Roy
10
Choudhury
July
to
and my
oppose
lord,
an
7th August.
only 10 days.
What is the applicable? That is the interim order, interim application.
Yes,
My lord, this is an interim application of the plaintiff, my lord, against which we went up in appeal. The appeal is pending, my lord. There is
went up to Supreme Court also.
What has happened to
that? My lord, Supreme Court, we did not get anything before the appeal court. The appeal court has only said, asked the defendant to identify a portion of the suit property for the purpose of handing it over. My lord, the dispute lordship remembers. I had when
35 square meter, square feet.
Yes, my lord, 1050 square feet and the, my lord, all the 340. Yes, my lord. Now your lordship remembers 340. He was only interested in 340. He doesn't want the main matter to be heard.
Okay, okay.
My lord, I am praying only, my lord, gives me 2 weeks, my lord. As a peremptory direction, I can, my lord, put in the
some cost should be imposed, my lord.
Concessions appearing for the defendant number 1. Police counsel for the plaintiff prays for extension of time to file affidavit in reply. Police counsel for the defendant number 1 raised objection and submitted that the plaintiff has taken time for filing affidavit in reply by an order dated on 10th of July 2024 as well as on 7th of August 2024 and prays for closing the opportunity to filing the reply by the plaintiff.
My lord, kindly also records they took 8 months time to put in their opposition.
Not to impose cost upon the plaintiff for extending the time to file reply. Police counsel for the plaintiff submit that the defendant has taken 8 months time to file affidavit in opposition in connection with GA 1 of 2024 and on but the plaintiff 2024 police. The plaintiff is praying only for a week's time due to his personal difficulties. Heard the learned counsel for the respective parties for use the record. This court find that for the interest of justice, one opportunity should be given to the plaintiff to file affidavit in reply. Let affidavit in reply be filed within a week from date.
My lord, may I pray till 9th of September, my lord? A week takes us to 4th. I was, my lord, praying till 9th, my lord, kindly.
On or before 9th of September 2024, after serving the copy to the learned counsel for the defendant number 1, release the matter on 13th of September 2024.
My lord, kindly makes this peremptory, my lord.
Grateful, my lord.
It made clear that no further opportunity shall be granted for filing reply if the plaintiff failed to file reply by the date fixed.
Grateful to your lordships.
My lord, before my lord takes up the next matter.
Huh?
Before my lord takes up the next matter, may I be permitted to mention item number 8 once, my lordship?
Yes.
My lord, I would be humbly praying for a not today, my lord. If my lord kindly, my lord,
what order
considers,
passed?
my lord, for a pleadings, your lordship, there is some urgency. My lord, Mr. Banerjee was unable to log in, your lordship. He called me just now, your lordship.
What order passed?
I'll inform Mr. Gupta once again, your lordship.
Yes, affidavit in opposition.
There is some urgency, my lord. We would like to move the matter, my lord, Mr.
But
Banerjee.
it is passed now. Where is the other side?
I'll inform my lord, Mr. Gupta.
Mention, give the notice, come tomorrow, then we'll see to.
So grateful, my lord.
My lord, I beg to appear for the plaintiff, my lord. There was an order to issue the summons.
Order?
To issue the summons.
Issue the summon.
That's given.
Is Kuti there arrange summon? Yes. What do you want?
The summons has been issued, my lord. Yeah, but they have made a more delay. They have issued it not yesterday. So, my lord, kindly fix a date, a short date, my lord.
Concession suffering for the plaintiff. Police to the superintendent attached to the office of the land and master and officer directly has filed the report informing that the defects have been cured by the plaintiff. Cured by the plaintiff. In view of the above, the department is directed. Have you submitted lodged the summons?
The summons has been lodged, my lord, yesterday.
Okay.
There was a delay.
Directed to take appropriate steps for issuance of summons upon the defendants. Next.
My lord, kindly fix a date, my lord.
They will fix outside or within the jurisdiction. They will take the date.
My lord, item number 12, next matter is, my lord, also an originating summons suit, but kindly takes it up tomorrow. My junior has a bereavement in the family. He was supposed to be there in court to assist your lordship. Kindly takes it up tomorrow, my lord. I'll be there, my lord.
Not today.
Obliged to you.
Item number 13.
Your Lordship, in item number 13, I appear for the defendant. I'm being led by Mr. Banerjee. If your Lordship, Mr. Banerjee is here, Your Lordship.
I'm appearing on behalf of the defendant, my lord. The Lordship would recall that this is an anti-suit injunction to stall the matrimonial proceedings filed by the party.
Of the plaintiff, Lordship.
Yes.
My lord, your Lordship had directed us to file our affidavit. We have done so, my lord, within time. My lord, we have also taken out an application challenging the jurisdiction of this honorable court, which is, my lord, an application under Order 7, Rule 11. But I am told by my learned advocate that the matter, my lord, has not gone through scrutiny before the master. But, my lord, if your Lordship kindly takes up the plaint once, since this is a point.
Which other side?
I heard somebody saying online.
Which was the plaintiff?
Lordship, I beg to appear on behalf of the plaintiff, Lordship.
Admit, where is? What is your name?
Lordship, am I audible, Lordship?
What is your name?
Aniruddha Ganguly, Lordship.
No, your name is not found in the list.
Lordship, is it now available, Lordship?
You are not.
It is called ghosted.
Yes. Admit.
Yes.
Admit.
Mr. Ganguly is already admitted, but his video seems to be off. Oh,
yes. Yes. Unmute, yes.
Lordship, am I audible right now?
Yes, you are audible. Audible, videos, all the things. Yes.
Lordship, I beg to appear on behalf of the plaintiff, Lordship. Lordship, Mr. Devbru Bhattacharya is appearing on behalf, is leading me in this matter, Lordship. Lordship, can this matter? They have filed an opposition as well as an application, Lordship, as my learned senior friend has stated. Lordship, we are.
What do you want?
Lordship, I am praying for at least 2 weeks' time to file the reply as well as the reply to the application, Lordship, as they have submitted the opposition just a few days back, and for that reason, And for that reason, Lordship, we need to file as well as affirm the same.
Consensus appearing for the plaintiff, consensus appearing for the defendant. Police counsel for the plaintiff press for time to file affidavit in reply to the affidavit in opposition filed by the defendant. Let the affidavit in reply be filed within 2 weeks. List the matter on 18th of September 20.
My lord, I do not stand in the way of the order. I only, my lord, intended to show your lordship one paragraph from the plaint.
What can we then?
My lord, the difficulty is that since this matter is pending before the High Court at Calcutta, my lord, their lawyer at California is citing pendency of this matter, and the California court, my lord, is adjourning the matter which is going on over there. However, till now there is no ad interim order passed by your lordship. This, my lord, in practicality is what is happening. In this anti-suit injunction, they say that the Special Marriage Act is applicable to the parties. Parties stay at Bardhaman, and that is the reason why the Calcutta High Court has jurisdiction. This is exactly a paragraph. This is the only paragraph I wanted to show your lord.
Okay, but the senior is not here.
No, then, my lord, they may file their reply after 2 weeks, my lord. But
come on, 18, come on.
But
Yes,
my lord, your lordship would, my lord, I
When,
beseech.
when your matter is fixed in California court?
My lord, 28th.
28th of
August.
Today.
Yes.
Today, yes, Lord.
That is, my lord, your lordship.
You take after the 18th, and by the 18th it will be
My
decided.
lord, I beseech your lordship to, my lord, kindly add a line, if so commensurate, that, my lord, this proceeding should not affect that matter there.
No. Yes, next.
Obliged.
And I'm appearing for the plaintiff in this matter. My lord, the defendant has approached us for settlement. This is a suit for eviction and for mean profit. The defendant has approached the plaintiff for settlement. I'm praying for 2 weeks' time. And my lord, I'm also to file my affidavit in reply and opposition affidavit in reply to the chapter 13A that I have filed, which is GA1.
You're for the plaintiff.
I'm for the plaintiff. And the opposition to the Manuel, kindly keep it after 9th of September.
So appearing for the plaintiff and submit that. There is a talk of settlement between the parties going on and praise for 2 weeks time. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 19th of September 2020. Next.
My lord, in item number 15, my lord, I beg to appear on behalf of the petitioner. My lord, this is my suit for recovery of money lent and advance. My lord, GA1 is my application for injunction. My lord, we were attempting to settle the matter. My lord, perhaps now, my lord, it transpires that my lord, settlement is perhaps not possible. My lord, if your lordship kindly takes up the matter any day next week, my lord, we shall move the matter and pray for ad interim release before your lordship.
Defendant.
I am appearing for the defendant.
Yes, affidavits completed.
No, your lordship, we have not
will
moved
require
for
affidavit.
ad interim release, my lord.
Matter will require affidavit, my lord.
Affidavit is completed now.
No,
No, your lordship, we have not moved
My lord,
before your
discussing on
lordship, my lord,
settlement
for
is
praying
now.
for ad interim release. My lord will permit us to move for.
You moved anti-interim relief today.
My lord, Miss Noel Banerjee is my lord leading me, my lord. She is not appearing. My lord, kindly takes it up next week, my lord, on 4th.
I am passing a direction for affidavit.
No,
If
in that event.
If time permits, you're not arguing the matter.
My lord, kindly keeps it at. My lord, kindly keeps it tomorrow, my lord. My lord, we shall move.
Then I am fixing after vacation.
Your lordship, my lord, the settlement has. My lord,
Today
I am
is the
late.
date. If you want the ad interim injunction, you argue today. If you will not argue today, I am passing a direction for affidavit.
My lord will kindly pass over the matter for some time, my lord.
I'm led by
Appearing
Mr.
for the plaintiff, appearing for the defendant. The plaintiff has filed an application being GA1 of 2024, praying for ad interim order. When the matter is called to the counsel for the plaintiff prays for time. In view of the above, defendant is directed to file affidavit in opposition within 2 weeks. Reply, if any, there to be filed within a week thereafter. Leave the matter on 25th of September 2024.
My lord will kindly not pass this order.
Next.
My lord kindly grants me a short passover, my lord. My lord, Miss Noel Banerjee is leading me, my lord. I'll ask her to join, my lord. My lord, kindly, my lord, permits us, my lord, to pray for ad interim release, my lord, kindly.
Yes,
kindly, my lord, kindly, my lord.
Who is appearing for the 16? Not today.
17. So this is my application for extension of time to file written statement.
Item number 17. You are appearing for?
Lordship, I am the defendant, sole defendant.
Who is for the plaintiff?
I am for the plaintiff, Your Lordship.
What application?
Lordship, extension of time to file written statement. Your Lordship, non-commercial suit. Lordship, writ of summons was served on 29th of July 2022.
29th of
July 2022, Your Lordship. Your Lordship, the defendant entered appearance on 3rd of August 2022. Lordship, the written statement was affirmed on 1st of May 2024.
1st of May?
May 2024, Your Lordship. There's a delay of around 21 months, Your Lordship. Lordship, I was humbly praying, since this is a non-commercial suit, the written statement may be
Lordship,
accepted.
if I may, Your Lordship, I'm being led by Mr. Dotto, and I do not know whether he's in
My
a
lord, yes, I am there, my lord. Lordship remembers when this matter was being moved, my lord, last day, Lordship was of the opinion that the defendant who was being represented by another advocate, he should come with a written statement. And Lordship inquired that whether the written statement was ready or not.
Lordship.
I was opposing, my lord, that application.
Lordship, the written statement is affirmed. It's with me.
When you affirm the written statement?
1st of May 2024.
1st of May 2024.
Lordship.
And when
Because
you
admittedly, my lord, the summons in the suit was, my lord, served, and they had chosen not to, my lord, accept the, my lord, summons. Lordship then inquired from the defendant what is the explanation. And being not satisfied, Lordship even imposed upon him that he has to agree that the suit would be taken up day to day for 6 months so that it can be decided.
Lordship, the application was taken out of on 2nd of May. Your Lordship, the written statement is the 1st of May. I'm carrying
No,
it.
application filed on 21st of June. 21st of June.
GA3, Your Lordship.
GA3, yes, GA3, 21st of June.
My lord, may I say this, my lord?
There
is another application, GA1, where my learned friend's client has, my lord, prayed for recall of an order by which the suit has been listed under the category of undefended suit. My lord, let this application GA3 be listed with GA1, and both can be taken up together and decided. Because Lordship had heard GA1 substantially, my lord, the other day, and it can be, my lord, taken up together now, my lord. In the meantime, I can use a very short affidavit to GA3.
Subject to correction, there are 3 applications. One of my learned friend under Chapter 13, one of filed by the defendant for rejection of plain. Lordship, this is the 3rd application for acceptance of written statement. Subject to correction, there were 5 matters, if your Lordship will recall, were listed together. Mr. Datta had argued another matter. Lordship, this matter perhaps has not been argued. Since there were 5 suits by the same plaintiff, I believe, or your Lordship connected family members. So your Lordship, Mr. Datta had argued another matter. This matter per se, if subject to correction from your Lordship and my learned friend, your Lordship, this matter has not been argued till date. So if this is my applicant, if your Lordship wants, your Lordship can keep all the 3 applications together, but your Lordship, the filing.
In all suit undefended.
Lordship, I am appearing.
My lord, I think Mr. Poddar is correct, my lord. I was under a mistake. I think Mr. Poddar is correct, my lord.
Mr. Kothari.
Mr. Kothari is correct, my lord.
Lordship, my suit has not been made undefended till now. My suit has not been made undefended, your
It's not undefended?
No, your Lordship, because I had entered appearance. If I had taken out an application.
My lord, Mr. Shorbujit Mukherjee would be assisting your lordship. I made a mistake.
If I may, Your Lordship, these matters are returnable on the 30th. Your Lordship had divided the matters. Few matters Your Lordship had heard out. We had moved 3 Chapter 13 applications, which Your Lordship had reserved. These are the other suits which are appearing on the 30th. If I'm not mistaken, Mr. Mukherjee is leading. Mr. Kothari is there. He's also appearing. Let this matter be tagged with the applications.
My lord, may I submit something, my lord? My lord, there are 3 GAs in the suit. GA1 is an application taken out by the plaintiff for final judgment, summary disposal. GA2, my lord, I have taken out challenging the maintainability of the suit. It's an application in the nature of Order 7 Rule 11. Now, my lord, GA3, my lord, is my application seeking extension of time to file written statement. Today, my lord, I would humbly submit, my lord, kindly allows this application, because even if this application is allowed and the plaintiff succeeds in GA1, which is an application for summary judgment, then perhaps this will not stand in the way. But if it is not allowed and we are given leave to defend, my lord, then again this application needs to be heard. Again, the written statement will thereafter need to be filed.
So what is the status of the GA1? Affidavits completed?
Yes, my lord. GA1 is ready and ready for hearing, my lord.
When it is fixed?
30th September.
30th September.
That is why I was asking.
So, okay, I will take both the application. What about the other GA2?
That's GA2 is same on the same date, my lord. Both applications will be heard together.
No. In this GA2?
Your Lordship, in this suit, GA2 is fixed with GA1 only.
GA1. So
Lordship.
let it become all together. So it will be taken up if your judgment on admission will come, or chapter 13 application will be disposed of in your favor, it will go. If it is not, then they will get an opportunity.
Very well, my lord. Let all the three applications be heard together.
That is all I was praying for. Grateful, Your Lordship.
So and so appearing for the plaintiff, so and so appearing for the defendant. It is informed to this court that another two applications being GA1 of 2024 and GA2 of 2024 in connection with CS number 177 of 2022 is fixed on 30th of August 2024. The defendant has filed this present application being GA3 of 2024, praying for extension of time to file a written statement. Considering the above facts, this court find that all the applications should be taken up together accordingly. List GA3 of 2024 along with GA1 of 2024 and GA2 of 2024 on 30th of August 2024.
Just one small correction, GA1 and GA2 are of 2023 and not 2024.
GA1 23, GA2 23.
Grateful, Lordship.
Grateful.
I'm grateful to my lord.
30th September.
Lordship.
30th September.
Grateful.
My lord, in my 18, Your Lordship, I am for the defendant number 1 unit.
My lord, in this matter, I appear on behalf of the plaintiff. My lord, I want to file my affidavit.
Huh?
Affidavit.
My lord,
What's the application for?
my lord, may I? Your Lordship, Lordship, I'm audible, Your Lordship.
Yes.
My lord, this is my application. My lord, I'm for the defendant number 1. My application for rejection of claim to Your Lordship. My lord, this application is applicable for Your Lordship for the first time, Your Lordship. The ground of this application, this suit is barred by law, barred by limitation, Your Lordship.
Barred by?
Barred by law of limitation, Your Lordship.
Law of limitation, yes.
Yes, Your Lordship.
Let they file the affidavit.
My lord.
My lord, kindly 4 weeks time.
4 weeks time, limitation, 3-page application. 3-page application, 2 hours.
The client is out of
I am
session
fixing
now.
a 2:30 for filing affidavit in opposition.
My lord, 2 weeks at least.
So and so appearing for the plaintiff, so and so appearing for the defendant. Defendant number 1. What
Yes,
about the
sir.
other defendants?
Both the
My lord,
no.
my lord, defendant number 2 is employee of the defendant number 1, Your Lordship, but he is not appearing there.
So you are appearing for the 1 and 2 both?
No, only 1, Your Lordship. I'm for the company, Your Lordship.
You are for the 1. What about the 2 and 3? Nobody.
My
You
lord,
are for the plaintiff. So and so appearing for the plaintiff, so and so appearing for the defendant number 1. Defendant number 1 has filed an application being GA3 of 2024 for dismissal of the suit. Counsel for the plaintiff prays for time to file affidavit in opposition. That affidavit in opposition we file within 2 weeks. A reply, if any, there to be filed within a week thereafter. Police release the matter on 26 September 2020.
Grateful, Lordship. Grateful, Lordship.
My lord, item number 19, my lord, I appear for the defendant number 4. One of the last occasion, my lord, I undertook before your Lordship, my lord, to file a written statement within 1 week. I have prepared, I have served, but the defendant department is not, my lord, allowing me to, my lord, file the same unless your Lordship passes any direction to that effect.
My lord, I appear for the plaintiff in this matter. My lord, this is the matter where Lordship, this application for recall of an order by which the suit was placed under the heading undefended suit. This application filed by the defendant was heard by your Lordship on the last occasion. My lord, affidavits were complete in this matter, and my lord, from my affidavit in opposition, I had tried to demonstrate that despite, my lord, the summons being served, they chose not to accept the summons. And there is a report to that effect. So thereafter, after hearing my lord, Lordship felt that the defendant, if they want to, my lord, contest, they would be, my lord, allowed to contest only if they come with a written statement. And my lord, I had prayed for costs to be imposed if Lordship is, my lord, inclined to allow the application. This was the stage at which we ended, my lord, on the last occasion, my lord.
No, my lord, I am ready with the written statement. I have served the copy upon the, my lord,
Mr. Datta's client, my lord, but the department is not allowing me to, my lord, file the same unless your lordship, my lord, extend the time for filing the written statement. Written statement, my lord, this is ready, my lord, with me, my lord.
Have you received, Mr. Datta, your client has received the written statement?
My lord, my advocate on record is not here, but if Mr.
Yes, my lord, I can show the receipt, my lord.
Mr. Chakraborty says, my lord, I will take it that, my lord, he has served, my lord. I will not join issue
No,
there.
I will show the receipt, my lord. My lord, this is the receipt, my lord.
When you receive the writ of summons?
My lord, I have not, my lord, received, my lord. But that was refused, my lord.
My
On the
lord.
last occasion, I submitted, my lord. As the my lord did not, my lord, ascertain that, my lord, any suit has been filed. That's why, my lord, he did not, my lord, accept the
Yes. Client have refused to accept. Yes.
My lord, my lord. That's why, my lord, my lord, submitted before lordship that within 1 week, my lord, I have filed, my lord, prepared the same within 1 week, and I have served upon Mr. Datta's client, my lord, on the 7th.
What is the suit for Mr. Datta?
Suit for recovery of possession.
Suit for recovery of possession, my lord. He initially claimed that he had no, my lord, nexus or relation with the property when a notice was issued. In fact, we also served a copy of the plaint as early as December 2022. Now, my lord, thereafter he files, my lord, an application, my lord, saying that in a writ petition, my lord, for the purpose of getting electricity in respect of the suit property. My lord, summons was attempted to be served. They refused to accept. Now, my lord, after this delay, my lord, they have come up with this application saying, my lord, it should be, my lord, removed from the undefended category, and, my lord, they should be given a chance to, my lord, contest.
So-and-so appearing for the plaintiff, so-and-so. Defendant number 4.
4, my lord. Defendant number
4, my lord. He is for defendant number 4.
Defendant number 4 has filed an application being GA
1
2023, praying for extension of time to file written statement. Praying for condoning the delay of 120 days for filing written statement. Okay. Counsel for the defendant number 4 submit that though the writ of summons and though the plaintiff has lodged the writ of summons and the same was duly the same was duly brought to the address of the defendant, but the defendant has refused to accept the same, and accordingly, as per the report of the department, this court has fixed the matter as undefended suit. Counsel for the plaintiff submitted, counsel for the defendant number 4 submitted. Subsequent to the refusal of the writ of summons, the defendant has approached the present counsel, and the present counsel has advised the plaintiff to take appropriate application for extension of time to file written statement. The counsel for the defendant submitted the plaintiff and the defendant has already affirmed. When you affirm the written statement?
My lord, it was affirmed on, my lord, 13th day of August 2024.
13th of August 2024, and also serve the copy to the learned counsel for the plaintiff, but the department is not accepting the written statement as this court has not extended the time for filing written statement. Per contra, learned counsel for the plaintiff raised objection and submitted that only to cause delay in the suit, the defendant has deliberately and willfully defendant number 4 deliberately and willfully refused to accept the writ of summons through the bailiff as well as the postal authority. He submits that from the report of the Deputy Sheriff of Calcutta, it reveals that the defendant number 4 has refused to accept the writ of summons and also refused to take the postal and also refused to take the summons through the postal authority, and accordingly the same was written unserved as refused. Counsel for the plaintiff submitted that the defendant has not shown any sufficient cause as to why the delay of 120 days be condoned for filing return statement, and he prays for dismissal of the application. At the learned counsel for the respective parties. Admittedly, the defendant has refused to accept the writ of summons from both ways, that is, from the bailiffs as well as from the postal authority. But subsequently, the defendant has realized and contacted the learned counsel, and as per the advice of the learned counsel, the defendant number 4 has filed the present application for condoning the delay of 120 days for acceptance of return statement. The defendant number 4 has affirmed the return statement and also sought the copy to the learned counsel for the plaintiff. Considering the above aspect, this court find that one opportunity should be given to the defendant number 4 to file return statement, but subject to conditions, subject to payment of cost of rupees 10,000 within a week to the plaintiff within a week from date. Full stop. The plaintiff is directed to pay the cost, and the defendant number 4 is directed to pay the cost of rupees 10,000 to the plaintiff within a week, and after payment of the cost, the department is directed to accept the return statement if it is otherwise accept the return statement if it is otherwise fulfill the criteria, and if it is otherwise completed in all formalities. Full stop. GA number so and so is disposed.
My lord, may I pray for 2 weeks time, my lord?
There is any counter claim?
My lord?
There is any counter claim?
No counter claim.
Okay, that's all.
My lord, may I pray? My lord, may I pray for 2 weeks time, my lord? Payment the cost, my
The
lord.
return statement is ready. You pay the cost. Otherwise,
Okay.
Grateful, my lord.
I am deeply obliged, my lord. Deeply obliged.
Yes, next.
Grateful.
Item number 20. Your Lordship, I am for your Lordship the petitioner. Lordship, I am just filed this application for clarification of your Lordship's order. Item 20, your Lordship. I am the defendant. Your Lordship has granted me an opportunity, your Lordship, to leave to defend. Lordship, kindly take page 44.
Yes.
Lordship, kindly page 44. Lordship has directed me to give secure your Lordship 11 lakhs rupees
with the
registrar original side. Your Lordship, on that occasion, your Lordship, I showed your Lordship that this particular amount, your Lordship, by way of a court order, we have already paid regarding the rent. Your Lordship kindly sees page 16. That is the order passed by the Honorable Single Judge.
Page 16.
Page 16. 16. We filed an application for the tender of the rent as well as your Lordship the current rent. Lordship has allowed it, and your Lordship kindly sees page 18. We have already deposited. Page 18, 18. 4th of March 2024. We have already given 11,24,035 as an occupational charges.
Amount claimed as earlier.
And this is the amount, your Lordship, is the area of the rent which your Lordship has directed me to secure.
Who is for the other side?
So Mr. Kankani and Mr. Arunima Lala, your Lordship, both are appearing.
Yes.
No, your Lordship, Spaja Bolli, your
Lordship, I am the advocate on record. Mr. Shengupta is leading me.
So nobody is there, not today.
Tomorrow, your Lordship, because the reason, your Lordship, the 4 weeks time has expired, we filed this application within time.
Okay, come tomorrow.
We'll come tomorrow.
So this amount has been deposited?
Yes, your Lordship.
It is not disclosed in the affidavit in opposition?
No, at the time of argument, your Lordship,
They are not disclosed in the affidavit.
It was not in the affidavit, your Lordship.
Okay, not today.
Lordship, we'll come back tomorrow.
21. Item number 21 is my application. It's for revocation of leave under clause 12. This in respect of a partition suit. The application for injunction of the plaintiff was heard, And when this point of jurisdiction was taken, which your lordship had decided at the time of grant of injunction.
Item 21, I'm being led by Mr. Rupa Ghosh. He's
Yes,
appearing on
I am appearing. I am appearing, my lord. They have already filed an appeal from your
Yes,
lordship's
may
order
I-
of 31st
may
July.
I indicate
But I
on
would
the,
like
on
to file an affidavit to this application.
Yes, my lord, I'm not praying for any order today, but my lord, in view of the pendency of the appeal from that order of 31st July 2024, may this matter stand over for 2 weeks, because the issues involved in this application and the issues which your lordship has already decided.
Where is the order?
But this order is not a part of this application.
What is the application for?
This application is for revocation of leave under
Revocation of leave
12.
under clause 2. So that will have a
That issue, this issue was taken up. This issue of territorial jurisdiction was taken up by us orally at the time of argument of GA1, which was filed by the plaintiff. Now, lordship has already decided that issue, the same issues have been made. The same points have been taken. So, my lord, since the appeal is pending, my lord, I would humbly beseech if your lordship, my lord, adjourns this matter for 2 weeks. My lord, we are taking steps for the hearing of the appeal. If by that time the appeal is heard, then, my lord, subject to whatever happens in the appeal court, my lord, the lordship may decide this application. So, my lord, for the time being, lordship, my lord, kindly adjourns this matter for 2 weeks. My lord, may we come back after 2 weeks? And then-
my lord, I don't, my lord, really join issue with my learned friend. But all I'm saying is, since your lordship anyways will be, my lord, adjourning the matter, if he can use a short affidavit also in the meantime.
Well, that may, my lord, affect to some sort of, my lord, the
Affidavit,
appeal.
what will affect you? It's my
May
right to
become-
file an affidavit.
Okay. They have filed an appeal.
Yes.
Yes. My lord, we have filed an appeal.
You have
Yes.
filed an appeal.
Yes.
Let the appeal be decided.
Yes.
In the meantime, let the direction.
That's right.
There may be a question during pendency of the appeal. They will say that this application.
Can anybody oppose anybody from filing an
Well, lordship,
affidavit?
if your lordship is kind enough to give them time to file affidavit in opposition, kindly provide that is without prejudice to my rights to proceed with the appeal.
That is always there. What my
Lordship-
learned friend is saying.
Yes, absolutely. Absolutely,
Can a
absolutely.
single
Well,
judge
that-
say, my lord,
No. Well, that is, I'm not saying that. But all that I'm apprehending is they may say in appeal court that this application affidavits have already been
cannot
taken.
be done. No such statement can be made.
Suffering for the respondent. Full stop. The plaintiff. You're for the defendant.
I'm for the defendant.
Defendant has
Yes,
filed
I'm for the plaintiff.
and filed an application being GA2 of 2024 praying for
Revocation of leave under
revocation of
clause
the leave
Leave under clause 12.
granted under clause 12 of the latest patent. Full stop. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition file by within 2 weeks, 3 weeks.
2 weeks, my lord. 2 weeks.
2 weeks. Reply if any may be
1
filed within a week thereafter. List the matter on 26 September 2020.
My lord, deeply obliged.
Grateful.
Grateful, my lord.
My lord, 22-23, my lord, I am seeking for a short passover, my lord. My lord, Mr. Jishnu Shah is reading me. He is in court number 40, my lord. Short passover, my lord.
What is the matter?
Is that the review of the
Acha,
order?
that one. Review of the order.
My lord, he will complete his submissions today, my lord. He is
Short passover. Passover.
About the 24, my lord, I appear on behalf of the applicant. This is, my lord,
I
that
appear for
alcohol
the
matter, my lord.
plaintiff, my lord. There's a series of applications which are on board, my lord. I'm being led by Mr. Chaudhary.
Or all.
Had a
The last day, lordship was hearing, my lord.
My lord, before my learned senior friend starts, my lord, may I just apprise my lord of the decision in the appellate court, my lord. My lord, we recall this is that matter where, my lord, there's
Chapter
been
13.
Chapter 13A maintainability was challenged. Thereafter, an appeal dismissed for default, Supreme Court. Then again, the appeal was to be heard. The appeal court has now dismissed that appeal.
Which one?
My lord, there was an
Chapter 13.
yes, challenging the maintainability of the Chapter 13A application pending before, my lord, which is due to come up on 13th September. That appeal filed by the defendant Harrow Hall has been dismissed. We're handing up the order, my lord, just for, my lord. I wanted to bring
matter,
that. to my-
lordship has fixed probably in the first week of September.
may I just-
Today, lordship is hearing my application. I just
May
want
this
to
be
add
kept
few.
with the record. That's all.
Yes.
My lord, may I, my lord, file? I have, my lord, in fact, concluded, my lord. Mr. Ghosh also concluded. But I just want to, my lord, cite a judgment on this, my lord. And, my lord, 2 documents, because lordship said whether you have any document on there is a nexus, whether there is any nexus between you and school, Harrow Hall, then obviously, my lord, court's view was that I may add you.
My lord, on the last occasion, Mr. Dev had concluded
I
his
know, I
submission. That's
told you.
recorded in my lord's order. Kindly.
बोलते देवी ना
Not more than 5 minutes, my lord. Kindly, my lord, takes up my supplementary affidavit once and I will cite one judgment. Not more than 5 minutes, my lord.
My lord, I'm being led by Mr. Chaudhary, is appearing online.
My lord, kindly, my lord, takes up, my lord, my supplementary affidavit, which I handed over to my learned friend previously. Not more than 5 minutes.
Dated?
My lord, supplementary affidavit was, my lord, affirmed, my lord. Just now I have handed over to your lordship, my lord. Affirmed, my lord, in August 2024. Just now, my lord.
Yes.
Lordship is got. Kindly, my lord, takes up, my lord, the first document, my lord. Page 5, my lord. This is an agreement. Lordship has got it, my lord.
Yes.
This is an agreement, my lord. At the top, Lordship would find, my lord, dated 12 September 2006, my lord. It was entered into between Harrow Hall School, represented, my lord. Kindly see, my lord, two names, my lord. My client's name, Mrs. Marilyn my lord. Kindly, my lord, see, and, my lord, her husband's name. School is being represented by the lady as well as, my lord, her husband. And this agreement was entered into for some internal arrangement, my lord, relating to, my lord, the functioning of the school with another person, my lord, whose name lordship would find Mr. K.R. Rahman. I am not going into the details of the agreement, but this is relating to some internal arrangement and function of the school. And one of the paragraphs I just place, and I would, my lord, then go to the next document, page 6, my lord. This is relating to, my lord, some internal financial debts of the school, and they were seeking some assistance. Page 6, my lord, second and third paragraph. Lordship would find, my lord, and whereas in due course of time, the said founder, with a view to run the school, efficiently formed and constituted a regular committee of management and got the same duly registered under the Societies Registration Act 1961, bearing number so-and-so, and obtained affiliation so-and-so on 24th November. And whereas the school is now being burdened with financial debts and suffering from acute financial stringency. Then, my lord, they are seeking some financial assistance, my lord. So this document, my lord, what I wanted, my lord, to show that the school was being represented by, my lord, my client, my lord. That's all, my lord, the purpose. I'm not placing all the clauses of the agreement as I submitted before your lordship that relating to some internal arrangement. Obviously, that relates to the financial debt of the school. Another clause, lordship may look into, my lord, page 7, second. And whereas in pursuance to an order, my lord, seeking some assistance.
Who has filed this affidavit?
My lord, this affidavit was affirmed, my lord, by Mr. Charles Mantos as the constituted attorney.
Of,
my lord, the applicant, Mrs. Marilyn Amstead. And the power of attorney has been already produced before your lordship, my lord.
Yes.
That he has been duly authorized to affirm and...
Then?
Yes. Now, my lord, the next document. Page 12, my lord. This is relating to page 12, lordship is, my lord.
Yes.
Got it, my lord. Relating to another suit which was filed by Kanani Properties, my lord. A notice was given by an officer appointed by the court in that suit. Kindly see third name, Mrs. Marilyn Amstead, the applicant herein. Obviously, what it appears, my lord, the school was required to be served. That's why a notice was given. Name, Marilyn Amstead, care of Harrow Hall School. So from these two documents, at least, my lord, it can be established, my lord, that she was and still is at the helm of affairs, my lord.
Yes.
And, my lord, one judgment I just want to, my lord, rely upon on this, my lord. I had cited one judgment, my lord, that is 2017, volume 1 SCC, my lord, that is relating to, my lord, at what stage, my lord, decree can be passed under chapter 13A. And I said I have a substantial defense, my lord, on merit, if I am added. Obviously, if that be so, my lord, then that judgment has some bearing in the outcome of this litigation. This is directly, my lord, relating to, my lord, Order 1, Rule 10, my lord.
Yes.
AR 58, Supreme Court 886, my lord. I have handed over, my lord, not handed over, my lord. I have given reference to my learned friend, Mr. Chaudhary, previously. Kindly, my lord, comes, my lord, to relevant paragraph. AR 58, Supreme Court 886. Straightway, my lord, paragraph 18. Under what circumstances, my lord, an application for addition of party can be entertained, my lord? Supreme Court has laid down, my lord, the law. There, my lord, what had happened, my lord? An application for addition of party was filed. That was allowed. Matter went up to the Supreme Court, and the Honorable Supreme Court had decided this. Relevant, my lord, pages 895, paragraph 18. The principle has been, or the law has been laid down. Paragraph 18. May I, my lord, place it? As a result of these considerations, we have arrived at the following.
18.
Paragraph 18, my lord.
Page
895. Lordship has got it, my lord. Arekta copy. If that is not legible, my lord, then I can hand over another copy, my lord. It at the neck. Kindly have a look at this one, my lord. Paragraph 18, my lord.
Paragraph 18.
Paragraph 18. 895.
615, 16. Rating starts from 896.
11, Lord, maybe one.
Respond number 1 and 2.
Lord, I can find it out, your lordship, Lord. Paragraph starts with, Lord, as a result of these considerations, we have arrived at the following conclusions. I can find it out for your lordship.
Judgment of Justice S. Jafar Imam.
Yes, you later. Purishkar kagos da. I'm sorry, my lord. Yes. Dekhi holo. Milche na to. Air 58 Supreme Court kotha milche. हाँ तो paragraph ta. Just give me 1 minute's time. Kotha milche paragraph. Yes, paragraph 18, my lord. Sorry, my lord.
Yes, same. Respond number 1 and 2.
Yes. Three judges bench, my lord. Justice Imam's view is the minority view. Majority view, my lord, I am placing paragraph 18. As a result of these considerations, lordship has got it, my lord. We have arrived at the following conclusions.
Again, the same thing.
My lord, it's not matching, my lord. He delay go.
Para 1. The para 13, 18.
I'm sorry, my lord. Para 13.
Sorry.
I made a mistake. It's my fault.
No.
895, paragraph 13.
Yes, 13.
Lordship, may I, my lord. As a result of these considerations, we have arrived at the following conclusions. Then, that the question of addition of parties under order rule 10, order 1 of the Code of Civil Procedures generally not one of initial jurisdiction of the court, but of a judicial discretion which has to be exercised in view of all the facts and circumstances of a particular case. But in some cases, it may raise controversies as to the power of the court in contradiction to its inherent jurisdiction, or in other words, of jurisdiction in the limited sense in which it is used in section 115 of the code. That in a suit relating to a property, in order that a person may be added as a party, he should have a direct interest as distinguished from a commercial interest in the subject matter of the litigation. May I pause here for a moment? Here, my lord, I have a direct interest in the outcome of the litigation.
Yes.
Next, my lord, why I say I have a direct interest? Because, my lord, from the documents which I have annexed, at least prima facie, my lord, her involvement in the management of the school is proved beyond doubt, my lord. Rest, my lord, cannot be decided here.
Involvement in the management of the school and occupation of the school are two different things.
Absolutely.
You are running the school in X place, and I am managing the school. So whether I am the proper person or the school is the proper person, who is in occupation of the property, what is the suit for?
Suit is for eviction.
Eviction. Who is in occupation?
At present, school.
School. And as the document which you have annexed, which you are relying upon, from the document, it shows that you are related to with the school, not in occupation. You might be managing, you might be doing that, but with regard to occupation, you are not in occupation of the school.
I cannot be directly. I tell your lordship, it's from the documents.
How your presence is necessary.
Absolutely. May I answer your lordship's query, my lord? I've shown you from the supplementary affidavits that school, my lord, status shown, my lord, is a proprietorship concern. If a school functions through a proprietor, physical possession will always be with the school, because school is my creation, my formation. So obviously, I cannot be directly in possession. I will be in possession. I am in possession. How? Through the school, because school is functioning. And that is more so, my lord, from the status of the school. What is that, my lord? That's a proprietary concern. Now the question what came before your lordship and what had fallen from your lordship, my lord asked me, it's a society, registered society. I told your lordship, I've shown your lordship from the plaint, which I have annexed and filed in City Civil Court, where they have filed the Section 10 application, that for a specific purpose, my lord, the school was registered. But the occupation or my right to the school was all throughout there. Firstly, Mrs. Amstead, after her death, I being her legal heir, I stepped into the shoes, my lord. Okay. And that's the direct interest I have so far as the management and function of the school. Okay. The creation of a society, creation of the society is nothing for a better administration and functioning of the school. So I was all throughout there, still am there, so long school is there. So if it is evicted, then obviously my right would be prejudiced. Now the question is whether it can be proceeded with in my absence, or I should be permitted to join. And that's the direct interest, my lord, I say, as distinguished from the commercial interest that has been contemplated or stated below in this particular paragraph. Next, my lord. Where the subject matter of a litigation is the declaration as regards the status or a legal character, the rule of present or direct interest may be relaxed in a suitable case where the court is of opinion that by adding that party, it would be in a better position effectually and completely to adjudicate upon the controversy. That's the language of Order 1 Rule 10, my lord. Whether my presence will create disturbance or my presence will enable the court to come to a proper and as contemplated in the provision, my lord, effectually and completely to adjudicate upon the issues. I say yes, my lord, my presence will help the court to enable, my lord, this, my lord, particular thing. Then the case is contemplated in the last proposition have to be determined in accordance with the statutory provisions of section 42 and 43 of the Specific Relief Act. I'm not going to that. In cases covered by those statutory provisions, the court is not bound to grant a declaration as paid for or a mere admission of the claim by the defendant if the court has reason to insist upon a clear proof apart from the admission. Now, my lord, the two things I, my lord, point out to your lordship, direct interest and whether my presence, my lord, would help the court to come to a better position for the purpose of effectually and completely adjudicate upon the issues. These are the two things. Now, I must tell your lordship, this is the majority view. Minority view, my lord, lordship, my lord, would find. There, my lord, the court, there, my lord, paragraph 14. Sorry, my lord.
Yes.
Lordship would find the majority view. The court, in that matter, my lord, challenge was to the order whereby application for addition of party was allowed. Court did not interfere. Paragraph 14, lordship would find. Court said yes, it's a discretionary power. Court has laid out the principle. Then paragraph 14, lordship would find, my lord, what has been observed by the court. Applying the proposition enunciated above to the facts of the instance case, we have to come to the conclusion that the courts below did not exceed their power in directing addition of party 1 and 2 as parties defended in the action, nor can it be said that the exercise of the discretion was not sound. Furthermore, this case comes before us by special leave, and we do not consider the fit case where it should interfere with the discretion of the court below. The appeal is accordingly dismissed. Then the minority view, that is, my lord, Justice Imam's view, is from paragraph 15 onwards. Though, my lord, Justice Imam did not, my lord, interfere with the proposition laid down, but his view was that lordship would find, my lord, paragraph 24. He, my lord, was of the view that the appeal should be allowed. But the proposition, or what are the factors, what principles, my lord, court would consider for allowing or rejecting an application under Order 1 Rule 10, that has not been troubled, my lord, that has not been interfered with. Minority view has been recorded. I accordingly allow the appeal as the board So that's a different thing altogether. For this, my lord, I am citing this, my lord. This, my case, my lord, directly, my lord, squarely, my lord, fits into this. These are my responses.
I'm being led by Mr. Chaudhary virtually.
It begins. On the last occasion, my lord, Mr. Bose had made submissions on an affidavit in opposition have been filed for the court. It was confirmed on 2nd of August 2020. We have served it at that point itself.
Which one?
So this is an affidavit to GA8 filed by the defendant.
Hmm.
It was served. But I find that no, this is served upon the applicant. So this opposition is to the applicant's application.
Okay.
I have a copy for my learned friend.
So you are supporting.
Yes, but
Why?
may this affidavit be kept on record?
No, my lord, without service, my lord.
You serve.
After have been served long back, my lord. It cannot be taken into consideration at this juncture.
You are not served.
No, can't be taken into consideration.
Hearing is
They have
completed.
served,
Hearing
they
is
have served
complete.
me so long.
Hearing is
Long
when?
back.
They
If
can't.
if he wants a copy, I'll give him a copy. I'm not.
But with regard to once you are supporting the applicant, so the copy of the affidavit is to be served to the plaintiff, not to the applicant. Now you are playing when the hearing has been completed. How that affidavit can be accepted? Sorry.
The hearing of GA8 has not been completed.
Yes,
by the plaintiff,
completed.
not by the plaintiff. Plaintiff has
So,
not begun.
so can it be taken?
Sir, kindly see this is an
Sorry,
affidavit
sorry,
of
sir.
2023.
This practice I am not allowing this.
Very well.
Well, a very quick reply to GA8. Well,
Yes.
kindly take the application.
Yes.
Well, in the application, the only document which is being relied upon by the intervener claiming to be a tenant is a rent receipt, which Lordship will find shows Harrow Hall, the school, as the tenant. That's the only document that is being relied upon. Well, at page 13.
Yes.
Receipt from Harrow Hall. And Millard, the whatever case is made out from the
Page
bar.
30. Page 30.
1-3, my lord.
1-3, my lord. 1-3.
Yes.
And Millard, this is Annexure B. And Millard, the averment in support of Annexure B is paragraph 6. Armstead passed away, leaving behind the applicant as legal heir. Applicant has inherited her estate and has endeavored that the Harrow Hall School continue to run on behalf of the applicant. The school tendered certain sum to the plaintiff herein for operation of the school.
Yes.
Copy of relevant rent receipt. So, my lord, two facts are admitted by the applicant. Rent has been tendered by the school, and the rent receipt is being relied by the applicant of the school, and my lord, school is a party. So, my lord, on the face of the averment, my lord, this application is not maintainable because, my lord, not a single document has been shown which would show that, my lord, Armstead or, my lord, her heir has any title.
Yes.
But secondly, my lord, kindly now take the judgment which my learned friend just now referred to. My lord, one of the principle of addition of parties is well settled. That is, my lord, the first principle is, my lord, it is the plaintiff's prerogative whether a certain person should be a party or not. Second principle is that the discretion of the court is there to add anyone as a party if the court is of the opinion that the presence of the party would be otherwise in the interest of the justice. So the second principle will override the first principle only when the court is of the opinion that the presence is required for the determination of any of the issue.
Yes.
A party cannot force himself upon the court to say my presence will be required, whatever may be the ground, because of X, Y, and Z. Now, my lord, the judgment which was relied by my learned friend, if Lordship sees paragraph 12, it was a declaratory suit. Lord, I just read paragraph 12 of the same judgment. when a declaratory judgment has been given by virtue of section 43, it is binding not only on the persons actually parties to the judgment, but their privies also. Under the term privy is not restricted sense of privy in estate, but also privy in blood. Privity may arise by operation of law, for example, privity of contract, by creation of subordinate interest in the property, for example, privity in estate, as between a landlord and a tenant, or a mortgager and a mortgagee, and by blood, for example, privity in blood in case of ancestor and heir. Otherwise, in some conceivable cases, the provision of section 43 quoted above would become odious. The contention raised on behalf of the appellant, which was strongly supported by the third respondent through Mr. Pathak as stated above, is that a declaratory judgment would not bind anyone other than the party to the suit unless it affects some property. In other words, unless the parties were privy in estate. But such a contention would render the provisions of section 43 aforesaid applicable only to declarations in respect of property and not declarations in respect of status. That could not have been the intendment of the rule laid down in 43. Under 42 and 43 indicated above go together and are meant to be coextensive in their operation. Then, my lord, that being so, a declaratory judgment in respect of a disputed status will be binding not only upon the parties actually before the court, but also upon persons claiming through them respectively. The use of the word only in section 43 as rightly contended on behalf of the appellant was meant to be emphasized that the declaration is in chapter 6. So the first distinction is that, my lord, the principle in paragraph 13, why, my lord, these heirs were added, my lord, this was involving Mohammedan property, was that this was a declaratory suit. My lord, this principle is not applicable, my lord, in case of an eviction suit, where, my lord, the defendant itself in numerous pleading, the actual defendant, Harrow Hall is claiming to be the tenant. Harrow Hall is claiming to be the tenant, but in the bar, somebody is coming and saying, I am supporting Mr. Armstead now. There are pleadings galore. I'll deal with that when I show that. And the fact is, my lord, I have shown your lordship the opposition in the chapter 13A. They are saying that I am the tenant, I have paid it because of some convoluted arrangement. It is not a real rent. But good, bad, indifferent, they have been paying rent of 20,000 rupees, the last paid rent. And that is also the rent receipt which has been relied upon by Mrs. Armstead. Now, this being the position, my lord, under Order 1, Rule 10. And my lord, second, my lord, I just forgot one thing. My lord, kindly take another supplementary affidavit which has been affirmed by Mr. Mantosh on 24th July 2023.
Yes.
Lord, paragraph 5.
Yes.
I say that it would be evident from a letter dated 19 September written by N.Z. Armstead, the late husband of the applicant, herein addressed to the branch manager of the Standard Chartered Bank, that Harrow Hall had a savings account at the relevant point of time in the said bank bearing number SB account so and so. In furtherance thereto, from the Provident Fund challans from the list of employees of Harrow Hall, form number 9 submitted to Provident Fund Authority, as also from establishment details of Harrow Hall, it would be evident that not only Harrow Hall is a proprietorship concern, but also Mrs. L.D. Armstead was the proprietor of the said school. In fact, prior to 1987, when the said school got registered as a society, it was functioning under the proprietorship of L.D. Armstead. Well, if this is the case, then there is an admission in law, even assuming this to be correct, that Harrow Hall, my lord, being the society, has taken over by operation of law. Because, my lord, society can be represented, it's a legal entity, my lord, it can be represented only by the secretary and, my lord, the other registered office bearers. In fact, they have taken out, Harrow Hall itself has taken out one application saying that the suit is not maintainable, it is not in the name of the secretary. One of the applications, my lord, out of the various GAs is that only. Now, my lord, this being the position, my lord, it's an admission that from 87 at least, even assuming whatever is being stated to be correct, well, once a society is formed and the society starts paying rent, well, there is no contractual tenancy. And well, most importantly, not a single rent receipt could be showed so far as Armstead is concerned.
Yes.
And in this case, well, it's a case of well, the person whom I am saying is the tenant is claiming himself to be the tenant. And that is the case. That is why he is resisting eviction. If my learned friend who is representing Harrow Hall supports Mr. Dev, then he has to first admit to a decree outright that he has no right. He has to admit to a decree, then only he can support Mr. Dev. Let him admit to a decree, vacate the premises, and we hear the contention of Mr. Dev. It can't be, my lord. These are all mutually destructive pleadings.
Yes.
So, my lord, GA8 should be dismissed, my lord, on the basis of the pleading itself. Number one, my lord, the rent receipt shows Harrow Hall. Harrow Hall is a party. Number two, my lord, in the supplementary, it has been admitted that even assuming that it's a proprietorship concern, my lord, proprietorship concern will not get any affiliation from any of, my lord, the boards. That was the submission that was made. So from 1987, whatever, if I assume to be correct, my lord, these are outright untrue. I'll demonstrate it later, but I am not required to. Then also by operation of law, once you say a society has taken over, my lord, under the Societies Registration Act, my lord, Armstead does not have any title whatsoever.
Yes.
You can't claim to be a proprietor and also run a society. There has to be, my lord, a limit to the inconsistency that can be addressed. So, my lord, this being the position, and also Lordship will find, my lord, the other, my lord, kindly see the annexures to that supplementary affidavit where the proprietorship is being claimed. These are all documents my lord, even page 6 of that affidavit, my lord, Lordship will find, my lord, this is a challan. State Bank of India, kindly see.
Which affidavit you are referring to?
Affirmed on 24th of July, my lord.
My lord, the one which I just showed, 24th of July, supplementary.
Yes.
My lord, the document itself will show the incorrect submission or the incorrect averment on oath. Page 6, Lordship will find Provident Fund, my lord, payments are being made. Kindly see, rupees 4,800 only paid, my lord, in the towards the middle, paid to the credit of Employees Provident Fund account number 1 on behalf of Harrow Hall.
Yes.
So the Provident Fund account is of Harrow Hall and only the depositor is Armstead. And name of the establishment is Harrow Hall.
Yes.
So, my lord, this document also does not support what is being stated over there.
Yes.
And then, my lord, Lordship will see one more document, page 10. I'll show you, Lordship, my lord, a document even prior to 87. So this is Form 9 under the Employees Provident Fund and Family Pension Fund. Lordship will find it is Harrow Hall, engaged as a school, EPF scheme so-and-so, and my lord, this is the depositor. It is only the depositor over here. It is again Harrow Hall. And my lord, page 11, similarly, establishment name is Harrow Hall.
Yes.
So, my lord, all the documents which have been relied upon on behalf of Armstead, my lord, clearly shows that, my lord, Armstead was nowhere in the picture, or if at all in the picture, was only as an employee or an office bearer with Harrow Hall and nothing else. And Harrow Hall in itself has admitted, my lord, it is a tenant, my lord, under the plaintiff. In fact, my lord, one of the contention is that I am not liable to pay to you, I am liable to pay to Y. not to X but to Y, that is, my lord, one of my sister concerns. That we will take care of, my lord, in the chapter 13. But my lord, if, my lord, today Harrow Hall tries to support Armstead, my lord, kindly pass a judgment upon admission straight away against Harrow Hall. That they are not even tenants. Because, my lord, so far as Armstead is concerned, my lord, I will get a decree on judgment upon admission independent of this, my lord. And judgment upon admission can be passed, my lord, without any trial. My lord, what they have done really is, my lord, it has cleared the way, my lord, for judgment upon admission outright. My lord, and especially so, my lord, now my learned friend says he is supporting, my lord, Armstead. My lord, judgment upon admission is straight away to be passed against Harrow Hall. We'll deal with Armstead later.
And
Chapter 30. Kindly note this conduct, my lord. Kindly note this conduct that Harrow Hall now is supporting Armstead when the chapter 13A was being argued and has filed or is trying to file an affidavit, my lord, in support of Armstead.
Yes.
So, my lord, Harrow Hall independently cannot have any right. So, my lord, this takes care of, my lord, so far as GA8 is concerned. Now, my lord,
what about this? The order passed before the city civil court.
Sir, page 9 of affidavit in reply take पर देखो city civil code section 10
Yes. Affidavit in reply, no?
Yes, yes, my lord, issues. But just a minute, my lord.
For page 13 of my reply, paragraph 11.
Correct.
Yes, yes, yes. But I forgot that point. I remember. I got my name.
Page 13, paragraph 11A.
Yes. Well, Lord, I have twofold submissions to make.
Yes.
But an issue is framed because of the pleadings. And identity of issues or directly and substantially in issue does not relate to identity of parties. My lord, these two propositions are well settled. So, my lord, when an application under section 10 is filed, I will not have to show identity of parties. All I have to show is identity of issues. And, my lord, if it is an issue over here, assuming for a moment, my lord, it is an issue over here. My lord, issues can be same, but the parties can be different. Armstead and Harrow Hall are hand in gloves with one another. The rent receipts are against Harrow Hall. If a decree is passed against Harrow Hall, Armstead will automatically go. Because, my lord, he is an employee. Now, my lord, kindly see page 10. Page 10 of the affidavit in reply.
Yes.
My lord, the section 10 application starts from page 9. Effectively starts from page 9 of the affidavit. Right? I am on page 10.
Yes.
Kindly see paragraph 4.
Yes.
In the said written statement in CS 364 of 2014, it has been alleged by Harrow Hall, the defendant therein, inter alia as follows. And then in para E, it was agreed and understood that society and Harrow Hall School would be entitled to retain perpetual possession of the said 2 rooms and any further rooms that came in possession of Mrs. Armstead. The written statement of Harrow Hall is not saying that Armstead is the tenant.
Yes.
Written statement in my suit is saying that Armstead would continue to remain in perpetual possession. Then a story is being spun that B.K. Kandani said this and that. And only this is the paragraph that is relied upon. Now kindly see the actual written statement which has been annexed. Lord, my plaint is there from page 19 and the written statement is at page 35.
Yes.
Let's kindly come to page 37. para 2 and para 3 is very important. The defendant society is running in the premises in question a school named Harrow Hall School. No question of proprietorship of Armstead and all that. Then in facts relevant, according to the defendant, they are saying that LD Armstead was in occupation, and then the pleading which has been paraphrased is that in paragraph 5 at page 38, it may be stated that rooms adjoining aforesaid 2 rooms in second floor, which is numbered as 27B, occupation of the nearby Olympia bar and restaurant in front of Kannani mansion. BK Kannani was not happy with the manner and use of the occupation. She negotiated with the management of the bar and restaurant. And as such, it requests Mrs. Armstead negotiated with the management of the bar and restaurant, who slowly handed over possession of the adjoining rooms one at a time to Mrs. Armstead. Now, Millard, assuming for a moment entire averment is correct, Armstead's possession here is through Olympia bar and restaurant. These are all, my lord, they are property grabbers, my lord, who have been staying there and, my lord, putting up, my lord, hydra heads one after another. And, my lord, this is how, my lord, this pleading comes, page 39, paragraph 7. At the time in early 70, when the said rooms were handed over to Mrs. Armstead, Mr. BK Kannani made it clear to Mrs. Armstead that society was to hold possession of the room for the purpose of imparting order. So, my lord, all that I am saying is that when the issue is to be framed, what is the involvement of Armstead, if at all, my lord, whether prior to the society coming in, my lord, this is what is relevant. If this is the suit, Armstead cannot go and file a separate suit. And if Armstead at all wants to come, my lord, it will come on as a witness on behalf of Harrow Hall. It is not required to be made a party. Armstead will come in as a witness on behalf of Harrow Hall.
Yes.
Because Harrow Hall itself has referred to Armstead. And if what Harrow Hall has stated is correct, Armstead cannot have an independent right.
Yes.
And neither does Armstead have an independent right after what it has stated in its supplementary affidavit, that a society has, from 87, a registered society is there. And the rent receipt is over there. Now, in this context, kindly see the comebacks to the Section 10 application. Let us see what are the issues that have been framed. Page 13. That issue is not whether Armstead is a tenant of the property.
Yes.
The issue, common issue, directly and substantially involved is what is the role of Mrs. Armstead in relation to the suit property. And Mrs. Armstead cannot have a better role in the suit than what has been pleaded in the written statement in this suit. And in the written statement, if this goes, my lord, that suit will automatically go.
Yes.
Then, my lord, issue B is Harrow Hall entitled to claim tenancy in perpetuity in running the said school? Because, my lord, in written statement, it is a tenancy in perpetuity. And that is, my lord, a defense in the chapter 13A also. I'll come to the chapter 13. The hearing whereof got scuttled because, my lord, GA8 was smuggled through inside.
Yes.
The Lordship kindly sees the modus operandi. All along, Harrow Hall took time on the ground that appeal is pending. Then when, my lord, the appeal is over and out of the way, now, my lord, again GA8 surfaced and a long lost application, my lord, is, my lord, again put on record, submissions are made. But absolutely misconceived. These are issues for the purpose of Section 10. And an issue can be directly and substantially without there being identity of parties. My lord, that is why exactly, my lord, to avoid a Section 10 issue, my lord, persons, my lord, they either through the air or for somebody else, my lord, they interchange and they try to avoid the Section 10 rigor by changing, my lord, and air cannot file it. Because, my lord, either Armstead or Harrow Hall is claiming to be a successor in interest. And if the school admits today because they are supporting it, well, a decree can be straight away passed against the school because of the admission that I am supporting Armstead. So I have no right whatsoever.
That's all?
Yes, madam. That's it. This is so far as GA8 is concerned. And if Lordship wants, I can continue the chapter 13A or it may be fixed on any other day.
Milord, just half a minute reply on this, Milord. Kindly, Milord, comes to Milord, section 10 once. What does, Milord, the plaintiff want? They want my suit to be stayed on one hand and to get a decree in this suit. And what does section 10 say? Obviously, Milord, from page 13, the issues which have been framed, sought to be framed.
So why you are not making application for transfer of the suit along with this? Make
Transfer?
an application for transfer of the suit from this court to here. Both the suit can be disposed of together.
Right now, Milord, the eviction
I am conceding, my lord. Let him agree. Let it be transferred here and chapter 30.
So let your suit become here. If you're telling that the connected with those, and they wanted the decree in the suit and that suit to be remain state or whatever it may be.
But I am consenting.
That, Milord, my right now it has fallen from your lordship, Milord. I need to take instruction on this. Tomorrow or any day, I can give an answer to this, Milord, without taking instruction.
No. This court has given that because you have submitted that they wanted that should be state and they want.
That's right,
decree.
absolutely.
So that's why.
That's the modus operandi.
If
Kindly have a look at section 10.
If it is your case that the conflict of decision will come, if that should be later on decided or this should will first it will be decided, there will be a conflict of decision will be there, then you have free to file an application for transfer of the case. Both the should be tagged together and disposed of.
Milord, that, Milord, I have to take instruction on this, Milord.
But no question of instruction, my lord. Kindly conclude the hearing, my lord. Again, my lord, it will be kept pending.
Yes.
That's the court's query. My learned friend is apprehensive that I am trying to defer it. No.
Yes.
Not at all.
Okay. What is the section?
Has been expressed from day one.
My lord, so far as prejudicial argument is concerned, my lord, I did not have to trouble your lordship. He is entitled to make any submission. Section 10. Stay of suit. What he is saying, my lord, on the face of it appears to be incorrect. In law, we refer to a judgment, my lord, only when there is ambiguity or a clarification is required in the provision. What does the provision say? No court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties, one, or between the parties. My lord has said anything on Mr. Chaudhary?
Yes.
Sorry, my lord. Or between the parties under whom they or any one of them claim litigating under the same title where such suit is pending in the same or any other court in law. May I pause here for a moment? Between the same parties. What Mr. Chaudhary has said? It's not between the same parties. Not required. What is required to be shown? Issue is directly and substantially same. One thing. Firstly, my lord, Armstead is not a party. Harrow Hall is a party. What's my stand? Harrow Hall is nothing but my creation. Now, if first part takes care of, or kindly see, between the parties under whom they or any one of them claim litigating under the same title.
Yes.
They have either or. Armstead is not a party, but the second one, or, which may not always be disjunctive, it's through Harrow Hall, Armstead, through Harrow Hall. And that's why, deliberately, my lord, this part has been done to stop hearing of my suit. 11A. What is the role of Mrs. Armstead in relation to the suit property? Read with this, my lord.
Correct.
They will never say that Armstead is a tenant, otherwise their suit will go. Why will they say? Role. Roles means what? It includes my right of tenancy also, because I say Harrow Hall is my creation. Kindly read this. Will they ever say, or will a plaintiff ever say, that Mrs. Armstead is a tenant? But what does the role mean? In connection with the averments made in the plaint filed in City Civil Court. And after looking into this section 10 or part, directly between the same parties or between the litigating parties. Harrow Hall is a party here, Harrow Hall is a party in the suit. And I say my presence is necessary. And the important thing, my lord, for Order 1, Rule 10, what the court has to see? Whether a person will be prejudiced or the sufferance will be caused to a litigant. And to enable the court effectually and completely to adjudicate upon the issues. That judgment.
It's correct.
That is the only thing what the court has to
Listen,
see.
what you are submitting, that is correct.
Why will he make me party, my lord?
That is to take.
You will get a decree and throw me out.
I just join issue here, my lord.
Mr. Chaudhary, just that is to be consideration with regard to the facts and circumstances.
Order 1, Rule 10. Absolutely.
Correct.
Absolutely.
It is not that yes, you have come and you have the person. It is to be considered with regard to the facts and circumstances of the case. Here, you are not made a party here. Correct. Now you are claiming you are having a
direct interest.
Direct interest. Okay. And you have sold the document.
And their admission in Section 10.
Since inception, you are having the document, you have an interest over the Harrow Hall, and you are managing that, but only the school is running by the society.
Absolutely.
This is your case.
Absolutely.
Now, they have filed a case against the Harrow Hall for their eviction on the ground of whatever it may be. Correct. So at this stage, because the defendant who are running against whom the case has been filed, they have not taken the stand which you have taken the stand in the written statement.
I haven't filed any written statement, Mr.
The original defendant,
yes,
Harrow Hall, has not taken any stand with regard to no. We are only the occupation of the premises in question, but the original management is of the Amstead.
Absolutely.
Correct. Now you have making a third case by making an application for adding as a party to say that making out a case that you are managing the school since beginning, but the society is running the school. But that is not the case of the defendant. If the defendants would have been taken that ground in the written statement, yes, we are running the society, but it's managed by the Amstead.
So that defendant has said.
No.
Yes, yes.
Nothing.
Amstead, not my client. Not my client.
Since beginning, I am telling in the written statement, what is the written statement of the defendant?
Yes. Defendant Harrow Hall has said about the existence of Mrs. Amstead.
Existence with regard to the connection.
Connection of the school. Milord, kindly, Milord, before I just kindly, Milord, visualize one thing. Lordship is hearing Order 1, Rule 10.
Correct.
Kindly, Milord, keep aside everything. Somebody has come up with an application whose suit is pending in City Civil Court, asking for a declaratory relief. Section 10 file, accepting the fact that she has a role to play in this suit. That's why Section 10 file. No, these things are very important.
Kindly come to the paragraph 7 of the written statement, sir.
Yes.
What you are making out the case, that is total different than the paragraph 7 of the written statement.
No. Just give me a minute. Just give me a minute's time. Paragraph 7, Lordship is referring to. Paragraph 7, Milord.
Paragraph 3.
Page 39, Lordship is referring to.
Yes.
Lordship. That at the time in early 70, the rooms were handed over to Mrs. Amstead.
Then.
Just wait.
By the said
Mr. Karnani, he made it clear to Mrs. Amstead that the society was to hold possession of the said rooms for the purpose of imparting education to the poor members of the Christian community, since at the time there was no English medium school in central Calcutta, which was available to the said segment of the society. In fact, Mr. B.K. Karnani, it is clear to Mrs. Amstead and to Mr. Andre Ireland that copy of it. That only was no rent to be paid for the said room, but that the adjoining rooms at 27B Park Street became vacant in Amstead could take possession of them. Then, entire written statement we have to see, not peaceable.
That's why when you argued the matter,
all throughout Mrs. Amstead, at least arrangement. Just a minute. I know.
Okay. No. I am going to
paragraph 8 regarding the. Just take note of this paragraph, Milord. I will not trouble your lordship. Paragraph 8, paragraph 9 regarding the arrangement and the payment of rent, why the rent receipt has to be issued, paragraph 11. Paragraph 11. Then paragraph 12, I place this paragraph probably. Paragraph 13. Affiliation part comes in, my lord, paragraph 13. Necessity of affiliating the school and to payment of rent, why was it necessary? Written statement filed on this averring. Paragraph 14. Paragraph 15 also.
Kindly read the paragraph 15.
Paragraph 15. That sometime in 1990s, একটু proper ভালো copy হবে এটা? Same. That sometimes in 1990s, Mr. B.K. Karnani, but that is not legible with in my copy, and Mrs. Amstead, now deceased, the problems had gone up with regard to the municipal rates and taxes in respect of premises number so-and-so, and requested Mrs. Amstead to pay some amount to the Suklal, that's the plaintiff, which would be shown as rent. In fact, Mr. B.K. Karnani expressed that the payment was required to be shown for the purpose of municipal valuation of the premises. Accordingly, a token amount of rupees 5,000 was paid by the society Harrow Hall to Mr. Karnani as rent for the school of possession of Mrs. Amstead, and for which the rent receipts is to be issued by Mr. Karnani in the name of the plaintiff. That's the arrangement. It may be stated that one rent receipt.
That's why that is the case made out by the defendant. Yeah.
But just one thing, but probably we are missing. Paragraphs are all just in half a minute. It's an arrangement made by the plaintiff, initially by Mr. Karnani, subsequently by the plaintiff, with the Amstead. School, Mrs. Amstead, just the sequence of facts. Then payment of tax, arrangement, 2 rooms, subsequently more rooms were given. For affiliation, municipal tax, rent, everything. But in all paragraphs, Lordship would find the existence of Mrs. Amstead.
That's what I'm telling
Now
you.
the question is, hearing a Chapter 13A application, decree or no decree at this stage, somebody comes in and files an application for addition of party. Add me as a party. Necessary or necessity for filing that application? A suit pending in City Civil Court seeking declaration about her status in the school. And then the sufferance that would be caused if a decree is passed in her absence. That is the point which, my lord, in my respectful submission, court has to consider while deciding the fate of the application under Order 1, Rule 10. The sufferance which can be caused to a litigant if he or she is not added. On merits, there are certain things which requires to go to trial.
That's why this court is telling, without going into that fact, why you are not bringing the suit before this court. Both the suit can be tagged together and disposed of. You will not be harmed.
My lord, I have no issues with that, but the client's call is important.
It is the lawyer to give the advice.
My lord, Lordship was
who has filed the application.
My lord, kindly see. Client has filed his application. My lord, one thing, my lord, Lordship will kindly not take me amiss. Lordship was on this side, my lord, for several years.
That's what I'm telling.
Without client's instruction, can a lawyer say yes?
See, that's why I'm telling.
Can anybody say?
So that's why I'm
Even for 10 minutes, I have to take instruction. Yes, are you agreeable? So far as I am concerned, if you ask me this question, I am ready. I am ready. But think about the situation because you are on this side also.
It is the lawyer to advise the client what is correct. What would be the benefit to the client? Client does not know what would be the benefit to him. But nowadays, the lawyer to advise what would be benefit to the lawyer, to the client in the suit.
Well, I tell you, Lordship, on a lighter note, nowadays, clients, they do understand much more than what we do.
No, that will.
And Lordship also knows this.
No, that will be in the service matter. The government servants should deal the government servant. It will. But with regard to the civil matters, I differ on that.
The person, been authorized, I can only ask.
No, otherwise I am not to take here. If you want, I am fixing after tomorrow or next week, no problem. You take instruction. If you want, then
Tomorrow, because I have concluded my argument. Mr. Chaudhary has concluded his argument. Nothing more, whether I'm agreeable to transfer this to suit. That's all.
Mr. Mantosh is in the courtroom. Mr. Charles Mantosh is in the courtroom.
He's there,
He
he's there, but
attorney.
But is the privacy?
Let him give
We are discussing on law. We are on law, not about an allegations against a person.
Why is Mr. Dev
We are on law.
He has represented
That's
both.
where Section 10 is filed.
Comfortable.
Hearing no final order has been passed. Pending. That's the fact.
And what about the defendant? They had appeared. They have filed an
Yes, that's why Section 10.
Section.
Why this Section 10, my lord? I put this question to myself. Why this question needs to be raised before the court, asking for stay of this role of Mrs. Armstead? If you are
Let him argue that Section 10
you have
over
said
there.
so many things. What
Let
is
him
the
argue
urgency? What is the
Section 10 over
necessity?
there.
Throw me out straight away.
Chapter 13
Lord,
kindly.
so far as this,
I want to
Lordship wants an answer. Keep this matter, my lord, tomorrow has to be mentioned. I can give answer to the court's query whether my client is agreeable.
That's only for that.
Absolutely.
Only
Hearing is
for that,
concluded. Absolutely.
Then if you said that, then otherwise I will pass an order for
Absolutely.
giving the written notice.
Kindly keep it as to be mentioned tomorrow. Just for this, I have to answer. my lord.
With leave of Mr. Chaudhary, my lord, one paragraph I intend to place reliance of the written statement is paragraph 16. So, Lordship,
And
kindly
if Lordship wants, my lord, I can file a written notes also. If my lord wants.
If
Tomorrow. Yes. I got your point.
that in or about July 2009, the office bearers of the Harrow Hall was approached by the directors of Kandani Properties, Tuklal such and such, who requested Harrow Hall to pay a monthly rent of rupees 2,000, which would be shown as rent. Since the following changes, well, if your lordship only comes down further down, my lord, indeed, C.K. Kandani made it clear to the members of the managing committee of the defendant that the status of the defendant would not change as a result of the increase of rent, in as much as the rent receipts that was already been issued showed that the defendant was a tenant in respect of two separate tenancies, that is, of first floor and second floor. Of second floor, since Harrow Hall, being the defendant, did not want there is little illegible on the said company.
Directors of the said company.
Director of the said
Harrow Hall, being the defendant, started paying a sum of rupees 20,000 per month to Shukla Chandanmal, being the plaintiff who used to issue rent receipts about.
These matters are to be decided by evidence. Can't be done on the basis of an affidavit evidence.
This is their written statement.
That's true.
Defendant.
Harrow Hall's written statement.
No, that's why.
Disputed facts are to be proved by evidence. Right? Key bolchu.
So that's why if this fact has been taken into consideration, they have disclosed in the written statement. Them to prove. Them to prove
at what stage? I'm not taking their stand. Them to prove at the time of trial.
Because you are deferring this.
That is what Mr. Dev has come
Not
for.
at all.
Okay.
It's a question, my lord. I am, my lord.
Suffering for the plaintiff, suffering for the defendant, and the applicant has filed an application being GA 8 of 2023 to add as defendant in the suit. Hearing is concluded. Full stop. Counsel for the applicant place for a test time to take instruction whether the suit filed by who has filed by.
But that suit was filed
by Armstead.
By Armstead, and maybe I just have to see whether any other person has been joined as plaintiff or not.
Court can be transferred before this court, so that the CS number 364 of 2014 can be analogously taken up for hearing. In view of the submission made by the counsel for the applicant, let the matter appear tomorrow as to be mentioned.
Grateful, my lord.
Let kindly fix the chapter 13A, my lord, on any date, my lord. Otherwise,
tomorrow I am fixing to be mentioned. What is the answer? Thereafter I fix the date for return notes of argument as well as chapter 30.
Grateful. The suit was filed by Mrs. Armstead and Harrow Hall, both.
Mrs. Armstead and Harrow.
And that's the number of the suit
against the plaintiff. Against the plaintiff.
Plaintiff and another. Plaintiff and another. And the suit number is, may I give the number, title suit number 304 of 2022.
City Civil Court.
City Civil Court, right? Before the learned judge, 5th bench, City Civil Court.
City Civil Court, 5th bench.
I'm grateful, my lord.
नहीं बोलो कहाँ है बोलो
My lord, my lord, item number 22 and 26 matter.
Lordship, the 12 noon matters.
Yes, yes. Call the fixed matter.
Item number 66 and 68, fixed at 12 noon.
Lord, item number 66, Lord, is fixed at 12 noon.
Yes.
Lord, this, can you remember, this is a matter application at the instance of the official trustee of West Bengal, Lord. I represent the official trustee.
Correct.
Now, Lord, in this matter, this is pertaining to a sale of a property in Ranchi,
Yes.
state of Jharkhand. On the last occasion, my lord, pursuant to my lord's earlier order, my lord, we had advertised and we had received, my lord, tenders. My lord, 10 persons had deposited their tenders. And apart from that, my lord, kindly remember, my lord, one person has also deposited separately a tender that was prior to even the publication of the advertisement. The advertisement was published on, my lord, 3rd July and the tender was deposited on, my lord, 1st July. I mean, on the last occasion, my lord, I found that a number of learned advocates were not appeared before your lordship, probably, my lord, in support of all those persons who had deposited their tenders. Today, my lord, in view of, my lord, there is some traffic disruption, my lord, in the city and around, my lord. So, whether your lordship will kindly take it up today, my lord, I am ready. Or lordship will kindly keep
Lordship,
it.
I am also
My lord,
appearing
I
for one of the
appear for
bidders.
one of the bidders, my lord.
Yes.
SK and Sons
All the
Realtors
parties are
Private
ready. Let
Limited.
the matter be taken up.
Lordship.
There are a number of learned advocates who appeared on the last occasion, but I don't see them here today.
Yes, they are here.
Lordship, I am appearing for one of the bidders.
Appearing for? Is there? Administrator General is appearing.
But I appear for the Administrator General.
Yes.
Lord, I am appearing for one of the
What's the role of the state?
Huh?
So what the court is doing? Have you gone through the orders? Have you appeared? What the court has passed an order? And what is the
Lord, I feel, my lord, it is not inconvenient to your lordships, my lord, in that
go through the orders first before making the submission before the court. Yeah. This court has taken the burden of the state, directing the administrator to publish the notice. They have published the notice, 8 quotation has been come.
10 minutes.
It has to be 10. Now it has to be seen who is the highest bidder. What you are making submissions? मनोज खोलो देखो कितना 10 है Now Bihar, they are private limited.
I am appearing.
Aparna Vihar. Just
Aparna Vihar. Veeravat के लिए.
Yes, Jai के. Next.
Appearance.
Yes. Second.
8 meter. Slap chale dan.
Who is for the Ayuravat?
I am appearing for Ayuravat.
You are appearing for both.
No, I am appearing for Ayuravat. I am for Aparna Vihar.
Yes. SK.
My lord, I am appearing for SK and Sons Private Limited, Realtors Private Limited.
Mrs. Mukherjee is leading me, my lord, for
Kundan Kumar. Nobody is there. Kundan Kumar. ये भी है सैयद खुर्शीद Safiullah Tabassum. Nobody.
This is the phone.
Azaz Ahmed. Yes. All right.
Lordship, I appear for Ehsan Manzar.
Yes.
I've also submitted within the period.
Ali. Ehsan Manzar.
Lordship.
Yes,
Ali. Sanjay Kumar Roy. Yes, 10 persons have participated. So the highest is SK 21 lakhs. And the first one is Aparna, that is 20 lakhs 1,000. Hyderabad is 19 lakh 11,000. SK 21 lakh. Kundan Kumar 12 lakh 40,000. Sayyid Khurshid 13 lakh 50,000.
Ehsan Manzar.
As Saifullah Tabassum 12 lakh 13,000. Ajad Ahmed 12 lakh 50,000. Ehsan Manzar 14 lakh 50,000. And Azaz Asraf 13 lakh 60,000. And Sanjay Kumar Raj 12 lakh 55,000. So the highest.
But I am appearing for Dhananjay Singh.
When you submitted?
Within the time.
No, that it is not here.
I am instructed that.
No tender has come. Have you submitted a tender?
Yes.
No, it is not here. Only 10%. So there is a report of the administrator, 10% of the
Only 10, my lord.
And 10 report has come. Out of the 10, the 21 lakh is the highest bidder. Yes. Yes.
Now, my lord, now, my lord, terms of my lord's last order.
What was the market value?
No, your lordship, my lord, market value was 12 lakhs. And it looks at my lord's last order, my lord. Market value was 12 lakhs per kata, my lord. When it comes to my lord's last order, it's recorded, my lord, it's 12th June 2024.
12 lakh per khata.
Lordship. Now, my lord, in terms of my lord's last order, my lord, the highest bidder is required to deposit 25%.
Correct. Yes.
Now, my lord, pursuant to my lord's last order, my lord, the highest bidder is required to deposit 25%.
Correct.
Of the rate which he has deposited in
Correct.
respect of the entire property, my lord, the value of the
Correct.
25% within 7 days.
Correct.
So, lordship will kindly pass an order to that effect, my lord, and my lord also kindly will direct that in the event, my lord, the highest bidder fails to deposit within that 7 days, then my lord, the next highest bidder, my lord, will be called upon to deposit. Kindly
Correct.
fix the time accordingly, my lord. My response sufficient, my lord, and kindly, my lord, in my order, lordship will kindly indicate, my lord, the bidders accordingly, the price as fallen for your lordship, so that when in the event, my lord, the highest bidder fails, my lord, we can call upon the second highest bidder, my lord, to deposit the money.
Yes, madam, your client is ready.
Yes, my lord.
So appearing for the petitioner. So appearing for the SK and Sons Realtors. ESSKAY. SK and Sons Realtor. So appearing for the Ishan. ESHAN. Ishan Manzar. Full stop. Give the name who is appearing.
We have given the name, my lord.
ठीक है, record कर लेना. Record कर लेना. Full stop.
My client is the second highest bidder, my lord, Aparna.
Aparna. If they fail, then you will come. Full stop.
Lordship, and in the event they fail, the Lordship, I may also be facilitated.
The third one is Erawat, I think, and
Third
the
is
fourth one
Arawat.
is Rashmi.
Third is Arawat.
Gosa's client. Ashan
Fourth
Manzar.
is you. Asan.
Lordship, Lordship.
My lord will kindly indicate the time also that in the event within 7 days, the first highest bidder fails. My lord, then within the next, my lord, 2 days or so, my lord, we'll have to call upon, my lord, the
June
next highest bidder.
Comma. The administrator had submitted a report along with 10 numbers of quotations received by the office of the administrator with respect of the sale of the land in question. Full stop. All the 10 sealed envelope is open in the open court, and after opening up the said sealed tender, this court find as follows. Mrs. Aparna Vihar Private Limited has quoted the price of rupees 20,01,000 per quote. Number 2, Airawat, AIRAVAT, Airawat Trade Company Private Limited, Tradecom, TRADCM, Com Private Limited has quoted the price of rupees 19,11,000 per quote. Number 3, SK and Sons Realtors Private Limited has quoted rupees 21 lakhs Karkotha. Full stop. Mr. Kundan Kumar has quoted rupees 12,40,000 Karkotha. Mr. Sayyid Khurshid Nurullah has quoted rupees 13,50,000 per quota. Police. Mr. Saifullah Tabattul has quoted rupees 12,30,000 per quota. Police. Mr. Ajaj Ahmed has quoted rupees 12,25,000 per quota. Mr. Ehsan Manzar, EHSAN Manzar has quoted rupees 14,50,000 per quote. Mr. Izaz EJAZ Ashraf has quoted rupees 13,60,000 per quote. And Mr. Sanjay Kumar Roy and others has quoted rupees 12,55,000 per quote. After going through the quotation submitted by the parties as mentioned above, this court find that SK and Sons Realtors Private Limited is the highest bidder who has quoted rupees 21 lakhs per quota. Accordingly, the price quoted by Messrs. SK and Sons Realtors Private Limited is accepted, subject for payment of 25% of the total amount with the Administrator General of the West Bengal within
7 days, my lord.
Within a week from date. Full stop. After depositing of the said amount, the official trustee shall take appropriate steps for registration of fair deed in the name of the property in question in the name of Messrs. SK and Sons Realtors Private Limited. How much time you will take for registration?
My lord, that is, they will have to give us a draft. We will approve that, and this has to be done, my lord, in Ranchi only, because for territorial jurisdiction, West Bengal will not have my lord, jurisdiction to register. So, my lord, 4 weeks time may be granted.
The SK and Sons Private Realtors Private Limited shall furnish the draft deed to the official trustee within a week from the date of deposit of the security amount of 25% of the total amount, and on receipt of the draft conveyance deed from SK and Sons Realtors Private Limited, the official trustee shall take appropriate steps for approval of the same from the Administrator General of the West Bengal.
The official trustee and Administrator General is the same person.
Shall approve the same.
They will have
the same within 2 weeks from the date of receipt of the conveyance deed. Full stop. After the approval of the same, the official trustee shall inform the same to the SK and Sons Realtors Private Limited within a week thereafter. Full stop. On receipt of the information with regard to approval of the conveyance deed, the SK and Sons Realtors Private Limited. Now, who will take all the who will do the all formalities?
Well, the official trustee will authorize a person. The official trustee will authorize an officer from his office who will be visiting Ranchi for that purpose. after the draft conveyance is approved, and they will go and do registration.
Contact with the officer trustee, and the officer trustee shall make necessary arrangement to obtain all the necessary documents for the purpose of registration of the conveyance deed in favor of SK and Sons Realtors Private Limited. Yes, anything further?
And my lord, all costs towards registration will be borne.
Money, they should hand over the erstwhile title deed so that the draft can
Yes,
be
my
put
lord.
in banks and sent to the official and sent to the administrator.
What deed?
Lord, we need the information to
For
draft.
the, my lord, my lord, for the purpose of drafting the conveyance deed, my lord, the recital portion, the earlier deeds, copies of the earlier deeds are required.
You are having the earlier dates,
My
Mr.
lord, copy must be there. My lord, I'll check, my lord, with my client, my lord.
Without that,
I am putting.
And
I
we'll
will
supply.
direct all the necessary documents to be provided to the so and so after deposit of the amount, so that they can prepare the draft conveyance.
Lordship. And my lord, lordship will kindly add, my lord, all my lord, the charges for registration, including stamp duty and registration, will be borne by the party, my lord.
Borne by the yes.
Lordship.
After. No, after receipt of the 25% of the total amount, comma, no, conveyance amount, the amount, comma, the official trustee shall forward the copy of all necessary documents, including the previous deed, if any, with respect of the property in question, to the party, namely SK and Sons Realtors Private Limited, and on receipt of all the documents from the official trustee.
my lord, may I be allowed to intervene? My lord, your lordship will fix a time within which, after receipt of the check, they will forward.
1 week. You have to deposit with 1 week. After receipt of the 1 week, they will supply the copy to you. And after receipt of the document, within a week, you prepare the forward the draft copy to the official trustee. Then official trustee will approve within 2 weeks, because it is the official process.
Yes.
So it will 2 weeks. After approval of the same, it will intimate to you. It will intimate to you after obtaining all the documents by the official trustee. Then conveyance process will be done, and on the date of the registration, you will pay the total amount to the official trustee in the account of the official trustee by transferring the said amount.
Deep.
Trustee, comma, the party, namely SK and Sons Realtors, shall prepare the draft conveyance deed and forward the same to the official trustee for approval within a week from the date of receipt of all the documents. Full stop. Okay, again, all the documents after receipt of the conveyance deed, we will take the approval from the will approve the same within 2 weeks. Full stop. After the approval of the deed, full stop. Then the official trustee shall also obtain all the necessary documents from the concerned department for registration of conveyance deed in favor of SK and Sons. Yet, full stop. Full stop. The full stop. The party, namely SK and Sons Realtor, shall borne all the incidental cost, that is the stamp duty and registration charges of the said deed. Full stop. The full stop. The official trustee on receipt of all the official trustee after receipt of the original deed from the SK and Sons Realtors shall submit the same to the registration office for registration for the concerned registrar for registration of the said deed. At the time of before the registration of the deed, comma, the SK and Sons Realtors shall pay the balance amount in the account of the officer trustee by transferring the said amount in the account, by transferring the same through banking transfer. To transfer, make a क्या बोला? Like officer trustee. Full stop. On receipt of the total amount, the official trustee shall execute the deed in favor of the party, namely SK so and so so and so. It is made clear that in case SK and Sons Realtors Private Limited fail to come forward for either before depositing the 25% of the security amount or after depositing of the security of the amount within a week as stated above, comma, the official trustee shall intimate that the rate quoted by the SK and so and so shall be cancelled, and the second bidder will be entitled to get the deed registered in their name on the same process as mentioned above.
Well, do we kindly keep the matter pending? Well, we'll come and report compliance because in the event
all the formalities shall be completed within a period of 8 weeks from date. 8 weeks from date. List the matter on.
That will be after the vacation.
Yes, list the matter on 7th of November 2024 for filing report by the official trustee.
And Millard, one only a submission, Millard, in case Millard, the highest bidder fails to deposit the money within a week, Millard, thereafter we call upon the second, as Lordship was directed. And Millard, the time within which the second bidder will have to deposit also is 7 days.
7 days,
Same.
seven.
As follow the same guidelines.
Lordship.
Deep.
And Millard, the other matter, Millard, item number, Millard, the other matter, item number 68, that is the other matter where Millard, the similar identical matter that's in Barabajar property. That matter today I am handicapped because the dealing officer of the official trustee, who was supposed to bring the tender, original tenders to be submitted before Lordship, he could not come to the office for traffic disruption. So as I'm only playing item number 68, kindly keeps it tomorrow or any day at around 12 noon. So we can submit the tenders.
68?
68, that's all the 2 p.m. At 12 p.m.
Yet not today.
May it be taken up tomorrow,
Not today, it will come tomorrow.
Gotcha. Grateful.
Item number 22 with 23.
वो बनाने के बाद सील कर देना उसको. Item number 20.
For review of the order, directing the input and the application to be listed in the ordinary original civil jurisdiction. Now, my learned friend started, on a very personal note. He said that, I had consented, and now, there was an attempt to, take away from the consent. And, the submission that was made in law was that, ultimately, when an order passed by contempt cannot be reviewed. Now, he relied on 3 judgments. With the greatest respect, I could not find that proposition in any of the 3 judgments. But before that, before I go to the judgments, the question that fell from your lordship was that what would be the legal effect in view of the decisions that now hold the field of a transfer of a petition, of a transfer of a suit from the original commercial, from the commercial division to the non-commercial division, and vice versa. Because
commercial to non-commercial, non-commercial to commercial, it's okay, but non-commercial to non-commercial.
No, I understand. The rationale or logic of that was that when a suit is transferred from the non-commercial to the commercial division, then a lot of paraphernalia has to be satisfied. Statement of truth, statement of verification, and 12-way leave, etc., etc. But that is not how the orders of our court have proceeded. Well, I'll show you, lordship, the judgments that hold the field, including my lord's judgment, which prompted me to say yes, it can be transferred. Now, when I say it can be transferred, I would be foolish enough to say that your lordships would be transferring it without following the procedure. When we say transfer, and the plaintiff has to be returned to be filed afresh, It is in fact a transfer. My lord, it is not, my lord, as if your lordship is rejecting the plaint because it's not Order 7 Rule 11, it's Order 7 Rule 10. So, my lord, but I'll deal with those cases later. Now, my lord, so far as the law is concerned, my lord, what my learned friend submitted was that, my lord, there is no provision in the Commercial Act, Courts Act, which provides for, my lord, transfer of a suit from the commercial to the non-commercial division. Absolutely right.
That is the thing.
But the question is, my lord, what is, my lord, now, my lord, the law that your lordships have laid down? My lord, may I, my lord, start with the law in the subject? My lord, the first of these judgments, my lord, was a judgment of our court, my lord, in Lakshmi Polyfab.
Mind in rejoinder, if he gives judgment, it's up to you by the.
No, of course, my lord, now, my lord, my learned friend.
I can respond.
Mr. Mitra, you know.
I know, that's right.
If he relies upon the judgment, naturally he'll forget.
Maybe I have to cite the judgment to counter that.
Well,
I will
sorry,
take my
my
lord.
Huh? Let's see the courts. Well, I'm sorry, my lord, this copy seems to be a little marked. If you lordship will kindly, my lord, excuse me. Just one paragraph I want to, my lord.
Lakshmi Polyfab. Which paragraph?
Para 78. Well, this is how it started. Well, let me just read this paragraph. The Act of 2015 has not provided for any transfer of a suit filed in the commercial division to any other court in the event a suit is found to be incorrectly filed in the commercial division. Thus, in my view, such suit has to be dealt with under Order 7 Rule 11 or Order 7 Rule 11 as the case may be. The fifth and sixth issues that have been raised are answered accordingly. Now, my lord, this is my transfer from commercial to non-commercial. And my lord, the view, my lord, for whatever, my lord, the reason, as expressed by this court was that, my lord, it will, my lord, then have to be dealt with either under Order 7 Rule 11 or Order 7 Rule 10. Now, my lord, thereafter, my lord, so far as this matter is concerned, my lord, there are, my lord, judgments that followed. My lord, the first of the judgments, my lord, is in the case of Deepak Polymers. My lord, may I just hand up to your lordship, my lord, a copy of that judgment? Well, let's kindly have a look at, my lord, paragraph 34 onwards. Well, the question was whether a, my lord, termination of tenancy by service of a notice under section 106, my lord, will ultimately be a commercial suit or not. And, my lord, in this case, my lord, in which was filed before your lordship, my lord, exactly the same situation. So, my learned friend were conscious that this judgment will stand in the way. So, my lord, they wanted to, my lord, it to be transferred. Now, my lord, if your lordship will kindly see 34, but I'll not place that. Kindly have a look at, my lord, 36. Since 21C7 of the 2015 Act is not attracted to the present suit, the question of valuation cannot be determined in light of section 19, as there is no scope of assumption that jurisdiction by the commercial court under section 6 of the said Act. Such jurisdiction involves dual ingredients of pecuniary limit and inherent jurisdiction. Pecuniary limit in case of a commercial dispute is circumscribed by the satisfaction of the prerequisite of dispute being a commercial dispute as contemplated in section 21C. Since the prerequisite is not met in the present case, the determinant of the valuation of the suit is not section 12 of 2015, but section 711D of West Bengal Court Fees Act. Once it is held that the dispute involved in the suits are not commercial disputes as contemplated in 2015 Act, the hierarchy of jurisdiction would not be governed by the 2015 Act, but by the Bengal Agra Assam Civil Courts Act 1887. As such, trial court exercise jurisdiction not vested in it by law in entertaining the suits and dismissing the application under Order 7 Rule 10 of the Code of Civil Procedure made by the defendant petitioners. So, my lord, there, Order 7 Rule 10 application filed for, my lord, transfer of the suit from, my lord, the commercial division to the non-commercial division. And, my lord, this court's view was that no, it was wrongly dismissed. Now, my lord, thereafter, my lord, we come to, my lord, further judgments, my lord, which seem to have been consciously ignored by my learned friends while handing up judgments to your lordship. My lord, the next judgment is, my lord, your lordship's decision, my lord, in the case of, my lord, Soumitra Sen. My lord, please have a look at, my lord, your lordship judge. My lord, may I hand it up? Copy the Well, at the first paragraph, defendant has filed the present application under Order 7, Rule 10, read with Section 115 of the Code of Civil Procedure, praying for return of the plaint on the ground that the suit filed the plaintiff is not in the nature of a commercial dispute. Now, I kindly see this order is passed in the commercial division. And then my lord looks at, my lord, the provisions, looks at, my lord, Jaspal Singh Chandok, again, your lordship's judgment, Deepak Polymers, and my lord, thereafter, your lordship, my lord, notices, my lord, the, my lord, law laid down in Deepak Polymers in paragraph 14. And thereafter, my lord, will kindly see paragraph 15. Plaintiffs have filed the suit against the defendant for recovery of possession, occupational charges, mean profits after issuance of notice dated 5th January 2018. Though the affidavit in opposition, the plaintiffs have denied that the said notice is not under 106, etc. Then, my lord, considering the facts and circumstances of the above case, this court finds the dispute involved in the suit is not of commercial dispute as contemplated under the Commercial Courts Act. In view of the above, the plaintiff, along with documents in connection with such and such, be returned to the plaintiff to present the same before appropriate court having jurisdiction to adjudicate the issue. My lord, again, my lord, commercial to non-commercial. Now, my lord, it is only in the case of Jaspal Singh Chandok that your lordship, my lord, had dealt with a similar issue. My lord, in the case of a, my lord, transfer from a non-commercial to commercial, but my lord, without noticing, my lord, as to what would be the, my lord, essential line drawn, my lord, in these cases. My lord, Jaspal Singh Chandok is also your lordship's judgment, but I don't want to cite that because that is, my lord, transfer of a suit from the non-commercial to the commercial division where your lordship held that, my lord, plaintiff must be returned and be presented afresh. Now, my lord, here, if your lordship...
In that case, I think Supreme Court judgment...
Well, I'll show you, lordship.
Supreme Court judgment has relied on.
Deepak Polymers, my lord. I'll show you, lordship. Well, that is the 2023 judgment. But, my lord, here, well, if your lordship sees the first paragraph, plaintiffs have filed the instant application under Section 15 of the Commercial Courts Act for transfer of the suit, such and such, from this court to the commercial division. That was the reverse. But, my lord, here, your lordship's, my lord, lordship does not, my lord, really, my lord, say as to, my lord, what would be the concomitants of, my lord, a transfer from the commercial to the non-commercial division and vice versa. My lord, paragraph 29, my lord, is the relevant paragraph. If your lordship will kindly have a look at paragraph 29. The order passed by the coordinate bench of this court in the case of Deepak Polymers, which the Honorable Supreme Court has also affirmed the said order in civil appeal number such and such, the same is squarely applicable in the instant case, as there is no agreement and the agreement of lease or deed relied by the plaintiff determined due to a flux of time. Well, this is, my lord, the, my lord, relevant, my lord, portion of, my lord, judgment. Now, my lord, coming to, my lord, the judgment that my learned friends relied, my lord, in this respect. Well, the first was, my lord, the Lady Moon judgment. The 2021 SEC Online, Calcutta 4240.
Yes.
Well, with the greatest respect, my lord, does not notice, my lord, Deepak Polymers, does not notice, my lord, the Lakshmi Polyfab, and my lord, kindly see, my lord, what it ultimately goes on to decide. It merely goes on to say what is a commercial dispute, as opposed to what is a non-commercial dispute.
In this case, with regard to the whether the suit is coming under the purview of
That's
the
right.
commercial.
Now, my lord, my learned friend admits that, my lord, it cannot be continued or maintained in the commercial division. Now, my lord, the relevant portions are, my lord, paragraph 21 and 23. But if your lordship sees, my lord, there's absolutely no discussion on this subject at all.
Yes, this is not with regard
Yes,
to...
that's right. Now, my lord, the next judgment. My lord, the next judgment that my learned friend cites, my lord, in this regard, is, my lord, the judgment reported, a judgment of the Delhi High Court reported in, my lord. Well, this is 2023 SEC Online Delhi 4563. Now, my lord, I am a little surprised that my learned friend cited this judgment. My lord, the judgments of our High Court, my lord, will bind our High Court. my lord, following the doctrine of stare decisis and precedents. And my lord, secondly, my lord, this was an application decided under section 24. My lord, kindly have a look at this. My lord, we should all, my lord, take some responsibility. Just like, my lord, I was taught the meaning of responsibility when my learned friend was submitting. I guess, my lord, the same should apply to my learned friends also. My lord, kindly see, the petition has been filed seeking transfer of the suit being such and such, titled Suraj Prakash versus Neeraj Kumar, pending in the court of the learned additional district judge central of such and such to the district judge commercial court. So, my lord, transfer from non-commercial to commercial again. Now, please come to paragraph 3. At the outset, the learned counsel for the petitioner submits that though the petition professes to have been filed under section 15, subsection 5 of the Commercial Courts Act, as the said provision is not applicable in the facts of the present case, it should be treated as an application filed under section 24 of the CPC. Now, it is, my lord, I don't have to, my lord, explain to my learned friends, my lord, who are, my lord, much more experienced in litigation than perhaps I am, well, as to what is the distinction between Order 7, Rule 10 and Section 24. He further submits, it is the own objection of the respondent numbers 4 and 5 to which the petitioner accedes that the suit in question raises a commercial dispute of a specified value and therefore is triable exclusively by a commercial court. And then if your lordship will kindly, my lord, turn the page. Paragraph 7. Mere reference to a wrong provision of law in the title of the petition cannot lead to the dismissal of the petition if otherwise the court has jurisdiction to grant the relief. Therefore, in the present case, this petition, though filed as one under section 15(5) of the CC Act, is treated as one under section 24. And, my lord, here, with the greatest respect, if your lordship kindly travels down and sees, my lord, reference was made to a judgment of the Delhi High Court, my lord, in Virender Kumar, my lord, where, my lord, Order 7, Rule 11 was resorted to. The distinction that is made is this. In Virender Kumar, relied upon by the learned counsel for the respondent numbers 1 to 3 also, this court had refused to reject the plaint therein under Order 7, Rule 11 of the CPC, and had directed the plaint therein to be returned to the plaintiff therein so that it could be instituted before the proper forum. In the present case, the petitioner has chosen not to await the return of the plaint, but to exercise the power of this court under Section 24. The objection of the learned counsel of the respondent numbers 1 and 2, this is very important. Objection of the learned counsel for the respondent numbers 1 and 2, 3 on the plaintiff not complying with 12A of the CC Act is also without merit. Learned counsel for the petition has stated that in the suit, not only an urgent relief was sought by way of an interim application, but was also granted, we ordered it such and such by the learned trial court. The case of the petitioner would therefore fall within the exception to the mandate of the pre-institution mediation as provided in section 12A1. In view of the above, I see no impediment in transferring the suit. So, my lord, this is a case, my lord, which is transferred under section 24. And, my lord, the objection under section 12A is taken note of by saying that the court was satisfied that the urgent interim reliefs were required and had granted that. But, my lord, with the greatest respect, well, in view of the fact that there is, my lord, clear precedent on the subject, my lord, of our High Court, well, this cannot really have any application because I think, my lord, it's very well settled that this would be only of persuasive value if, my lord, there is no direct authority on the subject of our High Court. My lord, would your lordship like me to continue or, my lord, come back?
It will take time.
It will take a little time, not very much time.
Hey, कल के क्या है? कल कुछ है? 1 बजे है कल? Tomorrow? Tomorrow 1 p.m.
Yes.
Lord, before your lordship rises.
So suffering for the plaintiff, so suffering for the defendant. Full stop. Counsel for the plaintiff has, counsel for the petitioner has argued the matter at length, but due to paucity of time, hearing could not be completed. Fix 29th August at 29th, 29th August at 1 p.m.
Great.
Lord, one request, my lord, item 15, my lord, due to some medical exigency, my lord, I couldn't come, wasn't brought to your lordship's notice any day, my lord. I am for the plaintiff, we have never taken time.
Fix on 19th, I think, 19th or
My lord,
18th.
your lordship, my lord, has given affidavit directions, I'm told. We had never taken time.
Yes, injunction, the affidavit is required.
No, my lord, yeah, there is an order of your lordship. They were taking time, my lord, on the ground of settling.
Okay, you do one thing, you do one the other side. They are mentioned tomorrow, we'll see to that.
No, they are there, they are online. I have informed.
My lord, I'm opposing this mentioning order has been passed. Let the recalling application be
No,
filed.
my lord, the only thing, my lord, I could not come. I informed the other side that because of some medical emergency, my lord, I could not come. It is not for any other reason.
My lord,
So kindly takes it up any other day. There is
My lord, I'm
already a
being
lot.
led by Mr. Jishnu Chaudhary. Let them mention tomorrow. We will be present with our counsels.
Okay, you come.
Mr. Ritoban was here. My lord, kindly takes it
You
up.
mention, let it be fixed tomorrow to be mentioned, we'll see to that. It will become as
Very
tomorrow.
well. Very well, very well. Grateful.
PM fixed matter today.
Huh?
Lordship, 1 PM fixed matter today. Your Lordship was
1 PM matter. What is the matter?
Lordship, there were 2 queries put by your Lordship that as to the Bengal Money Lenders Act, whether more than one tranche can be. Lordship keeps it any day convenient, your Lordship. I'll not trouble your Lordship now.
Day after that is a commercial day.
Commercial.
This 10 minutes.
4th September.
4th September, Lordship, at 1. Grateful, Lordship.
Time.
Other matters, other item 26 and other matters. Yes, ये तो उठे गেল
for the first appeal before the High Court do not amount to any variation of the original agreement between the parties, either in terms of Section 62 or 63, and for the purpose of this arbitration, these two orders passed by the High Court are to be ignored. Council contends that this tribunal should decide this proceeding on the basis of the original contract as if the original contract is still subsisting. Council contends that since the first miscellaneous appeal was not a regular appeal, no, that's on a point of whether he had power or not. I'm not urging that. And then one last para 32 on page 787, because in between is a judgment, my lord. Para 32. Therefore, the effect of the two consent orders passed in the first miscellaneous appeal before the High Court is that both the parties and consent have decided to change a part of the original agreement, by which the very sum due under the original contract continued to be due and payable under the second consent order dated 22nd May 2022. The first consent order having merged with the second order. The fact that imposition of the security by way of bank guarantee and legal costs were added would not amount in itself to superseding the original contract, as these relates to payments under the original contract and put the promisee in the same position as if the contract had originally been performed. It is seen that the agreement was not superseded, but was only sought to be enforced, the manner of performance being different. Thus being the case, the question in this arbitration proceeding remains as to who violated the second consent order and the consequence of such violation. Now, my lord, let me first deal with this point itself. Let's just recap very, very quickly. My lord, the agreement is of 22nd February 2022. The allegations were of breach either on 14th April or 21st April. 14th when they refunded the money, 21st when we said they should have delivered to us. The first order is on 28th of April 2022, where after making various provisions for delivery payment, it says parties are referred to arbitration. It also provides that because under this order, they are required to deliver to us at a rate when the price is higher, a bank guarantee for 5 crores in case in the arbitration it is held that we are in breach, then we would have to pay that amount.
Correct.
Now, my lord, then comes the intervening stuff, and then we go to the 20th May order. Now, my lord, one thing is very clear. On 28th April, when the reference was made, the only dispute was regarding the original contract. It could not be, because these orders did not exist, the performance was not there, issues of breach didn't arise there at all. Now, my lord, if your lordship, once you reach that position, to say, I would divert for a few minutes on one more aspect. The orders of 20th April and 20th May, they don't modify the original contract. What they provide is that although there has been an allegation of breach, and although that is referred to arbitration, to resolve the matter practically, notwithstanding the legal rights which will be determined in arbitration, this arrangement is made that if you pay, they will deliver and it will go. So these arrangements were not to affect the legal rights of parties under the contract. They were only a working out whose outcome was to be subject to the quantification of damages, nothing. So it does have an impact on the quantum of damages, but it does not have an impact on the date of breach, the allegations of breach, who was liable, who was not. Now, my lord, my fundamental point.
What was the claim?
The claim which we came was that they had, by failing to deliver on 21st of April, committed a breach of the contract. Therefore, our claim was then for specific performance and specific delivery. Their defense was that the contract stood terminated on the 14th of April due to our default. They said because we had not finalized the letters of credit, and therefore they were not liable to deliver. So that was the rival claim of the parties. There was no other claim then at that time. So let me just test it, my lord. Suppose for a moment these orders had not been there. Then what would have happened?
Original.
The arbitrators would have decided whether I was right in saying that they committed.
Whether you have violated the contract or whether they
he violated on that.
Or whether the contract has been terminated in terms of their.
And rightly terminated or not. And if so, who is responsible to pay? That does not change what, my lord, I accept one factor, that because of interim restraint orders and all, the quantification of damages might change. But it doesn't alter the rights of the parties on breach, who breached, when did the breach take place, all that.
Yes.
So, my lord, my first submission is that when the arbitrator in para 28 says, I will not decide that first question as to who had committed breach of 22nd February 2022, and instead I will only decide the third question, which is that who committed breach of the order of 20th of May, he is actually not dealing with the matter referred to him. And he is straying completely outside the reference. Now, my lord, your lordship will find in Sangyong a direct, but let us just understand. On the date of reference, this was the only issue. Merely because in the subsequent, without prejudice working out, there are breaches or no breaches or non-compliance or compliance. That does not mean
Whether the compliance of the order passed by the court can be prerogative of the
in fact, that was my second point. That at that time, your lordship will also recollect a contempt petition had been filed with the second order and rule had been issued. Surely it was not expected that the arbitrator was to decide whether a high court order has been breached or not and what is its consequences. That was never referred. In fact, it was referred only on the first part. I qualify that by saying that the arbitrator, while deciding that, in granting relief, can take regard to the fact that these orders had been there.
That can be taken into consideration.
Exactly. That is not the pivotal issue.
That can be taken into consideration and make that, yes, whether you have not complied with or whether they have not.
How much damage would be, those sort of things you could go into.
Can be,
but those are not germane for the issue reference. So my first submission is that the only matter referred was the breach, rival contentions of breach by 22nd February 2022. By declining to decide that and then saying I will decide only the other matter, you are acting in breach of the reference. My lord, your lordship will see, for example, in Sangyong, where there is a short, where are the, just give it to his lordship. For the other side. Yes. Just one para, my lord. It's too long a judgment. Everyone reads it. Para 40, page 171. It's like a Bible today. In every matter it is cited, so your lordship must be tired of looking at it.
No.
Let para 40, my lord.
Yes, that is there.
Then they're dealing with 28.3, but mark that the last 4 lines of that first para 40. Also, if the arbitrator wanders outside the contract and deals with matters not allotted to him, he commits an error of jurisdiction, and this ground of challenge will now fall within the new ground added under 34.2a. Now, here he was asked to decide the disputes of the parties. He says, I won't decide that. I'll decide whether a subsequent order of the court is complied with or not. This is not permissible. It is not his remit. His remit was to decide this. He says, I won't decide that. Now I'll decide this. That's clearly an error apparent in the award. Now, my lords, 1 or 2 more points on this. If these orders, he says that these orders modify the contract. Now, my lord, I'll just test it. I'm sorry. If the orders had modified the contract, then one would follow that once these orders had been complied with, everything would be over. But no, the order itself provides in 28th April, that notwithstanding that.
That's why the court has referred. Exactly. Why the court has referred? Court has referred in terms of the clause available in the agreement. So that's why it has been referred.
But more significantly, why would there be a 5 crore bank guarantee sought from us?
Because of the rate.
No, because a determination would result. Right. Otherwise, if you say that 20th April on compliance, everything was over, then the question of a reference, the question of a bank guarantee, all that would be irrelevant.
Correct.
And look at it from another angle. In the statement of claim, it is based only on 22-2-2022. The statement of defense is also based on 22-2-2022. But in the notes of arguments, this point of the other two orders was introduced for the first time. Now, my lord, it is, I submit, well settled that an arbitrator can decide only as per the claim and the defense. He can't go beyond that. Now, for that, my lord, there is an interesting judgment of the Bombay High Court, which I would like to place for your lordship's consideration. Because here, the arbitrator has decided on the written note outside the pleading completely. If your lord, I'll just tell your lordship, my lord, what was the facts that your lordship appreciates. This was that famous first of the scam cases where 600 crores had been paid by any National Housing Bank to ANZ Greenlays, apparently taken by Harshad Mehta and moved out. When the claim was made by NHB against ANZ, ANZ's initial defense was that they were only a collecting bank and they had complied with section 131 of the Negotiable Instruments Act. That was the pleading and the written defense. Then somewhere along the line, they realized they might not be able to sustain the defense of a collecting bank. So they orally argued that I became a holder for value of those bills. And once I became a holder of value of those bills, what I dealt with cannot affect you. The arbitrators upheld that point. Now, the argument which was made by NHB was that you can look at the pleading. If this issue doesn't arise on the pleadings at all, the arbitrator can't decide, and it will be without jurisdiction. In the light of this, my lord, just see para 93, page 103. Page number. Para 93. I hope my page number is correct. Just give me a moment. Para 93 to 103.
Now, if I could just have the reference, please.
Yes. Give a copy to the. Have you given a copy? The current report is an strange report. It's otherwise reported in learned judgments in Bombay High Court. So that's why this copy would have to be referred to.
No, that's okay. That's okay. You can give me the learned judgments reference. I'll pull it out.
That I'll give you. It's 1998 2LJ something. I'll just ensure that's made available. But meanwhile, we've taken this copy from there.
That's okay. That's okay.
It starts from para 93, page 30. At the bottom of page 30. At this stage, what is being considered is the case urged by counsel and denied by counsel that the arbitrators have decided against the pleadings. What is to be considered is whether a new case, which was not in the pleadings, on which no issue was raised, was permitted. What is to be considered is whether a case on which parties never went to trial and which was urged for the first time during arguments, after it was found that the case pleaded had not been proved, was permitted to be taken and accepted by. But I must tell your lordship that there is a slight difference. In our case, the issue was raised, but it was not in the pleadings. So it's not as if no issue was raised, because issues 2 and 3 dealt with the breach of these orders. But that I submit won't make any difference on the point that if it's not.
Once the issue was raised, so you are aware of the issue?
Yes, yes. But that still makes no difference. That is, jurisdiction is constrained by the pleadings of the party.
That is correct. That is another.
That's why I'm making the clear that there is that distinction.
Because you cannot restrain the arbitrator, that you cannot frame the issue.
Yes.
Issue was framed.
Yeah.
Now you're challenging that whether that issue.
Whether you could have raised such an issue.
Whether that
and
issue
whether you
is
could have gone into it at all. Yes.
The parameters of the context.
That's the way I look at it. But I thought I must make it clear to your lordship that that distinction is there from the judgment. Now, if your lordship just sees, thus it is necessary to see what were the pleadings on the basis of which the parties went to trial. Counsel has urged that the first respondents had disowned ownership of the check and the proceeds thereof. Counsel has urged that the first respondent under section, first respondents must be under 131.
Under section 131 of the NI Act.
Collecting in bank. And then it goes on, and your lordship will see then para 94. As already stated above, while setting out the case of the first respondents, the arbitrators do not set out that the first respondents have claimed to be the true owners of the checks. On the other hand, the arbitrators noticed that the petitioners were claiming on conversion and monies hadn't received, and these claims, as stated by Mr. Counsel, based on title, on the basis the petitioners were the true owners. The claim of the petitioners has already been set up. Then, my lord, let us go straight to para 102 on page 33. This was the pleading on which the parties went to trial. It is because of these pleadings that no issue has been raised as to whether or not the first respondents had become the owners of the check or the proceeds thereof. Ms. Counsel is right when he submits there is no assertion of title or pay or holders in due course, either positively or by reason of non-traverse. Readings show that there is a disclaimer of title. Assertion is that Mr. Mehta was the intended beneficiary. Government also is that Mehta was the owner of the checks and the proceeds. The plea that the first respondents as payees became true owners of the checks is contrary to the positive case in pleadings. It is a case on which parties did not go to trial, on which no issue was raised. Even though normally a person claiming conversion is to prove trial, in this case, petitioner's title to the checks was accepted in pleadings. Thus, even under issue number 12, the petitioners did not lead to evidence. A new case, contrary to pleadings, was made out for the first time in arguments. Undoubtedly, this was done as the first respondents realized that failed to prove the case pleaded by them. My lord, your lordship will recollect that in the note of submissions, what the other side said was that assuming we fail on the question of 22-2022, then in any case, that was modified by these two orders and the defect was waived, and therefore we can go into it. Now, just overly 5 lines and then we are done with this matter, my lord. It says, 4th line, if the arbitrators had gone beyond and contrary to the pleadings and the case on which the parties went to trial, there would have been a jurisdictional error. That would have been a case falling under the ratio laid down in associated engineering. As been held in that case, arbitrators cannot act arbitrarily or independently of the contract or case on which the parties go to trial. The function is to arbitrate in terms of the case with which the parties go to trial. If they travel beyond this, they would be acting without jurisdiction. A conscious disregard of the pleadings and the specific case would vitiate the award. In order to decide whether the arbitrators have exceeded jurisdiction, matters not appearing on the face of the award could be looked at. It was thus open to the court to see what was the case with which parties went to trial. Even otherwise, the arbitrators have set out the petitioner's submission that this case is contrary to pleadings. Arbitrators only say that disclaiming transaction is not disclaiming title. However, the pleadings are not disclaiming title. They have specifically disclaimed, etc. So, in other words, my lord, here the arbitrators have set out the statement of case and the statement of defense in the award, neither of which refer to anything outside 22nd February 2022. Only in the notes of arguments, this matter comes in. I submit, my lord, that there was no case, there was no reference on this point. It could not have been because these are matters subsequent to the reference.
Yes.
And it was not even anyone's case in the pleadings. So how could the arbitrator say, I do not decide the crucial matter referred, and I'll decide a matter which was not referred because it didn't exist. It took place 1 month later, the breach of 20th May. So that's the submission. And that, my lord, vitiates the whole award because the arbitrator has not decided what is referred and has decided what was not referred and which didn't arise on the pleadings. Yes. Now, my lord, if we go further in the award itself, from paragraph 33 onwards on page 787 is that second point which he decides, in which he decides whether there was breach of 20th May and who was responsible for that breach. Correct. So, in order to decide issue number 3, it will be profitable to quote once again the second consent order, which is quoted below. And my lord, he sets it out fully over there once again. It is seen, para 34, that the division bench on the above consent order is described, my lord, he says claimant, respondent, it's just a matter of convenience. Now, he breaks up this order into A, B, C, D, E, F at page 789. but it's only a matter of reference. So what he says is, take A. The claimant will amend the site LC into a usance LC upon a written request from the respondent, that's here, within 7 working days for the balance contract value against following documents to be provided. Then, my lord, F. The amended LC will be discounted by the claimant through the claimant's bankers under the claimant's limits within 3 days after submission of originals, bill of exchange, GST sales invoice, irrevocable delivery order by the respondent to the banker of the claimants. And then G, the respondent undertakes to start giving delivery of 10,000 materials to the claimant immediately after receiving the balance consideration through the usance LC without any delay. Now, my lord, let me just paraphrase for a moment, because here I submit that the arbitrator has misunderstood the matter. Undoubtedly, it was to be only a usance LC, nothing more, nothing less. But we were to discount the bill which we received from the other side, bill of exchange, within 3 days. And obviously, this meant that that money would be made available to the other side.
Correct.
Because obviously, if we were to retain the money, it could never work. So on a discount under clause F, the money was to be paid to him. And therefore, in clause G, he was to deliver the material.
After receipt.
Yes, after receipt. Now, the arbitrator somehow understood that if we were to discount, we would keep the money. Therefore, this could not be a simple case. Now, if that was so, then the whole order doesn't make sense. I'll just show your lordship what he says. Paragraph 35, page 790. Now, there's a misunderstanding about clause F. The discount was not to give me money. The discount was to make the money available to the other side so that the goods would go through in 3 days' time. Now, paragraph 35. This tribunal proposes to consider whether the above conditions have been fulfilled, and if not, who has breached. So far as condition A is concerned, it appears that in terms of the aforesaid order, claimant was permitted to amend the site LC into a usance LC within 7 days of receipt of the respondent's request. And the said usance LC was to be discounted by the claimant through its bankers within 3 days. The effect of such order was that the LC would be converted from site to usance, whereupon the respondent would be paid within 3 days of presentation of the documents, these being discounted by the claimant's bank. So he accepts that the discount is for the purpose of ensuring he gets paid within 3 days. And the claimants would enjoy a credit period for payment to its banker upon payment of interest. It appears that in terms of the aforesaid order, the respondent has requested the amendments. And what was the amendments? As per that letter, the words drafted site to be replaced by following drafted usance tenor to be served. Now mark these words. Provided, however, that the beneficiary will be paid at site. This is where the problem is. This is completely extraneous. The payment is to be not because the beneficiary is to receive at site, but through the discount. That is how he has to receive it. So by insisting that the tenor will be at site to him, he is actually stipulating something contrary to the order which says the tenor will be at usance. Even go further. Paragraph 47A, which he wanted to add.
Then 42C.
Yes, my lord. That was the clause he wanted to add.
Correct.
Right.
42C.
Yes.
This is a clause of the agreement.
No, this is what he proposes in the LC. My lord, this is the amendment he wanted to make in the LC by the letter of 23rd May. If your lordship sees, my lord, fourth line from the bottom, it appears that in terms of the aforesaid order, the respondent has requested the amendments in the existing LC by email of 23rd May with respect to conversion from site to usance. The following was proposed by the respondents. Okay. So he wanted the LC amended to say, yes, make it usance, but you also provide that it will be beneficiary paid at site. Now that is extraneous to the LC. The LC was, you can't have a usance LC payable at site. But he was to get the money through the discounting mechanism. That's the difference. Then even in 47A, despite the tenor of the LC, the beneficiary will be paid at site basis within 3 days after submission of original documents. Then, my lord, para 37. According to the claimant, the request made by the respondent for conversion from site to usance was not in terms of the order dated 20th May, as asserted in para 33 of the statement of claim. The tribunal is, however, unable to accept the above contention, and the tribunal is of the view that inclusion of usance terms in the LC was for the benefit of the claimant to enable it to avail of the credit period from the LC issuing bank on payment of agreed days. However, the respondent will be paid within 3 days of presentation of documents, 3 days being the time available to the claimant to discount the LC in terms of para 3. And on such discounting being made, the LC by issuing bank would release payment to the respondent.
Correct.
Consequently, the tribunal hold that the respondent has complied with the cause by making the appropriate request. Now, there's a contradiction in terms. The LC was to be only a usance LC. The payment in 3 days was to be made by us discounting and paying him through the LC.
Okay.
He insisted that no, you stipulate in the LC that I will be paid at site. That was an extraneous condition. And the arbitrator seems to say that because he was to be paid in 3 days under the discount, that condition was correct. How does it make sense?
Up till 3 days from that is, there is no dispute on that.
Yes, that we were to discount within 3 days.
Within 3 days.
Right.
There is no dispute.
No, not at all.
Only with regard to dispute whether it's site or not.
No, my lord, if it an LC is usance,
Correct.
it can't also be.
That's
site.
why
Yeah.
it is usance. So whether it can be, because after the order of the High Court, so you have requested them. No, they wanted to amend at site.
No, the order provides that they will give us a written request to amend it from site to usance.
Correct.
Right. Now they added that further part. It will be usance, but them it will be at site.
That's why it's
Right.
at site will remain in.
Yes, yes. How can that be?
That-
Because the arbitrator seems to say that was required because he was to get payment in 3 days after the discount. But if you to get it 3 days after the discount, it's not because the LC is at site. The LC is at usance, but I have to discount and pay through the LC. So the mistake lies in thinking that the requirement of a 3-day payment requires the LC to be at site. Now look at para 38. This tribunal finds substance in the contention of counsel for the respondents that once the respondents had complied with these obligations in issuing the request letter in terms of the order in the time fixed, it was for the claimants to comply with its obligations to modify the letter of credit and make payment of port and handling charges, etc. Now, once again, my lord, look at in the modifications, clause 2 on that page, clause 42C, the words drafted site to be replaced by drafts at usance, provided that the beneficiary will be paid at site. They always kept insisting that, whereas the idea was not that the beneficiary is paid at site.
This is the dispute.
Yes, this is the dispute. The idea was that he would be paid through the discount, not through the site.
That whether it should be paid at the site,
yes,
or
no, because my lord, the order is clear. The modification is from site to usance.
Correct.
Clause A. It doesn't say usance que me and site que him. So that was clearly an extraneous matter. But that is there everywhere. Then it goes on, and I'll show your lordship where it goes next. It's pages and pages, right up to page 807, I think, is the correspondence. And then paragraph 44, page 806. From the above interchange of emails between the parties, this tribunal is convinced that the respondent has by its email of 23rd May complied with the first part of the order of the court of 20th May. The additional sentences of the request of amending the site LC into a usance LC is in conformity with the direction given by the division bench. On the other hand, in spite of compliance of the direction by giving its request, it is the claimant who has not complied with its obligations arising out of the order 20th May and is illegally terminated. Now, the next 5 lines at the bottom. This tribunal is unable to agree with the contents of the mail of the claimants of 24th May, alleging violation of the order of the court. The email of 23rd May requesting the claimant to amend the LC is strictly in conformity with the order dated 20th May if clauses A and F are quoted together. A is a simple request, amend the site LC into a usance LC. It doesn't provide for anything more. F, which he puts overleaf, amended LC, will be discounted by the claimants through the claimant's bankers under the claimant's limits within 3 days after submission of documents under the LC. And then he will start paying, delivering once we pay. So where does this require that the LC has to be at site him? In fact, clause F, my lord, establishes the mechanism of how he was to get the payment. If this was just a matter of me getting credit, it would not have been in this clause.
Correct.
Clause F is a mechanism by which I ensure he gets paid immediately within 3 days. Now, the learned arbitrator misinterpreted clause F to sustain the requirement that the LC was at site KM. That is clearly extraneous, because if the court or parties had intended that the LC was to be at site KM, they would have provided this. The LC was to be at usance. The discount was the mechanism whereby he got the money. The learned arbitrator misunderstands clause F to say this justifies him requiring the LC to be at site KM. That's where the error is coming. Now, my lord, look at the way he puts it. At the bottom on that page, last para, 807, in the request letter sent on 23rd May to the claimant, the respondent has instructed to amend the LC on the basis of the order of the division bench. Clause A mentioned about to convert the LC from site to usance was subject to clause F. This type of usance LC is not uncommon. On the other hand, it is very much recognized in the field of foreign trade and is described as usance LC payable at site. The UPS LC is an agreement between the parties, buyer and seller, and a financing bank that guarantees payment to the seller upon presentation of compliant documents. Under a UPS LC, the financing bank pays the seller at site against presentation of compliant document, while the buyer pays the financing bank with interest on the due date. Now, my lord, this is patently wrong, because he was not to get it under the LC at site. He was to get it by discounting the usance LC and making the payment available to him within 3 days.
Correct.
So this order is based on a misunderstanding of clause F, read with clause G. So I submit, my lord, on the second point, the learned arbitrator could not add words to the order. The order said convert it from site to usance, simpliciter. He can't say convert it from site to usance and also provide for site with the beneficiary. That's completely changing the basis.
Where is the order?
The order, my lord, is annexed, and I've quoted it in the list of dates. I'll give you a lordship the page. May, 20th May. It's at page 68 of volume 2. 268, volume 2. But it's fully quoted in the award.
268. Oh.
Lordship, you see clause 1, 268.
Yes.
The applicant will amend the site LC into a usance LC upon a written request from the appellant within 7 working days. Now, to this, the arbitrator holds that he will convert it into a usance LC payable at site to the beneficiary. Where does that come from? He is not at liberty, my lord, to change your lordship's orders or to change the clauses merely because he might think it's more
The
convenient.
applicant will amend its site LC
Into a usance LC, simpliciter.
upon a written request from the
Now, what they insisted was, we'll make it into a usance LC to you, but payable at site to us. That is not the condition. In fact, the condition is item number 3. the amended LC will be discounted by the applicant through the appellant's bankers under the appellant's limits within 3 days of submission of originals.
Correct.
It could never be at site because he is to submit the documents.
Then only.
And then after that, 3 days later, I have to discount and pay him. So this whole story that because of this clause 3, clause 1 stands altered to say usance LC payable at site is a completely addition extraneous to the order. And he invents a new LC, usance LC payable at site. Might be, but that was not what parties had agreed. That is not what the court had ordered. So on the second aspect, he has acted contrary. If he says that this is part of the contract, I say it's not. But if he says it as, he has acted contrary to the contract and he has acted contrary to the order in insisting that in clause 1, the LC can be usance but payable at site to the beneficiary. So that was the main dispute. And that's the second point.
Correct.
Now, my lord, the third point is in fact more quaint. It's on damages. I'll tell you, Lordship, what happened. So the contract, according to them, could be breached at 2 levels. They said on 20th April, there was a price difference of 5,600 per metric ton between the contract price and the price as on 20th April. At one stage, they said, yes, in view of that, 10,000 metric tons, 5.6 crores will be our damages. Then they also said, but look, we were not in a position to sell the goods till 14 June. Because the division bench had said you're restrained. Therefore, the real loss suffered to us would be on 14 June, what was the price? And at that stage, the difference was only something which worked out to 21.98 lakhs. This was the 2 bases. What the arbitrator does, my lord?
Both.
No, it's more peculiar. He first sets out all, that both, in para 54, as I'll show your lordship. Then we argued that it has to be on the date of breach. He said, no, not date of breach in this case, because you had restrained him from dealing with it till 14 June. So I will say that the rate applicable would be the date of 14 June, which would be 21.98, which is the right measure of damages. Then in the actual award, he doesn't include 21.98, but he only includes 5.6 crores. So it's difficult to understand what he's done.
And 21 also awarded.
No, in the final award, it's not there. I'll show you, Lordship, but just look for a moment so we are clear how it works out. Just, I'll read the whole thing, but just to show your Lordships. First, look at para 54 on page 816. So he says in para 54, that, my lord, I'm just giving your Lordship a preview so that it fits. He says, after taking into consideration materials, they would be entitled to the following thing. A and B deals with the difference on 25th April, which results in 5.6 crores. C is handling charges. D is interest. Now look at E, overleaf. It would appear from the documents that the market price of goods on 14 June was so-and-so, and the difference is 21,98,700. Then, my lord, comes the whole discussion as to whether date of breach is applicable or not. And he says, my lord, look at page 822. I'm just giving your lordship a quick review, then I'll read it detailed. In last para, in the opinion of the tribunal, the claimants being fully conscious that on consent of parties, the respondent was restrained from disposing of the goods till 13 June, it could not before that day terminate the contract when the price of goods were falling in the market and abandon its prayer for specific performance. And then he holds at para 58, page 826, finally, after a long discussion, applying the above principles to the facts of the present case. Lordship has that, my lord. This tribunal holds that the respondent should get the difference of contract price and price of goods in market on the date next to vacating the interim order of the court, 14 June, as loss suffered for the breach committed by the claimant. Now, when he awards it, he doesn't include that, but he includes the earlier amount of 5 crores 60. It's a completely inconsistent award. Either there is a mathematical error and he's wrongly included 560 instead of 2198. But look at the way it goes. So he says that you are entitled only to 14 June. 14 June is para E,
Vacating, yes.
2198.
Correct.
He doesn't include that and includes the earlier amount of 560. Now the same contract is not breached on 2 days and damages can't be computed on 2 days. Having held that the date is 14 June, he goes back to 28th April, awards 5 crores 60 on that date, does not award the claim on 14 June. So if he is right, this claim, even if awarded, should be for items B, C, and E added on. So it would be 18 lakhs, 29 lakhs, and 21 lakhs. Where is this 560 coming from? Once you have held that the relevant date is only 14 June. That's what, so it's a complete mishmash. Maybe, my lord, that might be time, difficulty, whatever it is, but it's an unintelligible award on this point. I'll now read it to your lordship. I just wanted to explain what has happened. Because when I read it, it couldn't make sense. That's the way it is. So, my lord, let's just go through it a little slower. And because that's the fundamental point, that the award is disclosing errors apparent in its own internal, it's inconsistent. He awards 14 June, which is 21.98, after a long discussion, and then forgets that award and awards 28th April. That's what has happened. Now, my lord, yes. So we start from page 787. In order to decide issue number 3, para 33, it will be profitable to quote once again the second consent order. Oh, sorry, my lord, this is not. This is that second point. My apologies. Sometimes a lot. Where does it start from?
790.
No, but later, my lord. 1 second, I'll just see. Yes, para 47, page 810.
Correct.
The above bank guarantee is continuing and is required to be continued to the passing of the award. Now that the tribunal proposes to hold that it is the claimant who has violated the second consent order, the above bank guarantee given by the claimant has become enforceable in terms of the order of April 20th only after giving 14 days notice. This tribunal therefore now proceeds to calculate the amount of loss suffered by the seller. Now this is, he then in 48, he gives various dates at which the amounts are various amounts. I'm not into that. Then, my lord, para 50, he quotes the statement of defense fully on the claim made. It goes on right up till page 813 bottom. Then in para 51, he says this. This tribunal has also pointed out that the learned advocate for the parties made the following submission as recorded in the third sitting of the tribunal, that no evidence is required. That's all right. Then we can go straight to after that. This is rather peculiar. It may be mentioned here that counsel for the respondents had submitted that on instructions from the client, he was not pressing the counterclaim described in 47E. 47E is the difference as on 14 June of 21.98 lakhs. Read with paragraphs 44 and 45 the statement of defense as reflected in paragraph 2 of the minutes. The tribunal, in the opinion of the tribunal, the above concession of counsel should be ignored because the respondent in this proceeding has filed 2 statements of defense, one affirmed on 14 July and the other on 16 July, and prayed for accepting the latter one as the real SOD. Ignoring the earlier one is a repeal from recording in the minutes. Now go over the page, my lord. And in para 53, in the second SOD, which is the final one and accepted by this tribunal, there is no prayer in paragraph 47E. Now this is an error apparent because the second one had 47E, the first one didn't. But nothing turns on that, my lord. It would be a clerical response. But what happened, my lord, was the first one only had the 560 and ABCD. Yes. Then they amended to add E, which is 21.98.
Subsequent.
And the arbitrators mixed up the first and the second. But I'm not making an issue of something like that. Then look at 54. After taking into consideration the materials on record showing the admitted rate of the goods in question as would appear from the uncontroverted documents marked so and so, and the consent order of the court, which is marked as Exhibit FF, the respondent has been able to successfully establish the following facts. The market price of the goods in question on April 25th, 2022 was rupees 52,033, and the respondent is entitled to get damages for being unable to sell the goods at such price due to the order of injunction passed against it on the representation of the claimant that would purchase the goods at the contractual rate of 46,000. The contract price of the goods being 46,433, and the fact that the respondent could have sold the said goods even at the rate of 52,033, it was therefore entitled to the difference being rupees 5,600. Consequently, it could receive an additional amount of 5 crore 60 lakhs between the difference in the price of goods and the total subject matter of the aforesaid contract. Then C and D, my lord, are minor claims of handling charges. We are not, no dispute there. Can go overleaf. E, as would appear from the documents marked as JJ to the SOD, the market price of the goods on 14 June was rupees 45,780. The respondent is accordingly entitled to the difference between the market price of the goods on 14 June and the contract price being the sum of 21,98,000.
Yes.
So here he puts both. In AB he puts 560 and in E he puts 21,98,000. Then, my lord, look what happened. Paragraph 55. Counsel appearing on behalf of the claimant strenuously urged that even if it is assumed for the sake of argument that the termination of the contract by the claimant was illegal, in that event the respondent will be entitled to no damages because the market price was at all throughout higher than the contract price, and as such no loss was incurred by the respondent. While making the above submissions, counsel treated the date of breach as the date when the goods were to be delivered, but not delivered by the respondent, 21st April, under the original contract. In support of such contention, counsel cited 62 Supreme Court, which says, my lord, on a date sale of goods, the date of breach is the relevant date for the market prices to be looked at. Now go to page 821, where the judgment finishes. Then para 56. Similarly, the provisions contained in section 57 of the Sale of Goods Act are as under damages for non-delivery. 57. There is no quarrel with the above proposition laid down by the Supreme Court that ordinarily the above principle is applicable. But every case has some distinguishing features when the general proposition of law cannot be applied. In the present proceeding, in the opinion of the tribunal, the following conduct of the claimant would stand in the way of the claimant to avail of the benefit of the general law as suggested by counsel. The tribunal has already held in para 26 that the effect of the two orders before the Honorable High Court is that the seller, by accepting the advance price over again and the purchaser by tendering the advance price, which is earlier returned to it, agreed to extend the period of performance with further condition that in the process the value of good falls. At the same time, seller succeeds in the long run, purchaser would be bound to compensate the seller for the loss suffered by the seller due to fall of price in the market because of the fact that by injunction order, seller was restrained from selling the goods to a third party. Thus, the fact that the added amount in the security clause were added would not amount to itself superseding the contract, as those relate to payment under the contract, and put the promisee in the same position as the contract had been originally performed. The tribunal further finds that the original agreement was not superseded, but was only sought to be enforced, the manner of performance being different, and consequently 63 is available. Therefore, by virtue of 63 of the Contract Act, February 21st, 2022, the original date of delivery has ceased to be the date of the delivery, and mark these, and the date of delivery has been extended to 13 June, till which the respondent has been restrained from selling the goods. In the proceeding, it was the buyer who filed a suit for specific performance and was enjoying the order of injunction. And on appeal, the Honorable High Court maintained the injunction till 13 June, and at the same time, the High Court imposed additional conditions. Then, my lord, after the para, go to the last one. In the opinion of this tribunal, the claimant being fully conscious that on consent of parties, the respondent was restrained from disposing of the goods till 13 June, it could not before that date terminate the contract when the price of goods were falling in the market from the contract price and abandon its prayer for specific performance. Then, my lord, there's a judgment in 79 Calcutta quoted by 2 pages. And if your lordships go straight to page 826, which is the crucial para 58. Lordship has that now?
Yes.
I'll read that because this really is the applying the above principles to the facts of the present case. This tribunal holds that the respondent should get the difference of contract price and price of goods in market on the date next to vacating interim order of the High Court dated 14 June 2022 as the loss suffered from the breach committed by the claimant. In fact, as would appear from the 2 consent orders passed by the High Court, the division bench for the above reason demanded an undertaking, etc. Now, my lord, we just go back to 54, para 54. This difference on 13 June is claim E at page 817. Kindly look at page 817, capital E. The difference on 14 June is 21,98,000.
Yes.
In A and B, the difference on 28th April is 5 crore 60 lakhs.
No, E, it will appear from the document.
Yes. It would appear from the documents
Market
marked as
price.
JJ that the price of the goods on 14 June was 45780. The respondent is accordingly entitled to the difference between market price of the goods on 14 June and the contract price being 21,98,700.
Okay.
That is clause E. Now, earlier in the earlier page, clause A and B were price of goods on 25th April, in which comes to 5 crore 60 lakhs.
That is A and B.
Yes. Now, look at what he does. In the last para, he says you must go by 14 June in para 58.
Correct.
Then look at how he awards. He does not award that clause of 2198 at all, and instead brings in 5 crore 60.
Accordingly, the tribunal reject the claim of the claimants. However,
However, the tribunal at the same time allows and assesses the amount of compensation as follows. 5 crore 60 is on 25th April. There's no reference to 2198.
No. 59.
Yes, my lord.
The tribunal
Rejects the claim of the claimant. That's our claim.
Yes.
Accordingly, however, it will be entitled to adjustment of 449 or advance paid. The tribunal at the same time allows the counterclaim of the respondent and assesses the amount of compensation payable to the respondent by the claimant as under. In 58, he has said you must go by 14 June, which is 2198. That's not there only here.
Yes.
And instead, he brings in A, which is 25th April. So, my lord, this is an absurd situation. The whole judgment records that you are entitled to damages as on 14 June. That amount is 2198 by clause E on page 817. He does, after holding that is the liability, he doesn't include it in the award and instead includes A and B, which is for 25th April. This is just complete error apparent. Unless he wants to correct the award, because this is unintelligible. Para 58 says that I take the date of breach as 14 June.
Correct.
On 14 June, the damages payable would be 2198 as per clause DE on page 817. He doesn't include that in the final award. And instead, he includes an earlier claim of A and B at 560. For which would mean there are 2 dates of breach. 25th April and 14 June, which in law is impossible. So this award is unintelligible. In fact, there seems to be an error. He should have deleted A and instead written 2198.
2198 700.
Yes, that should have been at A. Instead of which he excludes that and puts in 5 crore 60 lakhs.
So, but that has been left.
Nowhere mentioned, though he concludes that is the award which should be made. In para 58, he says the relevant date is the date of 14 June and damages must be assessed on that date. After long discussion, and then suddenly A and B comes in. This is unintelligible.
In view of the above, the appellants are entitled to relief purely on equitable ground without going into any other legal issue. Appeal deserves to be allowed.
There's an error there. Either it's a typo and he's missed out the wrong one and he's put in the right one and put in the wrong one. But there's an error apparent here. Because all the paras from 55 to 58 come to a decision in 58 that the relevant price for damages is 14 June. Lordship has seen that, Malord, in 58. And 14 June in 817 is paragraph E. So he should have awarded this. It says, and there is no reasoning at all as to how 560 comes in and 2198 goes out. This is it could be maybe a typographical situation or some error, but this award is completely wrong.
So you have not filed the review?
No. In a 34, you can't go review in that sense.
No.
It will be sent back under
33.
34, yes, 34C. But otherwise, my lord, this is impossible. And look at the effect. If instead of 560, 2198 is added, the three together would work out to about 70 lakhs, against which I have to get 4.49 crores. So I would be the recipient of money instead of my paying the money.
That's the adjustment. That's the adjustment.
No. But if 2198 was there, I would be in credit.
You will get.
Yes, because he has added 5 crore 60, I am a paying party. So this award is completely wrong. But I don't mind if your lordship thinks it's a matter where he should correct the award. But it should not be going into the merits again. It has to only reflect the finding. That's all.
Fine.
But yeah, because para 58 is a categorical finding. After all that discussion, right from para 55 onwards, saying the date has to be extended to 14 June because of the injunction, then he comes to this conclusion.
Because actually the arbitrator is going to the 14 June.
Yes.
After the 13 June.
Yeah,
Taken the date of that.
And he says, in fact,
considered
para 58 is important, my lord. It says again, I hold that the respondent should get the difference of the contract price and the price of goods in market on the date next to vacating order 14 June as loss suffered from the breach committed. That is page 817, para E. So having held this, how could he discard that and bring in 560? There's nothing in it. But I'm certain that there must be some error in transcribing or dictating or something, because this is unintelligible. Para 58 and 59 can't stand together. Because having held in 58 that this is what I award, you don't include it in 59 and you include what is not awarded.
Yes.
So that is the argument, my lord. According to me, both 2, my lord, might be a little subjective in analysis of whether there is breach or not. But 1 and 3, that you did not decide what you had to and you decided wrongly. And the second point, that even if you decided wrongly, this award is ex facie and demonstrably erroneous. That is
what is their answer?
Yes, that is our case, my lord. Greatly obliged.
Thank you.
Well, if your lordship feels it would be of assistance, we could put in a note. But if
let me hear the other side. After hearing conclusion of the hearing, then I will.
Yes, of course, certainly. Greatly obliged, my lord.
Thank you. Hey, and last date. So appearing for the petitioner, so appearing for the respondent. Counsel for the petitioner has concluded the argument in connection with APCOM 32 of 2020.
I might not be pleased, but I'll tune in.
Let the matter appear.
His convenience.
Only one. AP 32. Yeah. There are two AP.
No, one appeal, my lord. There is also
Second one is the section 9.
Section 9, my lord. Section.
Once you are hearing the main matter, all these other points
automatically it will.
Yes, absolutely.
In connection with APCOM 32 of 2024. police. Yes, कब देगा date?
My lord, whichever date, my lord, suitable for your lordship.
Of September 23rd and 24th September. पहले नहीं है? पहले नहीं है.
ठीक है जी.
23rd, 24th September.
My lord,
At
I have no problems. My lord, only thing is, my lord, from 3 o'clock, my lord, I have, my lord, another fixed
12
matter.
12 o'clock. 12 o'clock.
It's a shorter date possible, my lord, to your lordship. my
I have
lord.
no problems, my lord. Whichever date comments to your lordship.
That's my diary.
Very good. So whatever your lordship finds convenient.
23, 24th of September at 12 noon.
I can do it at 2 o'clock. There's no problem.
No, no, 12 noon. 12 noon.
12 noon. Very well. Only thing
Both
is,
the days 12 noon.
12.
No problem.
No problem.
Pleasure.
My lord, in this matter, my lord, my witness was in the list with regard to when the box, my lord, with regard to an probate application, my lord. Mr. Jishnu Chaudhary was cross-examining. My lord, today, due to this political agitation, he cannot come. My lord, any 2 days your lordship fix in September, according to your lordship convenience. Because he was cross-examining for a long time, he'll finish within 2 days, 2 consecutive days.
2 days.
In 2 consecutive days, your lordship keep it
Not
only.
consecutive
My
days, my lord, 2 days your lordship may fix.
2 days, whatever consecutive to be there.
Consecutive, my lord,
Any-
after the, my lord, we will not get.
Because vacation is coming, I want I pray only before lordship. I can't pray nothing.
Before vacation.
Vacation is coming from October, so
Vacation.
no, my lord, sir. 2
Come
days.
after Puja
2 days. Let him finish the cross examination, my lord. Because your lordship is hearing it with after puja, whether your jurisdiction will remain or not, we don't know. So I want to
Other
finish.
judge will be there.
No, I want to finish it off, my lord, before you at least the cross.
Evidence.
2 days cross examination will complete.
He is assigned, my lord.
Assigned before lord.
Assigned matter.
Assigned matter.
Then
Assigned matter.
Yeah.
Oh, assigned matter. Then it's 2 days. Then his cross examination will be completed.
yes. कब होगा?
September में 2 दिन
नहीं है.
नहीं. Date नहीं.
Very problem. Date is congested. There is congested.
23rd, 24th.
कब होगा?
Wait.
नहीं होगा. Non-commerce 26, 26. So and so appearing for the plaintiff, so and so appearing for the defendant. Defendant's witness, plaintiff witness.
My lord.
Plaintiff witness.
Plaintiff's witness.
For further cross.
Further cross.
For further cross.
2 days fixed for further cross-examination of the plaintiff witness number 1. But due to some unavoidable circumstances, the witness could not able to appear before this court. Accordingly, counsel for the plaintiff prays for time. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 25th and 26th of September 2024 at 12 noon.
25th, 26th.
At 12 noon. For witness exit. Next.
Wait a minute.
25.
I am for the plaintiff, my lord.
Yes.
My lord, our counsel is not available today.
Not
I
today.
pray for not today.
Not today. Next.
26, my lord. Behalf of the
Right.
respondent, my lord.
I do appear for the plaintiff, my lord.
Yes.
Last day I was addressing, my lord, in a suit for eviction, my lord. They have filed again, my lord, a chapter 13A application. And there was an order passed by the trial court that the maintainability is kept open. So on that score, my lord, lordship said you address. And my lord, I started addressing the court. May I, my lord, continue, my lord?
Let Mr. Dev complete today, my lord. I will make my submission, my lord, tomorrow or day after, any day, my lord fixes, my lord. I will take a note.
It's required to give reply.
Certainly, Master.
Mine says everything. All matters.
If he is unable to convince my lord, then I am not required to give any reply.
All matters. Chapter 13A is heard and decreed. Then what will the trial court will do? Now, my lord, on the last day.
Now the law will change. All the suit will be decided either 7-11 or 13.
Yes. Nothing remains for trial.
Nothing remains for the trial.
Nothing remains
No
for trial.
suit court is required.
No. That's right. Lordship is absolutely correct, my lord.
So we'll propose from the High Court, the Calcutta High Court side. So this amendment is required for the Calcutta High Court.
Absolutely. Either on the first day suit goes, plaintiff nipped in the bud, or decree on chapter 13A. Nothing remains.
They will come. They might come. But this is a fit case, my lord, whether decrees should be passed under chapter 13.
That's true.
I will show you. Lord.
Absolutely. Now, my lord, this is, my lord, a suit filed on the basis of a notice on the last day, my lord, I argued, given under section 106 of Transfer of Property Act. 25 years lease.
Yes.
According to the plaintiff, after the expiry of the lease period, defendant was not permitted to remain in possession. A notice was given and said, you are liable to be evicted, you vacate. And since, according to the plaintiff, I was in possession, they also, apart from claiming the decree,
yes,
claim for mean profit because my possession was wrongful according to them. My contention before your lordship on the last day was, and today also it will be, that during the existence of the lease tenure, they have accepted rent, and therefore, on the basis of their conduct, which amounts to acquiescence, they have given up their right, my lord, to proceed against me, so far as the present suit is concerned.
So 106 will not apply.
Absolutely. And alternative point is, I am a tenant by holding over. Why I say this?
Unless decree.
Because of section 116 of the Transfer of Property Act.
Unless decree, you cannot be declared as illegal occupant.
Absolutely. Now, my lord, kindly comes to, my lord, page 76, the order. Page 76, my lord, is the order passed by Justice Kapoor on 13 December 2021.
Yes.
On an interlocutory application filed by them, kindly turns over to page 17 and the last paragraph.
Page?
Page 77 of their application and the last paragraph. Mr. So-and-so raises a point of maintainability of the suit, but submits that he would take this point at the time of final hearing of the suit. Now, lordship is hearing chapter 13A. So obviously, this is the stage where I would take the point that the suit is maintainable or not. And when the point of maintainability is raised, my second submission would be, when there are serious questions of facts are involved, whether ignoring this fact, court can pass a decree under chapter 13A or not. Whether, even assuming they have a point to argue that suit is maintainable, whether a trial is required, or at this stage, ignoring this, court will come to a final finding that decree will be passed on chapter 13. 3 documents, my lord, I would show to your lordship. First, my lord, I had shown to your lordship on the last day the notices. Kindly, my lord, comes to page, my lord, 57.
57? That is a notice.
Notice. If lordship recollects, then I would not trouble. This is the first notice. Then, my lord,
referred the 57, 60
yes,
your reply.
60 is my reply.
Second notice is 69.
Yes.
Second notice is 69.
So, and another document clarifying about the acceptance of the rent. Kindly come to page 61 once. Lordship, my lord, recollects everything, but page 61 is my reply to their first notice. Last paragraph.
Yes.
It is also to be mentioned in 1965, the monthly rent was rupees 251 only and rupees 1400 as per the new agreement dated 1995. That agreement they have annexed 25 years. As for the clause of new agreement, I was supposed to pay rent by enhancing 10%.
Where from your reading?
Last paragraph, page 61, running page 61.
Yes, yes.
Lordship has got it, my lord. Last paragraph. I'm not troubling you with the entire reply because Lordship has taken note of it on the last day.
Yes.
It is also to be mentioned in 1965, the monthly rent was rupees 251 only and rupees 1400 as per the new agreement dated so-and-so. As per the clause of new agreement, I was supposed to pay rent by enhancing 10%, but as nobody from your side demanded the increased amount 10%, so as usual, we paid rate at the old rate and from your side, it was accepted and receipts were granted up to June 2020. That, as per the usual practice, we sent you rent from July 20 to December 20. Kindly take note of this. So they have accepted the rent. And that would be evident from, my lord, my affidavit in opposition. Kindly takes up, my lord, my affidavit in opposition once. Opposition. Affidavit in opposition, my lord, page 17. The bank statement. I paid by check. Page 17, Lordship has got it.
Yes.
28/2020. This is a bank statement. I have made other statements also. I run my business there. 28/2020. Inward clearance 11,180.
Yes.
Sri, only the word Sri Lordship would find. That is, my lord, to the plaintiff.
Sri.
Yes, that part is missing. And then, my lord, page 18. Since it was not fully legible, this bank statement was obtained.
Yes.
And there, my lord, this fact has been recorded.
Yes.
This is to certify that check number so-and-so, the same check Lordship would find, it tallies.
Yes.
Dated same date, amount Lordship would find, then the total quantum also, Sri Lakshmi Thakurani. So this is the position. Now, one fact I must tell your Lordship, I have already filed a written statement. I will show to your Lordship about the averments made in the written statement also. Now, what is their stand? Page 70, the last note document I have shown to your Lordship, page 70, 69 and 70. This is after receiving the payment of the money. They have, my lord, notice was given. Page 70, if Lordship comes, the last line. Last two paragraphs also, Lordship can consider, my lord.
Page 70.
Page 70, 69, the notice starts. There are two notices. First notice I replied, then this is the second notice. In between that, there was one letter also I will show. Page 70. What they have said, be it mentioned here in such event, on and from the expiry of the 15 days, my aforesaid client shall claim damages, mean profit, per diem, and other damages till physical and khas possession of the said flat is made over and recovered by my client. It has come to my notice that you have made substantial addition or alteration in the said flat, thereby damaging the said flat. Then, my lord, kindly see, please treat this as a notice under section 106 of the Transfer of Property Act.
Now, this amount was paid up till June 2020.
Payment made, my lord, up to
June 2020.
From July to December. Page 61.
That as per the usual practice, we send the rent from July to 20.
Yes, 6 months rent.
6
we have paid.
So the
Now-
agreement was over on?
Yes. Now
31st
kindly
Oc-
comes to my lord,
No,
the agreement.
The agreement ends on 31st of October
Yes.
2020.
Yes.
And
Agreement they have annexed at page 27.
Correct. And they issued the notice on
They have issued the notice, first notice.
September 2020.
Yes.
September 2020. Therefore, requested, let me know the time as to when you would be hand over the vacant position.
Before the expiry.
Before expiry.
Page 42, last two lines, Lordship would find when the agreement will expire, my lord. Page 42, last 3 lines. Lordship was absolutely correct, my lord. 31st October 2020. So the first notice which was issued before the expiry.
Intimating you to
Yes, vacate. That was my reply. And from the document I have shown to your Lordship that I have paid rent till December. After the period, after the expiry of the period.
In the second notice, that is second notice of
Second notice,
1911.
yes.
63.
Yes. In between that,
No,
there is
it's a 63, 90, that is 63, 1911. What is the reply to your that?
They have given reply to my my reply.
No, with
That is
regard
page
to
63.
What is the explanation of the rent?
Yes, yes. I'm in receipt of your letter dated 14th October 2020 and noted the contents thereof. At the very outset, I state that in view of the good relationship shared between us, you have been allowed to use and occupy the third floor of the municipal premises, 117 BK Pal Avenue, for the period of 25 years in pursuance to the terms of and conditions contained in the deed of lease dated 15th December 1995. You were aware of the fact that the period of 25 years has expired on 31st October 2020, and thus you are under a legal duty and obligation to vacate and hand over the physical possession of the said flat to me on or before 31st October 2020. In this context, I have already written a letter to you on, Lordship has got it, Madam?
Yes, yes.
On 3rd September 2020 to let me know the date and time as to when you would hand over vacant physical possession of the said flat to me. You have not informed me anything about this in this regard. My letter is there. Even then say you have not informed.
That's why.
Yes, as regards, absolutely. As regards to the allegations made by you in the letter under reference are concerned, the same are absolutely and wholly false, incorrect, and without any basis. 7, except the rent for the month of July 2020, no further rent was paid by you. Now they try to give an explanation about adjustment.
So,
First,
and this is, and the rent which you're showing, that is a page number?
Page 60, Malad, 1.
No.
Oh, opposition.
Opposition, page 17.
Page 17, 2 pages. First the bank statement, then the bank manager's.
Bank statement and bank manager.
17 and 18.
That is August.
Yes.
That is August. It was August 2020.
6 months. The entry, Malad, the payment was 17th August. Yes.
20 August.
Yes.
20 August. 11,180.
Yes.
Correct.
6 months rent.
So this is 6 months rent.
Yes.
So where is the document you are alleging that the amount was paid from July to December?
That document is
because in the reply,
yes,
they have categorically denied that except the July they have not received that any amount. In the reply,
No.
in the not reply, second notice.
They have not denied about receiving the money.
Yes, kindly come to the
page 64.
63. 63, last paragraph. As regard the allegation made by you in the letter reference or content, the same are absolutely and only false, incorrect, without any basis, save and accept the rent for the month of July 2020, no further rent. Because
page 64. Page 64, second paragraph. They have accepted that, but given an explanation. After long dilly-dallying in the month of August 2020, you made payment of pending differential amount of lease rent. This is the new story they have raised. They did not dispute about receiving the money. They said it's a differential amount that you have paid. From the month of November 2015 to November 2019, last check of 11,180, which was given to by you towards the rent for the month of July 2020 and for payment of the aforesaid pending differential amount of enhancement of lease rent for the month of November 2015 to 2019, which was not paid by you in terms of the lease deed dated so-and-so particulars. This is the explanation they have given. Prior to that,
No, that's correct. See, this 11,180.
No dispute about receiving it.
No dispute, and that is August.
Up to December, according to us. 6 months rent.
That's why. No, that is August.
Yes, paid in August.
You paid in August.
Yes, but the month till December.
Correct.
Till December. 6
You are
months
telling
rent.
that 6 months rent.
Correct. Now, what they are saying, for the first time, they have taken this stand, not disputing the fact that they have received it. But they said the payment which you have made in August 2020,
that is a
differential amount.
That is arrears.
Absolutely. Now, on the face of it, if that be so, going by the lease deed, that should have been a ground for eviction in the first notice. If I'm a defaulter of rent for 5 years,
You're not asked for.
you are not asking for it. You didn't say anything. The moment I paid, you accepted, you said for 4 years. When? as a reply to my notice. See the first notice?
Only simple that he is intention that no extension.
Absolutely. Page 57 is the first notice. You could have said this. You could have said this as a ground for eviction. Good, bad, indifferent.
And 14, that last security deposit of 1400 given by you.
That's a different thing.
At the time of grant of censorship
Yes,
will be
yes.
adjusted.
Security deposit will be adjusted. And the last notice also. And the last notice also. Page 69. Notice for eviction. This was not said. You were deciding this point on the basis of documentary evidence prima facie, whether I have a defense or not.
Yes.
Page 69 also, they don't whisper. They don't say anything about this.
69?
If you see the notice, page 69, last notice. Notice under section 106. Kindly see. Your possession is wrongful. Nothing has been said or had been said about adjustment of the differential rent. It's frivolous on the face of it.
Yes. Yes.
Yes. Now, my lord, kindly turns to the lease agreement once. This is the basis, my lord, on which they proceed. Page, my lord, 40, running page 40. Page, my lord, 43 is the first clause about payment. The mode of payment and the quantum that has been stated. Page 43, clause 1. I am the lessee.
Yeah.
If I am in default or I am a defaulter, then what will you do? Will you wait for the tenure to expire and then to issue a notice, or before that?
Yes.
Now, my lord, kindly, my lord, comes to my written statement once before I cite few authorities. Facts are only, my lord, this. Page 23 of my opposition.
Statement.
I have filed already.
Not chapter 13.
Already filed, only then. Without prejudice, my lord, I filed it. My lord, in chapter 13A, with greatest of respect, my lord, one is before and the other one is after. 10 days, my lord, in the other matter, Harrow, 10 days when you file and give notice, point of limitation. Otherwise, also you can, provided there is no defense at all. If slightest,
Then
has to go to trial.
there are three conditions.
Absolutely, absolutely. I will cite that. Page 24.
Page 24.
A written statement, my lord, starts.
Acha, you are enclosed.
Yes, my lord, I have enclosed, my lord.
Of your affidavit?
Of my affidavit in opposition.
Yes.
My lord, first paragraph, the suit is not maintainable either in fact or in law and thus is liable to be dismissed with costs. Then I say the plaintiff has no cause of action. Plaintiff has no cause of action. Kindly, my lord, do not consider this. Straightway comes to the material averment, my lord, made in paragraph 12. Not paragraph 12, paragraph 11 onwards. Paragraph 10 onwards. These three paragraphs, 10, 11, 12, very important, my lord. paragraph 10, my lord.
Yes.
May I, my lord, place it? With reference to paragraphs 4 to 6 of the plain, save what matters of record and save what appears therefrom, each and every allegation contained therein is denied and disputed. It is contended that even after the expiry of the lease period, the plaintiff has accepted rent from the defendants, and thereby the defendants have become monthly tenant under the plaintiff under West Bengal Premises Tenancy Act 1997. The conduct of the plaintiff by accepting monthly rent from the defendant justifies such fact. Alternatively,
Order 7 Rule 11.
no, I have not filed. I have not filed, brother.
Yes.
Alternatively, the defendants state by virtue of acceptance of the rent at a regular basis, even after the expiry of the lease period, has put the defendant in the status of tenant by holding over. It's my specific pleading. The defendants have no knowledge about the partition suit. They have referred to a partition suit. I have said I have no knowledge, filed in the Learned Civil Court. The quantum of the monthly lease rental, as mentioned by the plaintiff, is disputed. The last rental by the defendant has paid and duly accepted by the plaintiff is 1863.40. 7 accept have been denied and disputed. Then next paragraph. With reference to paragraph 7 to 11 of the plain, save what matters of record and save what appears therefrom, each and every allegation contained therein is denied and disputed. It is denied and disputed that the last lease rental was paid by the defendants in July 2020 as alleged. They have taken this point. I have categorically denied. The contention of the letter dated 3rd September 2020 are denied and disputed as the same is incorrect. The defendants have duly replied the said letter of the plaintiff dated 3rd September 2020 by a letter dated 14th October 2020. The contents of the letter dated 14th October 2020 are all true and correct. That's my letter. And the defendants treat the same as part of the written statement. By the said letter, the defendants have informed the plaintiff about paying rent till December 2020. A copy of the said letter is annexed here to and marked where the letter be. The contents of the plaintiff's letter dated 19 November 2020 are incorrect and the same are denied and disputed by the said defendants. It is contended that though the lease period has expired on 31st October 1990, but even after the expiry of the lease period, the plaintiff has accepted the rent from the defendants, and the such facts would be evident from the bank statement. The rent has been paid through the bank, and from the bank statement itself, such facts can be easily demonstrated. It is denied and disputed that after expiration of the period of 25 years provided in the deed lease dated so-and-so, the defendants on and from 1st November 2020 have no right or authority to occupy the suit property, or the plaintiffs never accepted any money on account of lease rent or otherwise from the defendant in respect of the suit property as alleged or all. 7 except, that part lordship can ignore. Paragraph 12. With reference to paragraphs 12 to 15 of the plain, save what matters of record and save what appears therefrom, each and every allegation contained therein is denied and disputed. These defendants state that a notice dated 23rd November 2020 is non-est, and on the basis of such frivolous notice, the instant suit could not have been instituted, and the same is not maintainable, and no decree can be passed. So my specific stand I have taken in the written statement about the maintainability of the suit, about about accepting me even after the expiry of the period, and I'm a tenant by holding over. I would submit, my first submission would be, these are the facts, my lord, that on the face of it, the notice itself is bad. Therefore, my lord, the court has power to dismiss. Alternatively,
yes,
if the court finds that these facts are disputed and it needs to be proved because I have said something by giving a document, they have said something. Though in the notice they have, on the face of it, it appears they have not said anything about this differential amount. It came up only as an afterthought after, my lord, I gave the reply on the face of it. This, my lord, certainly, my lord, needs to go to trial. Without that, on the face of it today, these factual aspects cannot be gone in. These are the facts. I will cite, my lord, you judge. Kindly, my lord, takes, my lord, the first judgment, which I rely on.
Which one?
2017. Volume 1, Supreme Court Cases, 568. Kindly, my lord, takes this copy, my lord. I hope this paragraph 13 and 18 will not here. This will not happen. Though it was entirely my mistake.
Oh, hopped on.
Paragraph 17. Page 596.
Paragraph 17.
Paragraph 17. Previously, it was first 49 Calcutta, probably Lordship knows it certainly.
So that has been.
Yes, that is then Mechanic.
Kiranmoy.
Mechanic superseded, now this uptown.
Yes.
That's simple as that. So I'm not placing this 49 Calcutta because this has been followed, only the Mechanic has been superseded. And I would submit may I find it out for your Lordship.
Not complete, I think. So.
Incomplete one again. পুরো নয় আস্তে আস্তে দাও দেখি sorry my lord. Yes, this one is complete. Sorry my lord. Paragraph 17. My understanding, my lord, after going through the two judgments subject to what falls from the court, this gives more protection to the tenant. This is my understanding.
So this is a settled law.
Absolutely.
Now the court has to decide whether this is a tribal issue, whether you have any defense to defend the suit so that the suit can go for the trial.
Absolutely. Any or nothing. That's the point.
And there are three conditions. If court find if it is defendable without any conditions.
Without any unconditional leave to
That's right,
defend.
unconditional leave to defend. Or if it found there is something.
Yes.
Then conditional can be given.
Absolutely.
Or if it is found it is sham.
Absolutely nothing. Sham.
It is sham. Then
Absolutely. Only then and nothing.
Three things.
These three things.
And that is to be decided
So,
on the
basis of the documents. And my submission would be, my lord, this case, my lord, at least, my lord, does not, my lord, call for a decree under chapter 13A. It only says 17.5 when has no substantial defense or raises no tribal issues, or the court finds such defense to be frivolous. So that is not the case. Certainly not, my lord. This is one judgment, my lord. Next one, my lord. 2015 volume 10 Supreme Court cases 521, paragraph 15 to 24. This is a summary suit, my lord, order 37 rule 3, but the principle, my lord, has been enunciated, and that, my lord, has got some bearing, my lord, so far as passing a decree under chapter 13A.
Paragraph?
My lord, I am placing, my lord, paragraph 15 onwards. Paragraph, my lord, 15 onwards. As regards the entitlement of a defendant to grant the leave of defend, the law is well settled long back in 49 Calcutta, my lord. I have, my lord, but I am not placing because that has been followed and considered in 2017. Then, my lord, principle has been enunciated, my lord. Kindly, my lord, comes to paragraph 16. It is also noticed that the law as enunciated above has been followed by the courts in several cases. Some of the cases have been referred to. Then, 17. An analysis of the above principle makes it clear that in cases where the defendant has raised a tribal issue or a reasonable defense, the defendant is entitled to unconditional leave to defend. Leave is granted to defendant even in cases where the defendant, upon disclosing a fact, though lacks the defense, but makes a positive impression that at the trial, the defense would be established to the plaintiff's claim. Only in the cases where the defense setup is illusory or sham or practically moonshine is the plaintiff entitled to leave and sign. It's a triable, if I can show, then it has to go to trial. Then, my lord, my next is, I will give you the copies, my lord, because today I did not anticipate because it will be taken up on acquiescence. Because you have accepted rent, and after accepting the rent, it doesn't lie in your mouth to say that you should go. It's like approbate and reprobate. Accepting the rent from me on the one hand and saying on the other hand, you vacate. No, it's not done. You have acquised your right. My lord, 2015, volume 15, Supreme Court cases, page 1. And this has been followed, my lord, this has been followed in a subsequent decision also, 2022, volume 2, Supreme Court cases, 301.
2022?
2022, volume 2, Supreme Court cases, page 301.
Paragraph number.
You search it.
Yes, my lord, I will place, my lord, and my lord, paragraph 39.
Of 15 judgment.
No, my lord, 2022. 2022, volume 2.
Paragraph 15.
Paragraph 39.
39.
I am placing then, my lord, I will hand over and subsequently I will give a copy to your lordship in the compilation. Before proceeding further, it is important to clarify the distinction between acquiescence and delay and laches. Doctrine of acquiescence is an equitable doctrine which applies when a party having a right stands by and sees another dealing in a manner inconsistent with that right while the act is in progress and after violation is completed, which conduct reflects his assent or accord. He cannot afterwards complain. In literal sense, the term acquiescence means silent assent, tacit consent, concurrence, or acceptance, which denotes conduct that is evidence of an intention of a party to abandon an equitable right and also to denote conduct from which another party will be justified in interfering such an intention. Acquiescence can either be direct with full knowledge and express approbation or indirect, where a person having the right to set aside the action stands by and sees another dealing in a matter inconsistent with the right and in spite of infringement takes no action, mirroring acceptance. However, acquiescence will not apply if lapses of time is of no importance and consequence. Kindly have a look at this, my lord. This, my lord, expression clearly applies, my lord, here. 2015 paragraph.
If suppose, though he has not taken
Yes.
the plea, if he has not taken the plea, if it is said that no, it is not errand, it is a occupational charges, what would be that?
It's occupational charges.
If it is, though he has not taken.
He has not said. He has not said in the hypothetically.
Hypothetically.
Straightway it goes to trial.
So
Straightway it goes to trial.
If it is an occupational charge.
That's right. So I am saying it's a rent. You accept it. I am producing a document before a court of law, certified by a bank's endorsement. You are saying, no, no, no. It's an occupational charges. So obviously it's document versus document.
Because that document, because but now he can, because he has taken the other defense.
Yes, they have not. He has not said that.
Academic.
He has not. He said simply you go. Now, if he says that, then obviously it's document versus document, one document versus another document. Certain factual aspects are to be gone into. What is more important, why a trial is conducted, full-fledged trial, in order to substantiate a pleading, what has been averred by a party.
That is the time.
Everything cannot be said, my lord, in the plaint. Logic is drawn by a lawyer, settled by a lawyer. So legal things have also been stated. Now, what you have said in simple language, certain things are to be proved by calling or sending a witness, by asking him to go to box.
That's why when I was that side,
yes,
I used to tell the client in the civil cases, see, with regard to the pleading, written statement, filing documents, filing the examination in chief, that is up to the lawyer.
Absolutely, order.
Giving the evidence is on your shoulder. If you want
absolutely
to took your case.
Absolutely. Either to that side or
to come down.
Absolutely. It's about the witness to prove. Witness
is a witness.
So,
If
honestly,
you say anything against you, one answer will go the total.
Absolutely, absolutely. If you cannot prove your case, obviously, going by the Evidence Act, section 101 to 107, Lordship knows this. If somebody alleges, if somebody says something, It's on him to prove. Something negative you can't, but you have to prove your own case. And how? By asking the witness to go to box. That's why trial. When there is a doubt with regard to the interpretation, and more so when there is doubt with regard to certain factual aspects of the matter, certainly, my lord, trial is must. Otherwise, my lord, there will be no need to go to trial. All will be decided on affidavit, order 14, rule 2, preliminary issue. That can't be done. That, my lord, not possible also. Then, my lord, this judgment, lordship kindly says, I am on acquiescence. Then, my lord, 39 and 40. 40 and 41, 2015 has been referred to. Lordship would find in paragraph 39.
Yes. Paragraph?
Paragraph 30.
No, you are.
This one I will show you to 40 and 41.
Yes.
But I'm placing, then I will hand over and give you a copy. I'm not on factual aspect. This is all about interpretation of what is acquiescence. Likewise, if a party having a right stands by, and that's the language Lordship would find in 39, quoted from this one only. Likewise, if a party having a right stands by and sees another acting in a manner inconsistent with right, and makes no objection, while the act is in progress, he cannot afterwards complain. That's my precise case. Absolute. And one judgment, Lordship can take note of it on this. I will give in the compilation. 1992. I haven't brought this on approbate and reprobate. 1992, 4 Supreme Court cases, page 683. On reprobate and approbate. In that judgment, it says, taking advantage of an order, if the party acts and proceeds, subsequently he cannot back out on turn around and say, it doesn't bind me. Accepting means you are stopped from taking a contrary stand.
Cannot go back.
Absolutely. 40 and 41, if Lordship sees, my lord.
Okay, I will say. Give the book.
And my lord, section 116, my lord, of the Transfer of Property Act on holding over. My lordship can take my book, my lord. Yes. Effect of holding over, my lord.
Yes.
If a lessee, effect of holding over, my lord. If a lessee or under lessee of property remains in possession thereof after the determination of the lease, I am still is, granted to the lessee, and the lessor or his relative accepts rent, he has accepted, maybe he will dispute on the face of it, accepts rent from the lessee or under lessee, or otherwise it doesn't come. First part, it covers my case, my lord. Yes. Or otherwise assents to his continuing in possession. Obviously, this part also helps me because by accepting rent, you have accepted my possession, though you have subsequently issued the notice. But first part certainly helps me accepting the rent. The lessee, in the absence of an agreement to the contrary, here this agreement only, renewed from year to year this agreement, and from month to month according to the purpose for which the property is leased as specified in section 106. So either of the two, my lord, I am fully covered and protected.
Yes.
But if you decide, no, at this stage it can't be done, dismissed or whatever, certainly, my lord, trial is must.
Okay.
And this occupational charges, these points, my lord, lordship can takes it from me. In their application, they haven't taken, my lord. Nothing of that sort. Differential adjustment only after that letter. That's very important, the conduct. I'm grateful, my lord. These are my suggestions.
Yes.
Any day, my lord. I will respond, my lord.
Yes, respond.
My lord, keep it tomorrow, my lord.
Any day, my lord, when it's convenient to the court, my lord, but I will prepare a short notes with the judgments, my lord, because I have referred to one, but I have to give it.
Suffering for the plaintiff, suffering for the defendant. Counsel for the defendant has concluded his argument in connection with GA 5 of 2022. So counsel for the plaintiff prays for time. Let the matter appear on. Today we are on 28/9. Let the matter appear on 11th September.
I'm grateful, my lord.
I'm really grateful.
Number 27 to 28.
May it please your lordship. That I am appearing on behalf of the plaintiff in this
appear for the
partition suit.
respondent.
And there is also a contempt proceeding, which has been initiated.
What proceeding?
Contempt.
Contempt proceeding.
And by your lordship's earlier order, there are two general applications of the suit and the contempt proceedings. They were, my lord, directed to be heard and taken up together.
So today what is fixed? All?
My lord, all these three applications are there. But my lord, before I ask your lordship to take up the matter, may I, my lord, file my affidavit in reply to GA1? This, my lord, has already been served to the defendant.
GA1?
Yes. GA1 is my injunction application in a suit for partition.
Where is
wherein
the affidavit in opposition?
No, it must have been.
I filed it.
Yes, we have. Must be with the record.
GA1 पे यो है ये तो CS है यो है GA2 ये contempt है check whether originally
Your Lordship, my advocate on record is not here. I'm not assisted with the brief.
My lord, today I would have, my lord, beseeched your lordship to kindly grant me the opportunity to file affidavits to GA2, which has not been taken up till now.
What is the GA2?
GA2 is an
Application for addition of the son of the defendant, who is
a
the
partition
actual owner of the. It's a partition suit. So son is the owner of the other property that has been brought into the suit. So it is
Son
our
of the defendant.
son of the defendant.
So why you wanted to be added?
plaintiff's cases, there are a set of parties to this partition suit. There was an order of status quo that has been violated, for which the contempt proceeding is pending. During pendency of our GA1, which is my injunction application, and contempt proceeding, GA2 has been filed by the son, saying that he wants to be added as a party. He has some interest with respect to the properties for which partition has been sought. This is the sum and substance of GA2. Lord, I beseech your lordship to grant me an opportunity to file affidavits in opposition to GA2, and after that, your lordship, my lord, can fix
And what
this
about the
matter
contempt?
My lord, I'm not beseeching your lordship to take it up in a hurried manner, because analogous hearing of all the three has already been directed.
So appearing for the plaintiff, so appearing for the defendant. Plaintiff has filed an application being GA1 of 2021, praying for GA1 of 2022. No, 21. Praying for entry mode 21 or 2A.
That is injunction. That is for
praying for interim order, full stop. Counsel for the plaintiff has filed affidavit in reply after serving the copy to the learned counsel for the defendant. Let the same be kept with the record. It is informed to this court that the defendant has also filed an application. Defendant has filed. Who has filed?
Yes, Your Lordship. The son of the defendant has filed.
He is the party, no.
The
Who is the
defendant has
applicant?
filed. Yeah, it is from the
Who has
defendant.
filed the application?
The defendant has filed the application
Defendant has filed
for
an
addition of his son.
application being GA2
as a party
of
to the
2022 for addition of party. Police counsel for the plaintiff press for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks.
2 weeks.
Reply, if any, there to be filed within a week thereafter. Let all the application be listed on 26th of September 2020.
26.
Number 29.
Not today. Next.
Number 30.
My lord, I'm appearing on behalf of the plaintiff. This is my application, my lord, for injunction and security, attachment before judgment.
Who is for the other side?
My lord, Mr. Bagh was appearing, and your lordship, my lord, was pleased to take up this matter, and I had concluded my arguments.
And Mr. Bagh was there.
Mr. Proneet Bagh,
Yes, he was there.
my lord, this matter has been, my lord, taken up on and off. May I beseech your lordship to, my lord, kindly fix the date and time, my lord, so that
It was heard on 6th of December,
lastly,
23.
heard to some extent, and even, my
Not
lord, it was not completed. Once before your lordship, my lord, I also got an opportunity to address your lordship regarding the matter, but I couldn't complete. Mr. Bagh couldn't complete.
What is the application? Interim order?
Injunction with attachment before judgment in a suit for recovery of money lent and advanced. My lord, any date and time commensurate to your lordship's list. My lord.
Affidavits completed?
Affidavits completed.
Since appearing for the plaintiff, none appears on behalf of the defendant. Plaintiff has filed an application being GA1 of 2022, praying for interim order. Praying for interim order? What is your prayer?
My lord, my prayer in GA1, your lordship will kindly see page 19. Security.
For furnishing security.
Security and attachment before judgment.
Attachment before judgment. Full stop. As none appears on behalf of the defendant, for the interest of justice, the case adjourned. Let the matter appear after vacation.
But as commensurate to your lordship, I only will not beseech a time to be given.
Time,
so that
that's why I'm telling.
I beseech. Yes.
Give the date and time. 7 November at 3 p.m.
Lord, I have been pointed out by the learned court officer that the back sheet of GA1, it has been written as 2021. Miller, it should be 2022. Oh, the earlier matter. It's 21 hi hobe. Oh, by sure. Miller, I'll ask this correction to be made.
Yes, next.
31.
May it please, my lord, I appear for the defendants in this matter, my lord. Before the matter is placed, your lordship may kindly seize the last order, my lord. The last order, my lord, has recorded that the counsel for the defendant prays for a day's accommodation.
Mr. Ali,
we did not
jump into all with all its guts. So
I'm not.
Millard, I am for the plaintiff in this matter.
Mr. Banerjee, just a minute.
And Millard, there are two applications.
I did
one
not. One
application prior in time. Millard, I am for the plaintiff. One application prior in time filed by the defendants. Millard, seeking that apart from defendant number 1, the rest of the defendants, Millard, their names should be expunged. This matter, Millard, was heard, affidavits were exchanged, and it's a change brief. Now, Millard, I think after going through the pleadings that there is no requirement for the plaintiff to object to this prayer. So that's the first thing. Their GA can be allowed.
What is the GA?
GA4 is my GA, my lord.
What is the prayer?
My lord, my prayer is, my lord, deletion of, my lord, defendant number 228. Mr. Ratan Tata and, my lord, big position or holders, my lord, of Tata Steel have been made a party, having no cause of action to the instant suit, my lord. That is why
I'm not objecting to this, my lord. I'm not objecting to this. Unnecessarily, it's my suit which is getting delayed. My lord, the other application which has been filed by the plaintiff is upon notice receiving from the defendant, saying that the name of the defendant number 1 has changed. Now, my lord, in this situation, both the applications can be disposed of because the second application is on their request.
GA4.
GA5. Second application is GA5 by them. Filed after, I think, 6 opportunities given.
GA5.
Yes.
So Tata Steel is not.
Tata Steel Long Products is not there, my lord, anymore. It's Tata Steel Limited.
If your lordship kindly takes, my lord, the communication which was given to us.
It has commenced Tata Steel Limited.
Yes.
Yes, my lord.
PSL.
Kindly, my lord, takes up page 8 of GA5 once. It's communicated.
5.
So sorry.
GA5 is appearing in the list today. GA5.
Yes.
Well, kindly comes to page 8. It's a letter given by Mr. Joydev Korai, the advocate for the defendant. And my lord, here they inform us that the name of defendant number 1 has now been changed to Tata Steel Limited. And they have, my lord, given us documents to show that is orders of the court. And
We have given
pursuant to
the
this, my lord,
NCLT order.
Address is same.
yes, address is same. And pursuant to this, my lord, we have, my lord, taken out this application where we have suggested, my lord.
So both the application can be disposed of.
Yes.
Can be disposed of together, my lord. Just one.
For your lordship's convenience, but I have just prepared one short note which can be necessary for your lordship in passing orders in both the matters.
Note.
Because, my lord, once deletion will have to take place, again, substitution, that is not necessary. So, my lord, I have taken this into, if your lordship kindly considers this, my lord. This is just for your lordship's convenience.
Yes.
My lord, just my lord, in addition, my lord,
What
two
addition?
things. Your lordship, just my lord, I'll be seeking a. Lord, I'm being led by Mr. Mitra.
Yes, Mr. Mitra. So you wanted to go out from this case. But
I wanted to
I'm
go
here.
out of it.
no,
I'm here. I'm here.
you do not want to go out of this case with the 2 to 8.
Okay. Those names. No. It is. Actually, I have seen the different number 7 and 8.
No, I've conceded
The
to
names
that.
of different number 7 and 8.
Yes.
One more signatory, my lord.
This is the personal appearance must be.
So it would be
Yes,
better
yes.
to remain in the
Yes,
cause
yes.
title.
Yes.
So you can also say, see, I am appearing for so and so.
Yes, I find my life. Different number 7 and 8.
My lord, just with leave of Mr. Mitra, my lord. In the
Yes,
last order,
what
it
is
has gone down, my lord, that we have prayed for an accommodation. We never prayed, my lord. It
Okay,
was,
what purpose?
my lord, this.
Bill.
Yes, my lord.
There is a presumption that judicial orders are always right.
No, Lord, just the fact should be correct.
So and so appearing for the plaintiff, so and so appearing for the defendants. Full stop. The defendant number who has filed an application for deletion.
Me, my lord, defendant number 1, my lord.
Defendant
One
number
has filed, yes.
1 has filed an application being GA4 of 2023, saying for deletion of the name of the defendant number 228 from the cause title of the instant suit. Full stop. Counsel for the defendant number 1 submit that though the plaintiff has made the defendant number 228 as party defendant as defendant in the suit, but after going through the pleadings, it is found that no relief has been sought for against the defendant number 228, and as such, the defendant number 228 are not the necessary party or the proper party for adjudication of the instant suit and prayed for deletion of the name of the defendant number 228 from the present suit. Full stop. Learned consent can be recorded.
Yes.
Consult the learned counsel for the plaintiff also has raised no objection for deletion of the name of the defendant number 228. Accordingly, the name of the defendant number 228 has been deleted from the instant suit. Full stop. The department is directed to take appropriate steps for deleting the name of the defendant number 228 from the cause title of the suit. Full stop. The plaintiff is directed to reaffirm and re-verify the plaint and to serve the amended copy of the plaint to the defendant number 1.
Lord, with respect to GF, my lord, when there is deletion, there is no necessity for reaffirmation or re-verification. But my lord, since my GA5 is there.
Okay,
yes, that will be together. That's why,
Yes,
my lord,
yes.
given this suggested note.
Now, okay, deletion हो गया तो full stop. The plaintiff has filed another application. Plaintiff has filed an application being GA5 of 2024, praying for correction of the name of the defendant number 1 by deleting the name of the defendant number 1 as Tata Steel Long Products Limited, and by incorporating the name as Tata Steel Limited. Counsel for the plaintiff submit that by way of communication dated 24th November 2023, it was informed to the learned advocate on record of the plaintiff that the name of the defendant number 1 has been changed, and on the basis of the said communication, the plaintiff has filed the present application for correction in the name of the defendant number 1. Consider the submission made by the counsel for the plaintiff, peruse the communication dated 24/11/2023. Accordingly, the plaintiff is granted liberty to delete the name of the defendant number 1 as Tata Steel Long Products Limited, and to add the name of the defendant number 1 as Tata Steel Limited. Address are same.
Yes,
Yes.
addresses.
Yes. But then when the copy is annexed at page 70
That will
of
kindly
the application, 6-7, the amended, the showing the amendments.
This is without my proposed amendment.
Yes.
70, yes.
And order 2 rule 2 Miller, there was
Consider the
typographical error was
submission made
there.
by the counsel for the plaintiff. You also wanted to add?
No, it is already there, but it was not added in the concise statement.
Okay. The plaintiff has also counsel for the plaintiff submit that though in the prayer portion there is a prayer for leave under order 2 rule 2. Where is the plaint?
It's 70. 69, 70.
Your Lordship sees page 83.
It's not there in the.
It's there also. It was also there, my lord, in the
There is a
original.
prayer under order.
Such leave was
Prayer
granted.
for leave under order 2 rule 2 being prayer P of the print, but the said prayer was not incorporated in the concise statement. According the plaintiff prays for leave to add the prayer in the concise statement with regard to the leave under order 2 rule 2 of the Code of Civil Procedure, 1908. Consider the submission.
Now, Miller, sorry to interject. Now, Miller, if your Lordship sees page 70.
Change of address.
Miller, in page 70, I have indicated the address.
That's why.
So, Miller, and one more important thing, Miller, 2 to 8, Miller, they get expunged. So, there is no requirement for me to incorporate the corrections in 2 to 8. The only other page which is required to be, Miller, given effect, 70, 69 is there, 70 is there, and page 73.
So that's why I will pass an order for only for correction of the name of the defendant number 1, deletion of the name of the defendant number 2 to 8, and for correction amending the by incorporating order 2 rule 2 in the concise statement.
Yes, my lord.
And in the and
back sheet will also change.
And back
No.
sheet and the prayer portion.
And the prayer
Now,
portion.
another thing, Malad, the address. The address of the defendant
That's
number
why
1.
you're telling in the amendment.
Yes, my lord. Address is something which has been communicated by them to us.
No, that has to be
is
done.
why we
It's
inserted
Bombay
them.
House.
So whether that is the address.
Yes, this is the address which has been given.
Address is to be total change.
No, not total
No,
change, Miller.
Not change,
The-
added.
Has
The
been
head office, the registered office address will come in. The Bombay House address.
Nice. Full stop. Good. Consider the submission made by the counsel for the respective parties. GF4 of 2023 is allowed by deleting the name of the defendant number 2 to 8. The department is directed to take appropriate steps by deleting the name of the defendant number 2 to 8 in the cost title of the plaint. Full stop. The department is also directed to make necessary amendment by correcting the name of the defendant number 1 as per the proposed amendment appearing in page number 70.
Plus 69. 69, Miller, is the concise statement.
Amendment in terms of page number 69.
I'm sorry, Miller. It should be, Miller, 68 because that is the first page of
Miller,
the
in terms of annexure B, Miller.
In terms of now, then again,
No,
it will
yes.
be
Look, I'll mention
page
the page.
68, 69, with regard to the page 70, only the amendment is to be carried out with regard to the defendant number 1.
Yes.
As the name of the defendant number 2 to 8 has already been deleted. Full stop. And where is the other?
The address of defendant number 1.
That is indicated.
That is
on page 75. 75, my lord.
Page 75. Page 75. No.
And my lord, page 91.
75. ঠিক আছে?
91 is the back sheet of the plane.
And 91 as appearing in the proposed amendment.
I'm deeply obliged.
As appearing in the proposed amendment. Full stop. Delete over. Full stop. The plaintiff is directed to re-verify and reaffirm the print within 2 weeks.
3 weeks, my lord.
Within 3 weeks after the amendment is carried out by the department. Full stop. After the reaffirmation and re-verification of the print, the plaintiff is directed to serve the amended copy of the print to the defendant within a week thereafter.
I'm deeply obliged.
GA number so and so. This one.
One small technical issue, my lord. The written statement has been filed on behalf of defendant number 1 to 4. Now, that written statement will remain. But if lordship is one line, that we will use that same written statement.
So no problem. At the time argument, you can say that it is because it is
subsequently deleted. Obliged.
You have not filed a separate written statement.
No.
One written statement.
One WS.
One written statement.
One WS, yes. Obliged.
Extremely grateful.
Deeply obliged.
Has priority. No, first that. This is come first. Then it will. First deletion, then it will. Correct. Next.
My lord, this is an application under Order 12, Rule 6, my lord, 32, my lord. My lord, pursuant to a lordship order dated August 1, 2024, the respondent has filed the opposition, my lord. My reply is ready. Today I have affirmed, my lord, that only, my lord, let the matter come on next week, my lord. I'll file the reply.
Have you served the copy?
No, my lord, I'll serve. Today I have affirmed due to this political agitation, I couldn't serve, my lord. Tomorrow I'll serve them.
Kindly will it fix a date for hearing of this?
Any day next week. Any day.
And after vacation, if you want date, I will give you after vacation.
No. I'm the petitioner, my lord.
No. My lord, then let it remain in the list next week.
What do you
have? By opposition, my lord, in both the applications.
So appearing for the plaintiff, so appearing for the. Only one GA. GA1.
GA1, my lord.
Yes, my lord.
But there are two matters. So
two matters. This and thereafter the 32 and 30.
Yes, my lord.
Judgment upon admission.
Yes, my lord.
Pledged admission.
Both cases.
Yes, my lord.
So suffering for the plaintiff, so suffering for the defendant. Plaintiff has filed an application being GA1 of 2023, praying for judgment upon admission. Defendant has filed affidavit in opposition. Let the same be kept with the record. Full stop. The plaintiff prays for a day's time to file affidavit in reply. Let affidavit in reply be filed within a week after serving the copy to the learned counsel for the defendant. Learned counsel for the defendant. List the matter on 19 September.
My lord, yes.
Olay.
Two matters, my lord.
Yes. Not today.
I'm for the plaintiff respondent is the defendant's application for rejection of plaint on the ground of non-lodgement of writ of summons.
Yes. But I have a leader, I have an advocate on record. They are in difficulties today. But I would beseech your lordship to take it up tomorrow or any day commensurate to your lordship.
Not today?
Affidavits have been filed, my lord. My lord,
Yes.
keeps it tomorrow, but keeps it on the next week, my lord. Tomorrow, Mr. Mitchell may have some difficulty, my lord. Keeps it next week.
So appearing for the plaintiff, so appearing for the defendant. Who has filed GA7?
GA7
Yes,
is
this is our application.
For?
But for dismissal, because the writ of summons has not been issued till now.
So appearing for the defendant. The defendant has filed an application being GA7 of 2023 for dismissal of the suit for dismissal of the suit. It is informed to this court that the pleadings have been completed and praised for fixing the matter. In view of the submission made by the counsel for the respective parties, let the matter appear on 25th September.
Grateful, my lord. Deeply appreciated.
Grateful.
Number 36.
My lord, 36, my lord, I do approve for the plaintiff, but the defendant's application is before my lord, my lord. They have filed an application for dismissal of the suit.
Who is for the defendant?
Mr. Dotto and Miss was appearing.
All the applications are appearing. The plaintiff's
Mr.
application
Gupta is also.
for judgment upon admission as well as the defendant's demurrer.
Yes.
Mr. Rajoshi Dotto is possibly appearing for the
plaintiff.
For the defendant. I appear for the plaintiff.
For the
Along with Mr. Meghna.
Mr. Gupta is leading me.
Yes.
Yes. So
kindly takes it up some other demurrer.
Mr.
Not today.
Dotto is there in the virtual mode. I can see him.
Oh, son.
My lord, I am there, my lord. But I had instructions, my lord. I don't know, my lord, whether we have instructions to appear. I was only praying, keeps it next week, my lord. Let me ascertain from my advocate and record. Otherwise, lordship can proceed.
So appearing for the plaintiff, so appearing for the defendant. As per the prayer made by the counsel for the defendant, the case adjourned. Let the matter appear on.
Well, next week, any day, lordship can keep it.
For what?
But for this application, my lord, because
For
my application for summary eviction is being stalled by taking out an application for demurrer.
On 5th of September. 5th September.
Great.
Yes.
Yes, any matter. Both parties are there and
the same orders may be passed in items 35 and 36 and 37.
35, 6, 37, 38, 39.
36, 37,
36 to 39. Yes.
36 to 39, same.
Yes. Grateful.
Grateful.
Yes.
Item 40, my lord, is perhaps my lord wrongly appearing. Because, my lord, this is, my lord, a matter where, my lord, the defendant had gone before, my lord, an application was filed under section 95 of the Insolvency and Bankruptcy Code. And hence, my lord, the interim moratorium is still in place. And that application is still continuing. So, my lord, on my lord, 20th of February 2024, an order was passed. If your lordship kindly looks at the order, it was, my lord, adjourned sine die with liberty to mention.
What had cancel liberty to mention. Why it has come? Mantush, let's go to out of the liberty. Yes.
Great.